Welcome to True Crime and Wine Time. I'm Terry.
And I'm Lana.
Tonight, we are uncorking the truth behind one of the darkest crimes and breaking it down together with you.
One case, one conversation, and one or maybe two glasses of wine to take the edge off. It's time to get comfortable and double check those locks before we get started.
So let's take a sip and dive in.
Hello, friends.
Hi.
Happy Friday, everybody.
Is this like trouble, more trouble, and extra trouble
Yes.
with the three of us?
It's
Oh,
triple
didn't-
trouble.
It's triple trouble. Triple T trouble is what we got for y'all today.
That's right.
That is
Right?
right.
Yeah. Triple T's over here. Anyway, happy Friday. We got Buffy on with us today, joining us over here on
I crashed the party.
You did. You did.
You did, and
but
we love it.
I know. I'm very excited about it. Now, today, in case you were busy this morning, there was a hearing for South Carolina versus Alex Murdaugh, and it was a long one, to quite frankly, none of our surprise. If you watch the first trial, you would understand these lawyers, who I love. I do love it, but I've heard it's a long one. Terry and I haven't watched it, but Buff, you did watch it today, right? This morning?
I
Mhm.
did.
You're like, yes, and that's why I'm here.
That's why
For your
she's
favorite.
here. She wants to be
So
here
you don't have
for
to type
us.
in chat.
I always say I was yelling at the. My husband's like, "What are you talking about?" I'm like, "I'm talking to the attorneys. I'm talking to the attorneys."
Jeez, Mr.
Why didn't-
Buffy,
Pick up the phone and call them.
right?
I should have.
You're arguably famous enough. You could have.
Excuse me. What is happening? What
Yes,
are we
we have-
doing?
This is Buffy from Couch Court with Llama on the phone here. What the fuck?
Now, please tell me the audio's better and they weren't walking around where we can't hear them. Because if so, we might need to start a GoFundMe, raise money for them to wear lapel mics.
I agree. I feel like
Because I've been going back and trying to watch the first one,
Mm.
and it's awful.
Oh, it's so bad. It's so
It's
bad.
awful.
The first part of the hearing, it was a little low, but I feel like they fixed it by the end.
That's good. I was going to say I can probably boost the audio for a little
You're probably
while.
still gonna need to boost it.
Probably.
Yeah.
If it's anything like the last hearing, though, that we watched last week or whatever, they weren't really allowed to walk all over the place like they were during the trial, where they were just walking. Just not. I wonder how many steps they got during the trial, just walking back and forth. They need triple T earbuds. Yes.
Oh, could you imagine if they would wear them and let us talk to them in their ears? Kind of like Secret Service agents. We could be like,
They would.
yeah, that didn't
definitely-
sound really good. Back up. Try it again.
Try it again,
That would
please.
be
And
a-
thank you.
They would probably be crying by the end of the trial. What are you doing? Objection.
Objection. Hi, Gally Peak. Happy memberversary to you. 17 months. That's amazing. And we appreciate that so much. And Jasper, the friendly goat, member for 9 months. That's like a whole baby worth of time. So I love that.
She's supposed to be in class.
Oh, well, it's lunchtime, maybe. Terry telling Poot to straighten his tie and sit down. Sit down.
Yes. Sit down.
Amos flaunting her membership level for 24 months.
Man,
That's
look at all
amazing.
And then we got Pam.
11 months?
It's like we have our own little cult. TCWT
Perhaps.
cult.
It's an intentional community, Terry.
Can we just be a
Not a cult.
sorority instead of a cult?
I guess I never thought I would ever be in one, so it's probably the
You're the
closest
leader.
I get. Oh, okay. Well, I don't know how any of that works, but okay. I guess we could do that. Oh, well, thank you all for your member anniversaries and sharing those with us.
Yes.
We are so thankful for all of our members who help support the channel, to keep the wine flowing or the booze, which I did bring a glass of booze because it's Fukong Friday and it wouldn't be
I
a
did
Friday if
not
Lama wasn't day drinking a little bit.
because the one glass last night on the
Mm,
podcast did not do well. I
did
am
not do well.
actually going to see the doctor to see, do I have an ulcer or something? Because how can wine bother me? It's
Yeah,
a problem.
I don't love that for you at
Oh,
I
all.
don't. That's a problem.
Kind of is like the whole name of our show. So that's
I know.
change that.
I have to rebrand just to true crime
No,
and time, I
we're
guess.
just going to have to learn to deal with it.
Kelly says I have to say I love this judge. Well, I very much enjoyed her in the last hearing we watched. I can't wait to see
Yeah,
her again.
I
Um,
did too.
I
I'm
really
excited.
think she is going to be a very interesting judge to deal with both Creighton and well, both sides, because both sides are very theatrical and
They are.
long-winded, which I personally love, but there is a time and a place. And based on the last hearing that we watched her in, I felt like she was very like, let's go. All right. I don't know what you're doing here, what you're all talking about, but like no games,
Yeah.
though in a very good way, right? Not like in a Judge Bev way, where it's just like, ooh, yikes.
I'm not trying to give any spoilers. I'm trying to be very, very good. And if you only knew how hard that was for me, you'd really
I was
appreciate
fixed.
the restraint.
I am. I am. Now we'll see how she
Yeah,
does this hearing. I don't know.
I'm
So
taking notes.
you're taking notes. Okay. She's got out her notepad. All right. Well, let's go ahead and get into it if you ladies are ready, because it's a long one
Yes.
today.
Mm.
So, which is again no surprise. I expect every hearing from now to this trial to be multiple hours. Not just because of the lawyering, but the judge has set a very firm trial date of April 5th,
Mhm.
which means there has to be lots of discussions about numerous things. And they're going to try to cram as much into every single hearing they can possibly have between now and then. So, unlike some other trials and stuff where it's like, oh, the hearing is 5 minutes, I do not expect
Right.
that at all for every single
No.
hearing at like at all. So, hello, AZ. Long time no see. Hope you're doing well. Thanks
Hello.
for being here. So, all right, let's get into it. Nope, not that one. Not that one either. There we go. That's the right one for
It's
us.
such a pretty courtroom.
I even took a
I was gonna
screenshot
say,
of it while it was empty just because it was so pretty.
It is
it
pretty. It
is.
is a pretty courtroom.
And
The
I think we're
ceilings
gonna
are
need to
very
go
low.
there next year for the
Oh
trial.
yeah? Are we going to South Carolina in April?
I think we should.
I think we should too.
I have a
So,
friend that lives not far away,
Oh,
like
yes,
25
please.
minutes. So we could maybe ask if we could stay in his guest rooms because I think he has 2.
oh, look at that.
Matt, call me. Let me know if we can stay with you.
We have a good time when we're together. Call me,
We
maybe,
do.
please. All right. Well, let's go
He's
ahead
one of my
and get
gays.
to it. Oh,
He's one of my
okay.
gays. So
Oh,
he would be a blast. And he's a baker,
love
a
it.
professional
Oh, and a
cake maker.
baker. Ooh, all right. I'm already sold. I can do
I know,
that.
me too.
Now there is no closed caption available for this, you guys. So I'm sorry. I know a lot of us like closed caption, but it is not an option. 2, we are going to be pausing and doing commentary along the way. If you don't like it,
Yes.
that's fine. I don't want to hear about it. You can go watch this with no commentary over on Court TV, Law and Crime, or numerous other places that stream the trial with no comment or the hearing with no commentary. Okay. You don't need to leave a comment about it. It's fine. We'll all be fine. Okay. So that's what we're going to do here today. We will pause, takes breaks when we have things to go. Other than that, let's go ahead and get right
Only
in.
thing I'm going to say is if somebody wants to go over to Discord and tell everyone we're live, I just noticed I did not get notifications on
Mm.
my YouTube account that we went live.
Oh, interesting.
And I know we've been
Ugh,
having problems.
we thought that
I
we
I
heard
fixed.
that
can't
on
do it.
another channel this morning as well, that
Let me find
notifications
my
were
Discord.
not going out.
I thought they fixed
I
it. Damn it.
pulled
yes,
it
ma'am.
up, so I'll go over there and do one real quick,
Okay, there
just
you
so
go.
everybody knows.
Well, we'll go ahead and get started because I think it's just some hi, how's it going at first? So they won't miss very much. All right, let's go. I'm going to boost the sound too, which means we're going to be very muffled. And
Absolutely.
okay.
Okay, good. Let me tell everybody else, good morning. Welcome to
Good morning.
Lexington County and to the Lexington County Courthouse.
Okay.
As soon as we get
Was she like expecting like, yeah, Judge, love to be here.
Yeah.
Thank you. This is so
I know
awesome.
she was like,
She
response,
was like,
please.
all right.
Right.
Somebody needs to stand behind her with the applause poster board so that the entire courtroom goes, yeah, yeah.
Oh, I already love it. I miss court. We haven't been able to really be in court lately. I do not miss the waiting around. I'll tell you that much. Do not miss that. But you never know what's going to happen in a hearing or a trial ever. You never know, and I love that. Anyway, sorry. I just had to be like, Your Honor, we are happy to be here. Thank you for having us, since nobody else bothered.
brought out, we'll get started. Mr. Waters, how are you?
Judge, how are you today?
I'm good.
Okay.
Turn it up.
While we're waiting, let me introduce y'all to my new law clerk. This is my old law clerk. This is his last day. So you will not be emailing him anymore. This is Mary L. McKissick, and she will be the new law clerk that y'all will be getting emails from. So
Hi, Mary.
just wanted to introduce her so y'all would know when you did get them.
Okay. Tough,
While we're waiting.
tough crowd, man. She's just like tough crowd.
Right?
Yeah.
Like,
Anybody?
I thought it was
wanna
maybe just
say
because
anything?
the audio's low. Because I'm like, nothing, no
No.
response.
No responses.
no.
Well, hello, Mary. Welcome to the trial. Can't wait to hear more from you. It's just so funny.
She's the new
Anyway,
Becky.
right. Ooh, yikes. Hopefully not. No more
Hopefully
Becky's.
she's nothing like Becky.
They're having a cake and farewell party for him after session, right? Maybe. I don't, probably. They're very nice. So
I want
I think that's the Southern hospitality going on that I hear so much about from you Southerners. So, okay, back to this. Sorry.
Mr. Murdaugh, could I address one administrative thing? I've already talked to the clerk from Carlton County. When you file an order, on some occasions, you copy us when you file it. On some occasions, if we don't get it, the order allowing him to be dressed without shackles. We read about it in Fitz News before we were aware there was an order.
Oh,
You could, I don't know whether you over, but when you send an order to Carlton County, if you copy the lawyers, I think you've done that on
it's
this
very
order.
low.
Let me
Yeah,
tell you,
I'm having trouble
my
hearing.
office usually sends an order.
You see that microphone? That's like right there by that white arm. Poot's not standing
Yeah.
by it.
I do have it boosted, but Buff said it gets better.
Low at the
So
beginning.
yeah,
Okay.
I can't do much more than what I'm already doing without it sounding like garbage. So okay. Oh, he is all dressed up. I forgot. Yeah, she did approve that order for him to wear street clothes and be unshackled, which I was not surprised. They usually always do.
And you know, for somebody like him, that is probably a little bit of pleasure for him to be able to put on regular clothes and feel like his old self
And a suit nonetheless in court.
and a suit,
So,
reminding him of his better days.
oh, also, are we going to take guesses like how many times Creighton is going to say more than happy or just happy in general? Are we going to take a
Yes.
anybody want to put any
I'm gonna keep
guesses in
track.
chat how many time we're going to hear that he's happy to do whatever? I feel like it's going to be a lot.
It was surprisingly less than I expected,
Oh,
but
okay.
I was like, oh my, I mean, he does say it, but it's
I'm gonna
surprisingly less
guess
than I
10.
expected. And I expected, well, at first I was like, is he watching us? Because we do make a lot of fun of him. So I'm wondering if like he was like, okay, I'm gonna have to pull back on that.
I'm a little too happy, apparently.
Right?
And then what I
Mr.
know,
Happy.
we don't
Women on the
know what
internet.
we don't know.
Yeah. Oh, yeah, that's true. I forgot about Poots. We don't know what we don't know, Your Honor.
I will do a
Um,
ticker on my notepad.
Excellent. Excellent. I love that. Also, this wire there in the middle, I know it's for a microphone, but it looks
It's
weird. I don't like it. Also, why are your microphones hanging from the ceiling? This looks like a pretty modernized courtroom going on here. What are they doing? But
yeah,
okay.
why they don't have a wireless mic in today's time?
But
That's
what can you
interesting.
do? What can you do? All
Hello,
right.
JT.
Oh, hi.
3
well-
times in 1 week.
Oh, my goodness. It's like a party over here.
I know.
Just a party. All right. Well, let's see what they have to say here about Alex being brought in.
I do that not only in this case, but any lawyer who appears in front of me. I send a copy of my own order. I apologize for that.
To apologize for, but once things crank up, you know, getting it quick, getting it next day didn't bother us in this, but it may be that as you make evidence rule, whatever, it just, if you.
Absolutely. Well, I'll make sure that.
So he just said, we got into like 2 minutes of this, and we're already like, what? So he complains to the judge about how she didn't like forward regarding the order for Alec to dress in normal clothes, right? He heard it from Fitz News. And she says, oh my gosh, I'm so sorry. Like, I will do that. And he's like, no big deal. It's fine. Even if it's not until the next day. Like, then why did you even bring it up? I don't, because it sounds like you did have a problem with not knowing first, which is a fair argument.
Yeah.
I do believe the lawyer should know things before it comes out in the news, but so, okay, we're all fine then.
Agreed.
Hey, Poot. Oh, y'all, I miss them so much. Both Poot and Waters and all of them. It's fascinating lawyering, I think, that happens
Mhm.
between them. And not something that I've seen a lot in other trials. I don't know if it's just like a Southern thing or what, but I love it. And I love both sides. And
You enjoy the passive aggressiveness?
I do. Yes.
She does.
Yes, I do.
It's so Southern. It's like,
I
you
love
know,
it.
when they're saying certain things that you know.
And you
Oh,
all taught me that.
I hearing some things, and I'm like, oh, my
Oh.
uncle used to say that all the time.
Oh my. I don't know. Their whole Southern vibe, I just love it all. I really do. I can't get enough of it. In the best ways. And like I've said before, like when we watch like the appeals and stuff, I think both sides do a very good job of lawyering in this case. Like I really, really do. I have respect for the state and for the defense's team on both, even in the first trial. Even though I have unpopular opinions about the state's case, I do feel, and both sides get up to shenanigans all the time. All right,
Mhm.
they both do it. Both sides do, but I do appreciate and respect that they are good lawyers. So I do love that. Matt, that's right. We all did meet through Murdaugh. Most of us did anyway, the first trial. So here we are. 3 years later, some of us on the screen. together covering this. So you watched already and it's spicy. Oh, I love that. I love
I
that.
love that for a Friday.
They should adorn the wire with some streamers and balloons to honor the law clerk's departure. I
Then we wouldn't be able
agree,
to see. No
Oh,
balloons, just streamers.
Poot is still Poot, JT. That none of them have
Still
changed, and
not.
I am here for it. I love it. All right. Anyway, back to things. So he's just as like, Your Honor, can you please send us the emails when you can? Don't mean to be a bother. Adorable. Okay.
Everybody gets a copy. Again, I apologize for that.
Nothing to apologize.
I usually do send it myself.
Thank you, Your Honor.
Mhm.
Mr. Murdaugh.
Okay, you ready to get started then?
Place ready, Your Honor.
All right, well, let me just kind of do a little housekeeping here. Mr. Harpootlian, let me just address kind of what we did last time as far as making arrangements out at the Bureau of Prisons for a conference room where
Mm-hmm.
you could take discovery to your client. Have you had any issues with that?
Let me just confirm.
None at all.
I have no issues whatsoever. Everyone's been wonderful.
Okay, good. And then I told you that I would check on if there's any kind of download that you could do to the tablet that he has, and there's not. So we're gonna have to stick with the computer from either the law clerk or one of your staff members going out to the BOP.
We are, at this juncture, we have a law clerk, this young man back here,
Oh, no.
who's going down there, and of course, 2.5 hour drive. Typically, it's 2.5, 3 hours with him, and then 2.5 hour drive back. We understand. We want to put up with that.
Okay,
That's not a problem. However, we have retained some experts, and at some point, we're going to need to, and they've done this in the past for us, but we've done some FaceTime meetings with them so they can show Mr. Murdaugh
I'm with you.
drawings and all those sorts of things. So we're going to try to, and I don't think they're going to have a problem with that, but if we arrange for an expert to be available and we're paying them hundreds of dollars an hour, we like it to work seamlessly. If we can.
Okay.
Well, if you have any problem, all you have to do is just let me know,
Yes, ma'am.
and we'll try to work around that.
Thank you, Your Honor.
So the last hearing that we watched last week, well, it was from the end of June, but they were trying to get Alec to have a tablet in jail or prison, I'm sorry. So that way he could like review documents and all of that. It was freaking 30 minutes of arguing about this. And it looks like none of that can really be done. Instead, they have to send some intern who probably is either still in or fresh out of law school to drive 2.5 hours so he can sit there next to a computer with Alec for the whole day and then drive back. Oh gosh, that poor kid. But
No,
that's how they've settled that.
they need to get them an Airbnb or a hotel Monday through Friday and not make them drive so much.
Yeah. Oh gosh. That's the part about being an intern or something. You get stuck with the
guess.
really crappy jobs. And like they have to go through like security at the prison is a whole process
Mhm.
that can take a long time for you to get in. Though I think that if you are like legal or something like that, right? You don't have to, you have to go through the same thing, but it's not like the same line as like if it's just like civilians
Right.
and stuff, right? It's a different, but still egregious.
Still a
And
lot.
a lot. AZ's not very familiar with this case. Well, you are in for an interesting trial. I promise you, AZ, even as a retrial. It was fascinating the first time. Is going to be equally as fascinating the second time. So
Yeah, these
Izzy says they've
lawyers
got to
do
get back to
not
work.
disappoint.
Replay. Crew.
yes. Oh, yeah. Well, that's fine. He'll hear us later. What were you going to say, Buff?
Oh no, I said these lawyers don't disappoint either.
No, not at all. Not at all. I would say that the Murdaugh trial is right up there with the Karen Reed trial in like every day was a very interesting day, except for the 2
Mhm.
weeks of financials. That was the worst and longest 2 weeks. But they really both sides really bring it to
They
the
do.
table. And you kind of need that. If you have one side, like the defense being very theatrical and dramatic, then the state needs to do that too. And I do think Creighton does a very good job with that. But I said similar things as we're covering like the O'Keefe v. Reed civil trial. The plaintiff's attorney, I'm like, he needs to step it up if this goes in front of the jury because her team is going to wipe the floor with him in like charisma, relatability, energy. And that really, I think, is important in a trial like this, let alone a murder trial. But while, yes, you want to stick to all the facts, it is human nature um, to be more attracted or listening more to a side that feels more relatable and less stuffy. We've seen that numerous times in trials. So you'll be listening. Nice.
We're
Nice.
attracted to people that we feel a connection to.
Yeah. Yeah. If that lawyer feels like, you know what, I could go get a beer with that lawyer. And if they're not seeming like superior in some way or super dull that you're just like, I stopped listening to you like 5 minutes ago. It's
I'm
usually
gonna
not good.
I'm gonna be honest. I really just feel like people love reality TV and we're bored with stuffiness. We just need people to bring it and keep me interested. And if I lose, like if you can do that, then you probably have me.
That's true. Fair point. Fair point. Okay. All right. So they've settled that Alex does not get a tablet in jail. Intern guy has to drive and sit with him every day for the next 7, 8 months or however long it is till April. I don't know. So poor guy. All right, back to it.
We'll make sure it gets done. All right, if y'all don't mind, I've got how I want to do this hearing today. Because I plan to hear all of your motions except for 3.
Okay.
And I've kind of picked out the ones that I thought we could kind of go through right easily this morning. I know that both of you renewed your discovery motions and your reciprocal discovery motions. Let me ask the state, right now, do we have any problems with discovery?
Not that I'm aware of, Your Honor. Obviously, we have filed a motion as it relates to that defense phone extraction. That's obviously one of the things on the table today.
And I'm going to rule on that today.
We are obviously always auditing discovery, and of course, it has been a few years since the trial, so there may have been things that we would turn over that have developed.
Look how big that courtroom is. That is a massive courtroom, by the way.
And there's empty spaces.
Yeah, that is a huge court. I didn't realize they went like that far back. That is massive. I don't even know if we have a courtroom that big here. Maybe, but I don't know. Wow. That's impressive. And look at how big that clock is. I know it's weird. But it's a very large, I guess enough for the judge to like see the time all the way across the
I was about to say it's so large. You got to be able to see the numbers from how far back she is.
Right. Also, I feel like South Carolina courts all have these oil paintings. Is this a common thing elsewhere? Because I've never quite seen them, where it's just like oil paintings of all of the people. Because they were up in his first trial, which is not the same location. Here we are in
I know
another
they're up
one,
in
and it's just like,
Texas.
are they? Is that a
They're in the
thing?
courtrooms. I've been in Dallas, Houston, Austin, Bastrop, and they all had. So I just thought it was a legal thing, a court thing.
Oh, I don't think I've necessarily noticed them in other trials, and I haven't been to ours to like actually know, but I don't see them all the time. And oh, it's a southern. Probably says it's a southern thing. Okay, well that makes sense. That makes sense to me because
If I'm in a courthouse, I'm too terrified to notice. I'm just
sitting there.
Sitting there.
All right, let's get back to it here.
Since that time, and we're in the process of doing that, but we are not aware of any discovery issues at this time. Indeed, not too long ago, the defense realized that one of the original big murder downloads that we gave them back in August of 2022 had been corrupted on their end, and our staff worked and did hours and hours of work to put all of that, to provide that to them. So my understanding is that they have all that, which they had then at the time. But they
Yeah, certainly not anything new,
Not
just
anything new.
something you had to recopy
That's
to
fair.
give to them. Okay. How about you, Mr. Harpootlian? Do you have any discovery issues right now?
Mr. Griffin would like to address that, Your Honor.
Mr. Griffin, be happy to hear from you.
Yeah, I'll come up here, Your Honor, since I'm on the
Yeah.
microphone. Good morning.
Good morning.
Thank you, Jim. We appreciate it.
I want to make a record. I mean, there's
Jim is my
ongoing
favorite.
obligation by the state. They say that
There's an ongoing
They
obligation by both of y'all.
and so there's some items that we would have expected to receive by now, and we have not.
Let me know what those are. What are they?
So as Your Honor well knows, the state has to produce evidence, information pertaining to, that the defense could use to challenge the credibility or truthfulness of a witness. It's called Giglio material, and it's in United States Supreme Court, Giglio v. United States. And these include plea deals and promises, secret agreements, evidence of witness bias, and credibility issues of police where the evidence of past misconduct. And in that category, I have a few items as to secret agreements. There's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have
Wait, are they saying that he hasn't been like sentenced or pled or anything? Is that what he's saying?
That's what I was
Yeah.
wondering.
I think what he's saying is that it hasn't been like they haven't done anything with it yet. And
Yeah.
Creighton does respond
Just
to
kidding.
it, saying like that's still part of.
For 4 years?
It's everything is slower in Colleton County.
Suspicious to me. I've been suspicious
That's
about this whole cousin
suspicious.
Eddie thing for a very long time. Interesting though that it's, I mean, especially with those charges, 4 years for any sort of resolution. That's crazy to me.
Doesn't
Okay.
he have a right to a speedy trial?
Well, yeah, but if you waive it, then it can take
That's what they
however
say.
long the state wants to make it take. That's why you don't waive your right to speedy
Don't waive.
trial for a while. Okay? Don't do it. Don't do it.
We have a
Otherwise, you
list
will
of things
be.
you shouldn't do.
Yeah, yeah. Because you can sign it away at any point in time. It doesn't have to be right at the beginning. And sometimes it is in your best interest to press the state hard because they only have a short window to gather evidence and all of that, that it can be actually more in your favor the less time they have to get things together, including witnesses, experts, all of that. So, not a lawyer, but you shouldn't waive your speedy trial rights away.
But if
very
you
quickly.
waive your rights, does that just give them open-ended delay?
Yes
Because
and
I didn't think
no.
it did.
Well, here's the thing, right? Is like, so some states, right, you have to have whether you sign them away or not. There's different like time frames, right?
Mhm.
Like you have to have this done by this time and whatever. But if both sides are continuing constantly, the judge is fine with the continuing. It can go on for so long. I mean, Paul Canero, his trial wasn't for like 8 years,
Essex say, yeah.
and he was in custody a long time. So,
Courtney Clinty, who just got sentenced, she was there for a while too. That was
exactly.
Kingdom.
So, yes, while some states impose like, time limits, like a person has to be tried by 280 something days or whatever.
hmm
If all parties agree, then they can move on, right? But it's like the defendant's rights. So, but if the defendant is like willing to be like, okay, yeah, we'll continue or whatever, then it just does. So, that's why. Now they did not, Alec did not, I believe, waive his speedy trial the first time, and I don't think he's waived it this time either. So it did take longer for his first trial to happen, but it was also very quick. He wasn't actually indicted until 2022, July, I think, of 2022, even though he was arrested in 2021. The murder indictment, I believe, based on the timeline I'm putting together, was like 2022, and he went to trial January 2023. So I don't think he waived his speedy trial rights at all, even though he was in custody for like almost a year before the indictments came in. But he was in there for a bunch of different reasons. He wasn't going anywhere, but the murder ones. So anyway, I digress. So, but what about this cousin Eddie thing? I need to know more because he is somebody that I have been wondering about for years, and was also somebody I was very surprised was not called as to the stand, even though he was on the witness list by the state. I've always had a lot of questions about cousin Eddie, and now I have even more. So, guess what rabbit hole I'll be going down later this weekend. So, trying to find all of his court documents is what I'm going to be doing. All right, carry on.
A deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it. With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case. And the name of that case is State v. Michael Colucci. And he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motion
10-year trial right
identify
there.
David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award. Judge Young dismissed.
Isn't the lead investigator from this the one that also lied to the grand jury? I'm trying to remember from the first trial. I think it was the same guy who on the stand admitted to lying to the grand jury about things.
I don't
I don't remember
That
who it
such a long
was.
time ago.
I'm pretty sure it was the lead guy. I don't remember his name's Owens. I'm working on putting it all together for us. By the
I'm
way,
writing it
'cause
down
there's
a lot.
there's a lot. But
We're gonna need a chart.
we're going to need charts. We're going to need some comparisons. I have made several spreadsheets and folders for all of the different cases, but there is one thing that, quite frankly, is undisputable about this case, and that's that SLED fucking sucks. They just do. And are they at Massachusetts State Police level? Oh, they're close. They're close. Okay. There was a lot of problem. There is a lot of very big problems with SLED, a lot of very big problems with SLED in this case, particularly with evidence and things like that, mishandling, misconstruing. I do not trust shit SLED says. Sorry, not sorry. It's like listening to MSP at this point, right? You're just like, I don't trust you. Sorry. That's what happens when you have a few bad apples, right? They can spoil and taint it all. Because I don't think all of SLED is corrupt, but there was definitely some issues with this case specifically that I do not hold them in high esteem, if you will. So anyway, look at Jim there. Jim is my favorite of the three of them. I don't know why, but I just appreciate Jim.
He reminds
The
me
Colucci
of Terry Bradshaw.
because of withholding.
Oh my God, he does kind of look like Terry Bradshaw, doesn't he?
That's all he looks like. I'm looking at him. I'm like, you're supposed to be on the football field, not the courtroom.
I am, lady. I am. I got power back yesterday morning. And so that was really nice. Hi, Mama Llama. Hello. All right.
Of exculpatory evidence. We want to know what's in Mr. Owen's SLED agent, I think he's retired now, in his HR file. Was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter? There's another SLED agent who was the lead SLED agent in the financial crimes case. Well, right now, we assume he's going to be a witness. He retired from or resigned from SLED. We don't know exactly under what circumstances, but then he went to work for the Charleston County Sheriff's Department. On June 8th, 2026, Captain Ryan Kelly was terminated from his position, according to the Sheriff's Department, for conduct unbecoming, harassment, improper procedures.
Uh-oh.
And so that would be information. We don't have subpoena power.
Those are all very problematic issues
Those
for
are.
their lead investigators on this case. That is not good. Do you know how hard it is to get an officer of any kind terminated over something? That means it has to be wildly egregious and very, very bad.
All of this happened after the last trial?
Yes.
Yes.
Oh,
Yeah, they're
okay.
saying within like the last year and a half, which does, and we were talking a lot about this in our coverage of the O'Keefe v. Karen Reed,
Yeah.
because she is wanting a lot of documents from MSP and the district attorney's office because, corruption, things like that, targeted. And this is basically kind of like the same thing that Jim is asking for here is like, okay, so two of the main people that were a very big deal to this case, one for the murders, one for criminal, have now faced some very unbecoming accusations and job problems. And yes, I do think that when you see that, that's why bad cops are a problem, because then every single other case they've worked on now needs to have a new level of scrutiny to how they performed in it. Massachusetts is going to be dealing with that shit for years because of MSP and Canton's behavior. And we're kind of seeing that here in what he's asking for is like, we want to see why he lost his job. We want to see those disciplinary records, if any, because they will try to impeach them on the stand. And like I previously just said, in the first trial, they got one to admit under oath that they lied to the grand jury, which is a very big deal. So, oh boy, if so, this is going to be a very spicy retrial when it comes to law enforcement. I wouldn't be surprised if the defense has watched a lot of the Karen Reed trials as like some inspiration, if you will, of like how to navigate. I'm not saying that there's all this corruption everywhere in this state. That's we don't need to argue about that.
David
But
Owens is the one who lied to the grand jury.
So now he's been
just gave it a quick
disciplined since
Google.
then.
Yes.
Like I said, I wouldn't be surprised if they have sat and watched some of Karen Reed's retrial, in how to proceed further with this with SLED. So it's going to be interesting for sure. I'll tell you that. Bad, bad, bad cops. Bad, bad, bad. Tisk, tisk. Lainey. That's right. Tisk, tisk, tisk. Anyway, and again, if they botch this investigation so bad, and despite whether or not you believe he did it or not, does not matter.
That's
Okay.
right.
If they botched this so bad and showed bias in any way, you should have the same vibe that anything that comes out now from them, it cannot be trusted or verified because of who that would be coming through and what are their motives, right? Because as we're doing this Karen Reed civil suit, the MSP doesn't want to turn over anything at all. The town of Canton doesn't want to, and we all know why that is.
Why?
We all know why. So I am very interested to see how these avenues play out regarding the investigators in the last few years. So anyway, I love it.
Unless we subpoena them to a hearing. They have control and can request this. We don't have it, and we would like it. And so, Your Honor, that's some Giglio material, some Brady material that we have, think we're entitled to. And as you know, Your Honor, Brady is evidence that is, could be exculpatory. We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that Murdaugh murder weapons were connected to the Allendale County murder. Now, how could that be? And so we would like to know, were Murdaugh murder weapons connected to this Allendale murder? Now,
before he goes further here, the murder weapons from the Murdaugh murders have never been found.
That's what I'm saying. So then, but they're connected to this other murder?
Allegedly. But because I did hear about this part here. But Buff, you said you tried to find the article, but you couldn't find it.
I couldn't find it. So
Not
if
that
anybody in the chat finds it, send it to me.
Please do. Please do.
Because I want to read it.
Yeah, same. Because if so, this is a very big fucking deal. I don't know. I haven't looked into it. Fitz News has done a fuck ton of reporting on this. They're local news of South Carolina. They're pretty well known. And they've done reporting since this all happened. So I do feel like they're a fairly trusted source. But if you guys find that or hear about it over the weekend, please send it to us because I certainly want to read it, because this is if true, a huge deal, a very huge deal. So if you find it, send it to us on Discord, or you can email it to me or Terry. It'll all go to the same place anyway. So please and thank you, because holy fucking shit balls if this is in any way true.
if Your Honor, we'll get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdaugh. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 blackout at the house, at the driving range, and at the murder scene. Which leads us to, I mean, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdaugh murders, either their test is bad or someone's out there using a gun to murder other people. And so we would like that information.
Yeah, me too.
There's generally, we are aware that SLED has received tips, because we've received tips We've not been provided any information about tips of, you know, whether it's reliable or not, identifying anyone else other than Alex Murdaugh participating in the murders. We've not received any information, you know, have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligation seriously enough to find out what Brady materials out there has been developed and what Giglio material out there has been developed. And this is what we are aware of today, but you know, we don't have the benefit, we don't have the ability to contact law enforcement and get this information. So those are our concerns.
Okay.
Creighton is not going to like what he just that he's not being cooperative or anything. He's probably not going to like that one bit.
He's happy to give them any information.
He's
they need.
happy. Yes.
Happy to do it. I don't know, for those that ever used to be a server, like for the restaurant I worked at for many years, like that was our slogan. Happy to do it. I am never happy to do it, ever. Ever. Wow, that would be that is very, very problematic if true.
Yeah.
Oh boy. Okay. That's a pretty big deal. That's a pretty big, that had to have been like recent news, I would think. But otherwise, why wouldn't they have brought up this gun thing, you know, before, if that was the case? I don't know.
I looked for it. I could not find what he was talking about. I really, really did try, but
Interesting.
Yeah, I'm
because I wanted to
and
read
so
it.
far nothing.
Yeah.
I know, right?
Maybe it'll
Where is
make
this
its way to
article?
Reddit or something later. I'll keep an eye out on the Murdaugh ones, or maybe Fitz News will say something. Because if it's not true at all, I imagine Fitz News would put out a statement being like,
I went to their Twitter as well.
Oh,
And
interesting.
there was nothing there. The posting that I saw when I was watching it was from 2 hours before this was ever said. So
Ooh.
I just went to Twitter too. So Buffy, we think alike.
So they haven't come out and said otherwise. Well, that is interesting. I would also think that they would then tweet out that article to have more people read it.
well, see, and that's what I thought.
But and Miss said they may have taken it down. Maybe they got the information from a informant and they don't want to have to share that.
Well, they put it out on an article, so they intended for it to be read.
That means most likely, if this is true, it came from a court document of some sort. More than likely, but I don't know. We'll see. Again, anybody this weekend you come across any of this information, please send it to us and we can talk about it on Monday for sure. When we come back with Murdaugh stuff on Monday. Oh my goodness. Oh, okay. All right. This is a spicy trial already. See, that's why court is fun. I know so many people think it's boring, and maybe it is, but like once you kind of like speak the language of things and know who the players are, it's like way more interesting to me. So they could have been like, let's remove that. I don't know. That would compromise journalistic integrity, I think, to do that. But I don't know. We'll see. We'll see.
Mr. Waters, let me hear from you on the Giglio.
Yes, ma'am. First of all, I want to say we take our obligations very seriously.
I know you do.
And have never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, they, of course, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that obligation very well.
Are you happy to
As
do it?
to
And those
the-
cases are still pending.
That's correct. Yes, sir. Yes,
Okay.
Your Honor. As to Colucci and Kelly, we are all aware of our Giglio obligations. And as far as the Colucci matter, the judge, as I understand, I wasn't involved in that matter, but ultimately dismissed that indictment just without prejudice, just to allow some additional information to be presented back to the grand jury that the individual said that he forgot. But there was no finding that he misrepresented anything. I have made inquiry, and I am not aware in any HR file of a finding of dishonesty or anything like that that would ultimately trigger Giglio. I have made those inquiries and will renew those inquiries. And if anything is applicable there, I will immediately provide that to the defense, as we do every law enforcement witness in the case. The same thing with the termination of Ryan Kelly from Charleston. My understanding is
SLED agent.
he was a SLED agent. He went to Charleston County Sheriff's Office. And, you know, deputies served at will, and he was terminated. But the inquiries I've made, and my understanding is that none of that had anything to do with dishonesty or falsification of reports or anything that would go to Giglio, that they were personnel matters. I will, of course, re-verify that. And if there's anything that needs to be provided in that regard, I will, of course, provide that to the defense. But that is my understanding at this time. And again, we always renew our Giglio inquiries for any law enforcement witness that testifies as we move to trial. And obviously, if anything's forthcoming, we'll provide that. But those issues are not there. As to tips, we provided a lot of that information before. But as I said, this case was tried, over 3.5 years ago. And so we are in the process of, correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense.
Thank you, Polly, for that
we
info.
are constantly always doing discovery audits and discovery checks.
All right, well, tell me about the Allendale with
I'm sorry, Your Honor.
the murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, "Hey, Creighton, by the way, X happened." So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay.
Thanks.
All right. I hope that answers your questions. He's going to get back with you. He's going to double check on Agent Kelly. But to his understanding, there was no dishonesty, but that would raise the bar to Giglio.
Yeah.
But he's going to get back with you. As far as the murder in Allendale with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of, and we can go through a long litany of that. But there was a podcast. There's a reference to what I just said.
I will say this just real quick, because I want to bring up this Fitz News. Thank you, Polly, for sending that to me. But this is very interesting coming from SLED News, in the sense that they actually don't confirm or deny anything in their statement about it. It says, regarding the Allendale murder referenced earlier, lead prosecutor Creighton Waters acknowledged a .300 blackout, the same type of weapon used to murder Maggie Murdaugh, was used in that murder. So yes, Creighton confirmed it's the same type of gun. However, Waters said the SC State Law Enforcement Division, SLED, informed him there were no leads or hits on the blackout that was used in the Allendale shooting. In other words, SLED claims there is nothing to tie the blackout used in that shooting to Murdaugh crime scene. Murdaugh attorney, Poot, very skeptical, essentially arguing SLED has no credibility. They didn't say shit. They didn't say anything about whether or not they wrote an article or not. That's just recapping what was said here. they're not even like denying that the
Yeah.
information was wrong at
I
all.
don't even see that post.
She said it was
Yeah.
from
On
like
their
10 a.m.
10 a.m.
Yeah,
I
earlier
don't
even
either,
see that
Buffy.
post on their Twitter.
I
They
Yeah.
d-
must have
I'm not
deleted that
either.
too.
And I went to
Interesting.
Wayback Machine and tried to find the Fitz article. I couldn't even find it there.
Fitz News says they never did a report on the Allendale murder. Where did they say that? I would like to know. Just
Well, I
because
can't
I would
find
like
the
to, I don't even know
article.
what this case is, and I do want to learn more about this Allendale case.
I don't see that tweet.
Hmm.
And
Interesting.
yeah.
But that is just them confirming what we just heard ourselves. I don't think it's well, hey Ange, if you find it, can you tag me in the Discord, please?
Yeah,
and
let
thank
me
you.
know. I'm looking at their Twitter right
Please.
now. I don't see it.
So,
I'm not
'cause
arguing with you.
it
Maybe
is
I'm looking in the
interesting.
wrong spot. I'm just saying I don't see it on there.
Oh, you
The
found the
tweet through
tweet through
Google.
Google. Interesting. Interesting.
Okay. Because
Well,
Yeah.
nonetheless, all very interesting. I'll be looking into the Allendale murder thing this weekend. That's a murder case. That sounds very interesting. So, all right, let's continue on.
Do you?
Maybe you could forward that to Mr. Waters and let him look at it and see if there's anything to it.
Well, we would ask that they look into that. It's-
And I'll be the first to say, Your Honor, is that I don't watch the podcast and I don't read the blogs. I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened in SLED and not call me. I communicate them daily. Their general counsel sitting here in the gallery here today.
Okay.
And Your Honor, we would ask for the underlying documents on the Colucci matter involving, judge's ruling, anything that was filed, anything related to the Colucci matter. And we'd
On
ask
the one that's going back to the grand jury that was dismissed, that was referred back or dismissed without prejudice.
Without prejudice, just to represent to the grand jury is my understanding. And again, my knowledge of that case is very limited. All this really was publicly reported, and there's a public transcript in the judge's ruling, which is available to the defense.
Get it from the clerk's office.
Yeah.
Well, we do have some materials, but we don't know if we have all the materials. And then, Agent Kelly's, documentation relating to his termination. I don't think it's just sufficient for him to say, well, I've asked and there's nothing related to misconduct, because what's publicly reported seems to be related to misconduct.
Well, there's a difference.
All right, let's pause there for a second because Angie has sent me another thing. Oh, I got rid of the wrong thing. Damn it. Hold on. Un momento, please.
But I just sent Buffy. I Googled it and then I hit the link, and Google took me to Twitter to see it, but I can't find it when I go straight to Twitter, which I find weird.
Yeah, that's what the
On
problem
Fitz
is.
page.
I went straight to Twitter and you can't see it on the Fitz page, but if you Google it, apparently it'll take you right there. So
It'll take you there. So that's weird.
Okay, so here was another thing they said. We have not filed a report on the Allendale murder, which is a weird thing to say when you write articles. I don't know why filing a report, what that means, but okay. There is a reference to it on our most recent Week in Review episode, which apparently links to YouTube. And here is the link, because Angie's amazing and also sent me the link to that, what they're talking about here.
See, I always have issues with tweets because they can be so easily faked. So, like, if I can't find it on somebody's Twitter account, like, I wonder if somebody didn't just construct that in Photoshop.
Right.
It's a very fair and valid argument, of course. But we'll look into it. I mean, again, they're still not saying yes or no, because they are saying, yeah, we talked about it here, right? I don't understand the first sentence of filing a report. I don't know what they mean by that. That's not how news works, I thought, but what do I know? Apparently things have changed in the 2 days I've been offline. I don't know. But very interesting. Very interesting. give that a listen later. Thank you both, Polly and Angie, though, for sending us some information about that, especially since y'all know I don't have social media. I live vicariously through all of you. So
She has social media. She just doesn't want to admit to it.
stop
She
it.
just doesn't want to admit it. Thank you for
Over
calling
you
her out,
too.
Buffy.
Over you
I
too.
always take
We're
the
just trying to keep you from lying. Okay. I mean, you're in denial.
keeping you honest.
We're keeping you
Wow.
honest.
Wow. Okay. Jeez.
Okay. Let me
Tough
rephrase
crowd
that.
here.
Her version of what social media is unique to the rest of the world.
She's
Well,
in denial. You
am-
had it right the first time.
I am a unique, special little dewdrop. What can I say? I just am. No, just kidding. All right, let's
She's
get back.
harnessing her inner Laura Owens on this Fukong Friday.
That's right. Always. All right, let's get back into it, friends. I'm going to use
The difference between what's in a personnel file may be
That's
powerful.
exactly right. And there's a different
Yeah, go ahead.
avenue to go when you're talking about law enforcement's personnel file. Usually, you can ask for them, but then they come to me. And then I go through them.
Mhm.
And in camera. And if there's anything in there that I think that needs to be reported to both sides, not just one, but both, then I'll give it to you.
Absolutely, Your Honor.
We'd love for that to happen. Hearing that.
I don't mind doing that.
All right, thank you.
That's
Absolutely.
fine. You just, y'all need to get together, get them. I don't want anybody looking at them. It's not, I want them delivered to my office.
Thank you, Your Honor.
We'll
Okay.
get that done, Your Honor. Thank you.
All right, next, Mr. Harpoolian. I think this motion should be moot. I heard Judge Gergel dismissed
Should be moved.
without prejudice, and I think you have it on appeal, to modify the protective order for your federal case. Are you going to withdraw this and maybe refile it later after the appeal?
Yes, Your Honor.
That's what,
We filed it before Judge Gergel precipitously dismissed the case.
perfect. I figured that made this motion moot, and I could get rid of it. If you need to refile it, please feel free to do so
Once
after
Fourth
the
Circuit
appellate.
sends it back, we'll be doing that.
Okay. Then my next motion was the state sent me a proposed order for an amended protective order. This is by consent because I received your email, Mr. Harpoolian, that you consent. Mr. Waters, what I want to make sure is because, this is a new case. That means there's new filings. And in your motion for this proposed protective order, you listed a bunch of stuff. Is that included in all of this? Or was that just a history exhibit B that you gave me?
Yes, the Exhibit B just was for, this is a new case, but I just wanted to provide the court the sort of the historical development of the protective orders and sealing orders in this case. So
While we're signing it, why I'm signing it and y'all are agreeing to it. Is that
yes,
right?
ma'am. It was just for the court's information as to how things started, how they progressed through the first trial, and how they now set up for Your Honor.
Okay, well, if you both agree, I'm gonna tell you, I'm going to sign it. I also took the liberty of putting a consent for both of you to sign. If y'all sign that, I'll have the clerk file it and take it back to Colleton today.
Want us to do it right now, Your Honor? Maybe we approach.
And I'm gonna give it to the clerk and that one's done.
I like it.
Yeah. Thank you.
Thank you, Your Honor.
All right, now the next motion that I wanted to hear, Mr. Harpoolian, I did not get a response from you, but this is for the voir dire. It's a questionnaire.
Your Honor, we agree this should be a questionnaire.
Okay.
But we think
Hold on, before we go into jury stuff, sorry. Update from Angie, who's doing all the hard work over there for us. Per a Fox News article, which she did link for me, regarding today's hearing claim, Fitz News told Fox News Digital that Griffin's reference was to its August 8th Week in a Review YouTube episode, which is the one that Angie linked and was in the tweet or whatever it's called, X post that we had up on the screen. According to a transcript reviewed by Fox News Digital, I don't know why you didn't just fucking listen to the thing, but because transcripts are not always reliable, but okay, fine. Fitz founding editor Will Folks and research director Jen Wood discussed what they described as an unverified report involving a possible third gun at the Moselle crime scene, which is very different than what Jim has brought up, but also interesting. Third gun. I mean, that's definitely nothing we've ever heard before. But again, apparently unverified reports on that. So I'm sure this is going to be talked about a lot over the weekend. So
I'm sure this is a great first episode for my brand new podcast, Misinformation, Speculation, and I'm just kidding.
Yes, absolutely.
Look out for TCWT Media's new show coming with your host, Buffy.
I'm only teasing, but that's
you get a show. But no, even an unverified claim of a possible third gun, well, that's interesting because one, that doesn't make a lot of sense, but they said 2 guns were used. If you had a third one,
right,
that implies that there was more than one person. It really does. I know 2 guns could be used by one person. Fair. It's a fair argument, I think. Is it likely? It's usually not how it happens, but we don't know. Maybe one of the guns jammed. I don't know.
I mean,
it wouldn't be the
as we
first
learned
time.
last night. Sarah Hartsfield took 2 guns, one
Exactly.
in each pocket.
It's not out of the realm of possibilities for one person to use 2 guns. But it's less likely, but not impossible and not unheard of. However, a third gun, if this unverified report is believed to be true, that would very much to me point to there being another 3 guns for one person doesn't make a whole lot of sense at all. But anyway, it's all
2 I can
unverified,
buy.
so we're not gonna spend any more time though discussing all of that because now it's just pure speculation. But maybe some more information will come out over the weekend, and maybe we can discuss that further on Monday, Murdaugh Monday. So we'll see. Thank you, Ange. And also, anyone else still send us information if you know it. We still want to read it. We still want to see it. So again, thank you, though, guys. Polly, Angie, appreciate you guys. All right. So now we're going to jury questionnaires. Okay.
As this case develops, there's going to be additional questions we're going to want to have in that questionnaire. Now, what we did in Colleton, not that that matters too much, but
true.
What we did in Colleton was we had this questionnaire they filled out and mailed back in.
Ooh.
And then when they got there was an additional, more case-specific questionnaire.
Is the audio fine for you
We're not
guys?
going to be mailing questionnaires to jurors until
January.
So we've got several months to deal with that. If you just give us to like the 1st of November to flesh that out, I think we can agree on a questionnaire.
Is that fine with you, Mr. Waters?
Yes, ma'am, Your Honor. We worked together last time to develop this questionnaire, and obviously I think we can do that again. And then if we have any issues, we'll bring them to the court.
Are you
Well,
happy?
I looked at it. I thought it was great.
I object. Creighton has not said happy one time.
He hasn't. I have no ticks.
I told you that he doesn't say it very much.
Disappointing.
I think he's watching the show.
I think he's not happy at all. That's what I think. How are we going to know, Creighton? How are we
I
going
think
to
he was happy even when he said he was.
That's true. I think it was just politeness.
Seems like it was helpful.
It did. Your Honor, what we didn't address in the questionnaire, and we've got a consultant we're talking to, about is, do we ask in that questionnaire a level of awareness about this case? I'm not saying we should. I'm just saying
Right.
we're examining that. That's why I'd like till the 1st of November. And of course, in the question, if you do a questionnaire when they get here, obviously we want to know a little bit more about their specific knowledge of the case. But
I don't.
so yes, we agree there needs to be a questionnaire. We may want to add some questions to that.
I don't think I would put that in the first round if you're mailing juror questionnaires. That really says kind of exactly what case it is that you're on or considered to be on. I would think that's not a very wise thing to do until they come in and do a second questionnaire. I don't know if I would be putting that on the first one. They're paying some jury consultant, which again, I don't know how anybody gets that job, but I'm going to look into it. That would be a great job, actually. Do we know a jury consultant person? Because if so, I would love to talk to them about their experience and how that all works. Because those are real people with real jobs that do get, a lot of work in trials and selecting juries. I think it'd be very
I bet
interesting.
Terry would find one for you to talk to.
Find us
I
one, Terry.
just wrote it
You
down.
wrote it down?
Jury consultants, look up for llama.
Add
Done.
to
Do
the
I
list.
know? I was like, she
You
will
know.
send them a cold email. Hi, we have
She will.
questions.
She'll be like, I got 15 I sent emails to. So
Right. And I will keep
Um,
calling till somebody talks to me.
that is also very Terry. And I appreciate that about her because I am not that person. I'll be like, oh, I'm not even gonna bother calling them because they're not even gonna pick up the phone. And then I'm like, but what if they do? And I'll be like, that's even worse. That's even worse if they answer the phone. What am I gonna say?
Yep.
Anyway, so I think that would be a very interesting conversation to have. Anyway,
Questionnaire.
actually, I think I have a
Not sure,
book.
but we will be by the 1st of November.
And what we did
I
last
think I have
time,
a
Your Honor,
book.
that worked very well is we had that questionnaire. The parties went through that questionnaire. We actually then had a dialogue where we agreed based on certain responses of jurors to exclude. And so they were already gone by consent, but we already identified ones that would need additional questioning. And then, of course, there was additional questioning with the court and the parties in private for either the jurors by their questionnaire or by responses in court that just needed further inquiry. And again, we were able to do that in 2 days.
And Your Honor, we would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the clerk's conduct about how certain people maybe got on the Venari and others did not. She was apparently excusing people, we believe, and of course this litigation would help us. Litigation that's on appeal before circuit let us develop that. Her daughter appeared on the jury Venari, and she and
Oh, yeah.
I guess at the time either I nor Mr. Waters thought that was unusual, but she was talking to both of us about how to make a great juror. She talked to me, I know she talked to you. I'm not saying expecting that to happen again at a new court, but in terms of summoning jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia, and then the clerk excuses before he or she issues those summons. There's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on, patent exemptions such as over 65 who claimed that were non-residency issues and that sort of thing.
Right. Would be my understanding of what normally happens
And when we
pick a jury here.
we had the whole panel arrive, yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with the Murdaugh, with Alex Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, but what was never done, and I tried to get the list, compare the initial list that was generated.
That's
in
very
Columbia
awesome.
to what actually were summons that were issued. And certainly there were people that the clerk said
They don't live here. They're
Right,
over
right, right.
65.
Dead, whatever. I get that. But there, if we never
Yes,
got the
Savage.
original list. So we don't know. And again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? And I'm not saying that could happen again, but I think I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen the clerk of court interfere in this process. And clearly,
Who we know, okay? We know. We get it. Becky Hill sucks. All right. Becky Hill sucks. She did a lot of very not cool things that she should have never done. And that's why we have this retrial now. But we don't need to just say Becky every 2 minutes in every argument you have. All right.
No,
I
but
think
it's a
it's
new
suspicious.
fear.
And I thought it was
If it
suspicious
happens
when her daughter
once,
got one. But yeah,
right.
no, I do understand what he's saying. But it's just like, oh, Becky Hill is
I
just going to
don't
be brought up
disagree with him.
so much with
He has
everything.
every right to. I mean, it did give
Fair.
him the second trial, but like also things could have gone differently in the first trial if she had not got involved. So
Fair points. But let's add Becky Hill mention to our bingo cards from the hearings,
Okay.
because that's going to be a good space, because it's a guarantee that they're going to bring up Becky Hill every chance they get. Which, I mean, I do like that they do keep bringing up her name, because she should be shamed for what she did. She knows
I
better.
think she should have to
Um,
pay for the whole new trial.
I think she should too.
That is a very
We're
fair,
gonna have
because
to
I, go ahead.
go ahead. I was gonna say
Oh,
we
I
need
was just going
to
to say,
come up with a prize for the bingo cards and
oh,
make a
yeah.
"Don't Be Like Becky" shirt or something to give away.
Because I believe it's the home county that this happened in, Colton County, or right? Colton County, I think.
Colleton.
Colleton, sorry. Colleton County. They're the ones who have to pay for these things. And now granted, smaller poor counties like here in Ohio, when they have really big murder trials happen in these small poor counties, they can ask the state for additional funding, but again, it still falls on them and the taxpayers there. And I agree. I think Becky should have had to pay for some of this as a
Mhm.
voted on. What do they call them? Public servants who fucks it all up. I'm just saying. I'm just saying. So
our Supreme Court found she did.
Okay. Well, I can tell you, Mr. Harpillion, I certainly don't mind overseeing it.
Thank you, Your Honor.
That's for sure.
And again,
Mr. Waters,
this,
I will, wherever this trial is going to be.
did I miss that?
I will certainly make sure that it is on the up and up. I can promise you that.
and just to be clear, there's absolutely no evidence that there was any shenanigans with that part of the
Yeah,
process.
I haven't heard of any
Shenanigans.
of that, but you know, we'll just make sure that everything is done properly.
Thank you, Your Honor. That's all I'm asking. And again, I would agree, we couldn't we were never allowed to look at that piece of it for our motion for a new trial. It wasn't relevant to that. And the court was not going to do. She never admitted she talked to any jurors. She was with the court, both Gene Toll and the Supreme Court found her to be a horrible liar. So you have to prove it extrinsically. We don't need to go there. We may go there in our federal case, but we don't need to go there. I'm just saying, call me naive. I just want to make sure that you are in charge of this process.
I think a lot of people are going to call you a lot of things, Poot. Naive is not one of them. But
Oh, Poot.
Oh,
Bless your
Girl,
heart.
he is buttering up that judge. Pay
mhm.
Oh,
attention
he
to
is.
how he said. I just want to make sure you're in charge of that because Judge, I trust you to do that.
Yeah, I mean,
So
I don't
funny.
his
trust
nose is getting
them.
really brown.
That's typical. Typical Poot. Typical Poot. I love it. I live for it. I do. He ain't no simple country. I can't believe I missed him saying simple country lawyer. It's
He
like
didn't say that here, did he? I missed it too.
Yeah,
I feel like somebody just said that
he
he
did.
did.
I thought he
Did
just said
he?
it.
I didn't think. Did he?
I
I don't know.
Oh, Angie
Maybe
said
I
he's
was
just a
tuning him out.
Oh,
Oh,
Angie said
no.
it.
No, he said
Ho-
from the first trial.
Yes, I
First
didn't
trial.
finish
Okay.
reading that. That was my fault.
So I saw it in
Can't wait
chat.
for him to
Okay.
say it again. And
He
then we
say,
found out
I-
he is not a simple country lawyer. He is anything
kind of
but.
would have like remembered that because that was just like a quote, like a
Right. Egg lady. That's going to be another bingo space, of course. Oh, goodness.
Not deferred to some functionary.
No, I don't have a problem with that.
Thank you, Your Honor.
All right, the next
Very
motion.
quickly, if I could
Oh,
just
yes.
say that as we got the dumps from the clerk's office with the jurors, it had the numbers on there with the over 65s and had the return from those individuals.
You did get those?
That's my
We
recollection.
did it, but the question is, who got off that list before we got it?
Okay.
That's the problem. And do we have any
You
evidence?
just
of
want
that?
the original list.
I want the
is what you
original
want.
list, and I want
I understand.
you to have the original list. So when the summons go out, you know that everybody was on that summons list
Oh.
was summons unless you were told they were dead.
Oh, she's
or-
not. I love her.
Again, I'm
She's
a little
not.
paranoid
She's great.
after our last experience, not realizing the court was trying to fix the jury.
Okay. Well, I will, I'll make sure I speak with the clerk before that process.
And Your Honor, certainly Mr. Waters is not vouching for her veracity and truthfulness here today. I understand that we're here because she attempted to fix the jury, right? Am
I
missing
think
something?
I think he understands.
Well-
Let me hear from you, Mr. Ward.
Well, look,
I
there
think
is
he
no, absolutely
understands
no
why
evidence.
we're here today.
I went through a lot and actually, suggested a lot of these procedures. Ultimately, all we were trying to do, recognizing the uniqueness of this case, and there's no denying it, is get a fair and impartial jury. And,
Right.
and the process that we put in place worked very well. That the person who was handling all that and sending out those juror responses, it was, there was multiple staff involved, and all of that was under the supervision of Judge Newman. So we certainly understand what the Supreme Court ruled.
Look at Alex's
I
face.
know Your Honor will supervise whatever process.
Yeah.
My only goal and my only intent is to
Tell he was
let
during
the
his whole
Supreme
trial.
process take place, and then give us the jurors that are in play, and then we'll put together a fair process to put 12 in the box.
I agree with you, Mr. Waters. I'll take care of that. You don't need to worry. Neither one of you. All right, next motion is going to be the state's motion in limine to exclude evidence of the polygraph. Let me hear from you, Mr. Waters.
Yes, ma'am, Your Honor.
I'm
Yeah,
gonna
this was just
screenshot
a
those
prophylactic
faces.
motion in limine that we filed prior to the first trial. And again, the case law is cited in there. I'm happy to detail it for Your Honor, but obviously the case law is very clear in South Carolina that polygraphs are a no-no. And that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual
why are we
notes
talking about
that,
this?
it's not a lie detector. What it does is record physical responses that in the subjective opinion of the examiner may indicate deception, but that deception may or may not be related to concerns of.
Wait, didn't she just say this was a motion by the state to exclude?
Yes, the
The lie
defense wants to
detector.
bring in the polygraph.
Okay, I was like, wait, what? Wait a second. What are we talking about? Because
Yeah.
I mean, that's interesting. The defense wants to bring it in. And listen, I think lie detectors are a bunch of fucking bullshit. And that's why they're not allowed in trials. Because the science, trust me, the police want you to believe that no, it's not. It's garbage. All right. It's garbage science. All it does is do your elevated heart rate, which could be for numerous reasons. All right. But that's interesting. I did not know that the defense wants it put in.
Wants it in.
but the state says, no, we don't want. Ooh, that is interesting. So are they saying he passed it? Quote unquote.
Well, I
this
can't
garbage?
imagine why.
But
I can't imagine why they would want it in if you failed it, 'cause that just sounds dumb.
Unless they
well,
ask leading questions.
I mean,
yeah,
we
there's
could
a
always-
lot of problems with lie detectors. A lot of serious problems there. But I mean, everybody under the sun has called Alex Murdaugh a liar, and he is a liar. He's lied numerous times, and that's why no matter what happens, he will not be walking out of prison if he's found not guilty here. I suppose that the defense could want to use that as like, yes, he lies sometimes, but he's not lying about this. See, he passed a lie detector, but to me, I don't know how other people on the jury will feel. I don't really give a shit either way. It doesn't mean anything to me because they can be easily passed. Honestly, I would expect a lawyer to be able to
They can
pass
be
them.
easily failed. I would
Yes,
be
that too.
100% telling the truth and probably
Same.
fail every question because I
Right.
have terrible anxiety.
Absolutely. But, ooh, that's interesting. Okay.
Yeah.
All right.
Guilt or innocence. And that's why the courts have always rejected those, in addition to the fact that they go to the heart of why we have courts and why we have juries. And that's, of course, for the ultimate determination of the truth of the matter. And so, obviously, from the state's perspective, if there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that that witness and that, officer or whatever does not say the P word out loud. And that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that. And we just asked for the same thing, that there be, just sort of an in-camera ruling and an instruction that the polygraph word is not to be mentioned because, again, it can be hard to unring the bell.
That's right. Let me hear from you, Mr. Harpootlian or Mr. Griffin.
P word, right?
Sure.
So generally, Mr. Waters is correct.
Savage, I forget. Did you watch the first trial or not? I can't remember. If you haven't, you are going to fucking love this trial, Savage. And I can't wait for all of your comments. But yes, Foghorn Leghorn versus Richard Dreyfuss. Yes, that is exactly what you can expect for 6 weeks of this trial. It's very entertaining. So it was a great trial. I think this second trial is going to be just as good, if not better.
You'd remember this trial if you watched it. This one's not one you easily forget whether you watched or not.
True. Yes, it is everyone's gonna be like Llama. We're watching the Karen Reed retrial. If they didn't see the first one, they're gonna be like, what? Lots of snot. Yes. It's certainly gonna be a very interesting. So I'm pumped.
But, and let me point out to the court, and I'll hand up a copy of the case. It's the state versus Henry Eastwood, which,
It's the Eastwood case? Is that what you said?
I'm sorry?
It's the Eastwood?
It's the Eastwood case.
I've
Paul,
got a copy of it.
the armpit
Go ahead.
corner. Remember that? Oh, what a wild time.
I've got a copy.
So, as you know, if you've got a copy of it, the Supreme Court said there's not an absolute ban. There are circumstances under which a polygraph could be used. Again, it is not a lie detector, but the question is, if somebody was confronted with the fact that they failed a polygraph, did they give it? I mean, in this case, did they give a confession? The Eastwood case, it was a confession gotten. In this case, and we want to argue this more fully, depending on whether or not this witness is called, Eddie Smith, who we've already understood was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows,
but he didn't pass it.
In other words, he had a deal,
That's exciting.
and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying
very
that
similar
it's an issue
to Vacation
not now,
Cousin Eddie,
but much closer to trial that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdaugh passed the polygraph, flying colors. So the same polygrapher. So it may play a role in this trial. I'm not willing to concede that not under any circumstances can a polygraph ever be used. I'm just giving you this example of Eddie Smith failing the polygraph and them relying on it to cancel this deal. Now, that's what our understanding is from the limited documents. They never called Eddie Smith in the first trial, which we were shocked by.
Me too, Poop. Me too.
But should they call him in the second trial, we may want to go into this, but
they're not gonna.
So I would ask you not to issue an order prohibiting any mention of polygraph with this guarantee. We would not mention polygraph in a courtroom with a jury until given permission by Your Honor to do so.
All right, well, let me tell you, anything else from the, Mr. Waters?
Well, Your Honor, just to correct one thing, there's
Oh, wait, hold on. Let me listen to Craig
sort
real
of
quick.
deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a agreement. It's only
nah.
essentially a first date. Again, polygraphs can be an investigative tool, but they are never, I never base decisions on them. And frankly, in my experience, I found them to be wrong or indicate DI for other emotional reasons than
I don't know why it's being like that. I'm gonna go back just a few and let it catch up to something, and then we'll discuss.
DI for other emotional reasons than they're not ever relied upon in court. The case that they saw a completely different issue where in that particular instance, the defendant wanted the fact that he had been given a polygraph and was told by the lying.
Was this happening when it was live?
Defense and presenting an expert on, and that is nothing that we have in this particular case whatsoever. And in fact, if you look at the that we cite in the memo, Your Honor.
Hold on. All right, I'm going to restart this so we can talk about this while I'm reloading it.
It's either YouTube or
yeah.
All right, 154.
I'm going to say YouTube, StreamYard, it's both.
Who knows? It's a day. It's always something around here. 154. That's
I really
farther
like
we
that,
were.
Judge.
Give me 1 second. I'll find.
Okay. All right. Let's re-listen to what he's going to say here at the end, and then we'll talk about the polygraph scenario here.
Of what the Supreme Court has.
Oh,
one situation.
I'm not even sharing it with you guys. That'd probably help, huh?
We're just staring at each other.
I'm just staring at Buffy's amazing hair.
I know. It looks so great, as always.
I love that.
And give me 1 second, I'll find the case. That would be State v. Counsel, which is the seminal case on that. And in that particular case, their witness who took a polygraph on were you present, were you involved, and DI was shown, deception indicated was shown, that because a polygraph cannot reliably show truth.
Why is it doing this?
To the jury because it doesn't show anything. So that's a vastly different situation, more akin to what we have here, where the Supreme Court has already said no, than the situation, the Eastwood case.
Why does Creighton talk so damn fast?
This aspect of it was crucial to.
Thank you.
I listen to things in 2 times speed, but like he talks in 2 times speed.
He does. Why is it doing this? It's driving me crazy.
And this aspect of it was crucial to.
Thank you.
Very, very briefly. It was
It didn't do it this morning.
You're going to tell us to stop, and if you pass the polygraph, we can go to the next step, which would be perhaps testimony. They were using it as a screening device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right. He doesn't have no. And the reason he doesn't have a deal is he failed the polygraph. Now, whether we talk to the jury about that 9 months from now
I'm gonna restart after
is an
poop.
issue. But all I'm saying is we would ask you not to issue an order blank
I am gonna use the different.
mention of polygraph, although I will concede I would not do that without having the in-camera hearing of some sort.
Well, that's going to be my ruling.
Okay, hold on. We're gonna talk about this before we get to her ruling while I try a different source because I don't understand why it's doing this. I don't have anything on unless not so little llama is using all of our bandwidth. Probably. He's probably not even awake yet. So I find it very interesting what they're saying regarding the polygraph exam regarding so this seems to be more about cousin Eddie and less about Alec and his passing of it. Do I think they did not call cousin Eddie in the first trial, which was shocking. I was on the same very surprised they didn't call him. And they want to bring it up if he should testify, which I don't think he's going to, because I think the state does not want him on that stand in any capacity, which is very interesting to me. But they're saying, oh, the state, just got up here and told you, Judge, that polygraphs, they don't care about them. They're not significant. But Eddie over here, they were willing to give him a deal if his proffer, if he didn't fail the lie detector, which I think is very interesting. And the state's like, well, a proffer is not a deal. Yes, it is. Okay, it is part of the deal. Is you give your truthful statement of what happened under oath to the state, and it is part of a plea deal. In most cases, here anyway in Ohio, that's considered a proffer from a defendant, and that's when they give them. Otherwise, don't tell the state fucking nothing. Um, but so it's interesting that they were like, well, he failed it, therefore he doesn't get it because he must be lying. And then Alec passes it, therefore he must be lying. We don't want either one of these in court. And it's like, what are you? That's very interesting to me. And then Creighton's like, well, we all know lie detectors aren't accurate. So were you just pulling cousin Eddie's leg then, if that was never going to convince you? It's very confusing what the state is trying to say here.
Yeah. Y'all are the experts. I'm confused.
I mean, listen to me. As I said, lie detectors don't mean shit to me. I don't care who takes them. I don't care what the result is about it. It's irrelevant. Anytime I hear it, it just goes into this is garbage. I'm not going to pay attention to it at all. But it is very interesting. The defense say, hey, we're not going to bring it up, Your Honor, unless cousin Eddie takes that stand. And then we're going to be like, oh, here's the state trying to like make deals and going back on the deals because whatever. They're not interested in the truth. They're just saying he's lying and third party, all this sort of stuff. I understand why the defense wants to bring it up. I think it's worthless. But
Angie's
that's
saying,
not true, though. It wasn't why his proffer was not allowed. Is that not what he just said?
That's what I thought he just said. So did I misunderstand?
So, because that was my understanding, was that if he passed it truthfully and gave his proffer, then he would be given a deal. Well, he didn't pass it, and therefore deal
So they took
taken
it
off
away.
the table. Now, Creighton, okay, I think Creighton said, oh, no, that's not the case. I don't believe that for one fucking second. When you're trying to secure deals. Do I think it's the only reason? No. And I think that's what, that's, okay, yes, that is what you were implying, Angie. I see. That doesn't necessarily make me believe him at all about that. But it's interesting that they are no longer interested in making deals with Eddie. I think there's a lot more to it. I'm going to go with the judge is just going to be like, no polygraph things, period,
I
which is
don't even
fine.
know why they
And I
even
agree.
do them at all if you can't use them
Exactly.
in court.
Because
And I would
it's
never, ever, ever, ever agree to take one if I was the target of
Mhm.
investigation, even if I
Never.
didn't do
Because
it.
Nope.
they've proven people lying past them, people telling the truth fail them. So why would you take one?
It amazes
I mean,
me
they
that the
can't do
federal
anything to
government,
help you.
right, and the federal government uses them all of the time for their like
Mhm.
high security level employees, and I'm just like, what?
Yeah.
Why? What are we doing here? Are you guys
Yeah.
serious? That's not how they work. It's very weird to me, and I don't understand. Because also, when you don't know somebody's baseline, I mean, there is no scenario where you walk in and the average person isn't fucking nervous. Like the average person, all right, a civilian, if you will. Maybe not the professionals that, get polygraphed by the government or whatever. They're probably used to it. But a civilian going in there with another officer, like that is so anxiety inducing, I think, for anybody.
Mhm.
Innocent, guilty, it doesn't even matter. Because I would be. I'd be like, oh boy, I can't even fill out a government form without being really nervous. Like, oh my God, what if I get it wrong and they accuse me
A
of
government form, try school forms. I
Yeah.
put in the wrong thing in every line. I'm like, oh, that's her name, not my name.
Right. Had that filling out one of Not So Little Llama's forms yesterday for orientation. They asked for the email address, and I was like, do they mean his? Do they mean mine? Because later on, it asked for my email address, and I was like, but what's the first one?
It's like,
It's
do you want her
stupid.
phone number? Do you want mine? Why are you calling her? She's in class. I don't know what you want.
Exactly.
It's too many questions. Can you use the one from
Yeah.
last year? I don't want to do this
So
again.
half-ass fashion, that's what I was thinking. All you got to do is take a Toprol, which is a beta blocker, and you'll pass it.
Mm-hmm. Open house. That show is so ridiculous.
But
Oh,
they
it's so
tell you when
funny.
you get on beta blockers that you must tell if you ever take a polygraph test that you take a beta blocker.
Mm.
This is not legal advice.
This is not legal advice.
No, don't take one. That's not
I'm
legal
going to just
advice,
say
but also don't take
never
one.
take a polygraph test, but that's not
Mhm.
legal advice.
Right? Okay. Anyway, let's see what the judge has to rule on this. Oh, you know what? I didn't even look up a different. Oh my goodness. I'm just over here talking away. Murdaugh trial.
Must be really hot outside because all of the dogs just came into my office, like
It
opened my
is. We
door and
have a
came
heat
in.
advisory here
We do too.
until like
but
8
I'm like,
o'clock tonight.
"Geez."
Oh wait, I was just using court TV, wasn't I? I
There's
needed.
no sun at 8 o'clock at night. Why is it still so hot?
So hot. That's why we're going to the burn ban. Everything is crispy.
It gets hotter here in the evenings after 5 o'clock. Always. It's always the hottest then. I'm not typing in my name. Oh my
Why?
goodness.
The sun goes down then.
I know, but that's when it gets to be the hottest. It's very weird. In my house, and let me specify,
Okay.
in my house. I will have no air on all day until about 5 or 6 o'clock at night, and then my house is warm, and I'm like, ugh.
What is that like? Who doesn't
I
put
know.
their air all day?
I know. I'm like, what are you talking about?
Why is this?
I can't
Oh,
live
because
without
long crime.
AC.
The south here. No.
We hardly have had needed to use ours this summer, which is wild.
That is
All right,
crazy.
sorry, I forgot.
She's adorable.
Oh no, does anybody remember what the timestamp is? I think it was like 1:54.
154.
See that not
Oh, too far. Too far. It's all right, we'll backtrack a little bit. Let's do this, give it a go. All right. Nope. Put us back on stage with that. Thank you very much. I don't need to see long crime crash chat. Thank you very much. It's the worst. So
Who did you do the vom sound? Because
I did,
like you
yes.
almost started a chain reaction over here.
I was going to say that was a little too real.
Oh no, that was just me doing that. So
You've got Buffy and I back here going,
Yeah, I was like, you can't do that. Some of us have like reactions that are automatic to that sound.
yeah.
Okay, noted. Noted.
Yeah.
All right. So if you ever see people in the long crime chat, just be like, hey, are these people unreasonable? Come watch with us. because it's a rough time.
I tried
Yeah.
that this morning. And
Did you?
I was like,
No.
close the chat.
Close.
Close
Oh,
the chat.
looking at it. Ooh, no, thank you. Hard pass. All right.
One situation.
We backtracked a little bit,
Give me
but
1
whatever.
second, I'll find the case. That would be State v. Counsel, which is the seminal case on that. And in that particular case, there was another witness who took a polygraph on, were you present? Were you involved? And DI was shown, deception indicated was shown. And of course, the court said that because a polygraph cannot reliably show truth, it's of no assisting to the jury because it doesn't show anything. So that's a vastly different situation, more akin to what we have here, where the Supreme Court has already said no, than the situation in the Eastwood case, where that false confession and this aspect of it was crucial to that expert's opinion.
Okay, thank you.
Very, very briefly. It was a proffer agreement. In the proffer is, you're going to tell us stuff, and if you pass polygraph, we can go to the next step, which would be perhaps giving him something for
a lot quieter.
They were using it as a training device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right. He doesn't have a deal as far as we know. And the reason he doesn't have a deal is he failed the polygraph. Now, whether we get to talk to the jury about that 9 months from now is an issue altogether different. But all I'm saying is we would ask you not to issue an order, blanket order, prohibiting the mention of polygraph, although I will concede I would not do that without having the in-camera hearing of some sort and getting clearance.
Well, that's going to be my ruling, Mr. Harpootlian. I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial. You understand?
Well, I think, Your Honor, you probably shouldn't threaten mistrial. You should start contempt.
Contempt. Yeah, you don't want me to hold you in contempt, Mr.
Well, I don't want you to
Harpootlian.
mistry the case.
And I might mistry it if you start screaming polygraph. So without letting me know before.
You would think she wouldn't need to clarify that, but it checks out. Okay. It checks out.
I just need
things
her to
that
call
happen.
him Poot one time.
Just one time. Just one time.
I love the way she talks. She's like, and I'll tell you what, don't make me come down there.
I very much enjoy her. You have to say it P word, not the P word. Woo woo. Okay. Though, again, she would have to, she does need to be specific. Like, if you do this, you're going to be in so much trouble.
Beforehand. You understand? I want to make sure everybody's on the same page.
I got it. I think I suggested it. I agree with you. I wanted you to know there are circumstances, and that's one where we may seek to do that. We're not going to do it without getting your approval, and
perfect.
That may come up in the context of his testimony. He may say something that.
I mean, you never know what happens at trial.
Right.
I'm just telling you right now, I'm telling you a polygraph is not admissible. If you're going to bring it up, you need to let me know first, and then we'll have an in-camera hearing.
Thank you, Your Honor.
Any objection, Mr. Waters?
None at all, Your Honor.
All right, then let's move on to the next motion. The next is the state's motion in limine to allow the state's use of the defendant's prior testimony in retrial.
Ooh.
Let me hear from you, Mr. Waters.
Before we go on that, we talked about this on Monday because this was one of the new motions filed this week that I thought was a very interesting argument, which was Alex testified in his first trial, which he shouldn't have done, but it's bad. It was so bad. And now the state wants to use that testimony against him in this new trial. And the argument is that allowed? Is it not allowed? Under some previous cases they cited where, but the interesting thing was that the cases that they cited were not mistrials. They were trials that did already, like there was a death penalty one where he was found guilty, and then the sentencing portion was redone. All right, so the whole trial was not redone, just the sentencing. And the Supreme Court ordered that, yes, they could use his testimony in that because it was not a new trial. And one of the this was filed by the defense. And the other argument was that oh, I can't remember the other case off the top of my head. Anyway, this I've pondered a lot of thought of. I thought it was a very interesting thing to bring up. So I'm excited to hear both sides argue their points in this. So yeah, okay. Look at me nerding out over here. Like, yes, finally. So excited to hear it. Because, do you waive that if it's a brand new trial or does it stay? I don't know. So thank you, Angie, for the happy poop. Jules, that's our favorite over here. Well, my favorite. I don't know about Terry, but it's definitely my favorite. Thank you so much for that. Appreciate you. Should be a happy poot. We'll rename it. How's
Should
that?
be a happy poop.
It should be. Do you get to type in what it is or no? I've never sent Jules.
No, it's just pictures.
Oh, you just pick a thing?
Yeah, you pick a
yeah.
picture of what you want to send it. You get a picture and it tells you how many joules each is worth, and you pick the one you want.
Oh, do we get to create them ourselves?
No,
No,
you have no say so in this.
That's a
This is not Burger King. You can't have it your way.
I'm gonna write letters to YouTube. Angry letters. Maybe emails.
Okay.
I'll have you do it because I don't want to send them.
If you write letters to YouTube and ask them to make something else, they're going to screw up YouTube again.
That's true.
I was say, yeah, let's not do that.
Fair. All right. Let's listen to this argument.
I've done a lot of research on your motion.
Yes, ma'am, Your Honor. Obviously, at the first trial, Mr. Murdaugh, who of course had given multiple statements to the police, in which he said he had never been down at the kennels. He had told all his law partners, all his friends, all his family that he had never been down at the kennels either. And obviously, during the state's case in chief, we presented witness after witness who knew him very, very well, saying 100% that's his voice on the kennel video, which again was taken at the scene with the victims and according to the timeline, just moments before they died. And so he ultimately, with the full waiver with Judge Newman, said, I'm going to testify and I want to testify. And of course, right out of the gate, the first series of questions asked by Mr. Griffin on direct examination was an explanation of why did you lie about being down at the kennels. It was the most important issue in the case at that point. Obviously, as a general rule, under Harrison.
And by the way, we will, because we'll have lots of time in between hearing. I'm pretty sure I can speak for Terry and I. We will be rewatching his testimony for sure. Like there's this weekend I am categorizing the previous trial where we are gonna watch previous testimony and all of that and revisit the first trial while new stuff is happening in this. So we will definitely be watching that again. Get your tissues. It is filled with snot. I wish I was joking. It is not. I don't know. I don't know if you can handle this snot, Ange. Yeah, it's so much. It's kind of wild, but so we will be revisiting some of that. If you haven't watched before, be prepared because we'll be going there.
Defendant's testimony at a former trial is admissible, and I'll get to the statute in a second. And then I'll also, of course, under Rule 804A1, it would be admissible, of course, based on unavailability, assuming that he would refuse to or exercise his Fifth Amendment right at a second trial. The issue, of course, boils down to the statute. And of course, the statute says that the testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. And of course, our position in that is that this is the same criminal case. This is not an other criminal case. It's the same indictment. It's the same allegations. It's the same case that we are doing. There's no question that we are starting the evidentiary presentation again from new, but that doesn't change the fact in the plain language of the statute that this is the same criminal case. And we say
That's the critical distinction for the statute. Either
But
you're
didn't
in
they,
the same case.
didn't both he and the judge refer to this numerous times already about this being a new case?
I felt
I mean,
that.
I think I know
Yeah.
where they're about to go with this argument, but I'm just saying, I have heard both of them say that this is a new case a few times
Mhm.
already,
Mhm.
both him and the judge,
Mhm.
when arguing other things that was brought
Mhm.
before them. So, okay, all right.
Yeah.
Just
Put
wanted
a
to make
pin in
sure.
that.
Put a pin in it. You know, I always get up my pins out. Put a pin in it. We'll be back. But okay, just wanted to make sure we're on the same page here. But okay, interesting.
So you're not.
I agree, and we cite Tucker for that proposition. Now, I do agree that Tucker's a little different. It was a death penalty bifurcated case, and that the guilt phase was affirmed and the sentencing phase was reversed. But the court clearly said there that during the resentencing phase, that prior testimony was admissible because it was the same case. Now, the defense obviously argues that that because of the Supreme Court's guidance on the financial issues, that ultimately his decision to testify is somehow impelled by that, and we would respond to that in two ways. Number one is the first thing is it's very clear that the most important reason for him, quote, "I want to testify," is that he had to explain that kennel video, which again was the most important issue for the defendant to testify. Secondly, as we look at the opinion, and obviously I know you've deferred on the motive evidence, and we'll get to that at a later time, of course. But the Supreme Court, while saying that perhaps the trial court let the state go too far with that evidence, the court did say that the court appropriately ruled the evidence admissible under 404 and did appropriately admit at least some of that evidence. So ultimately, depending on how Your Honor rules on that motive evidence, admission of any prior testimony, should the state decide to do so, could be very much tailored to whatever the appropriate parameters are based on this court's ruling as to the extent of that testimony.
Right. I think it would go along with what financial crimes are allowed in at the time of trial. Absolutely.
Absolutely. And the state certainly understands that and is willing to do that. And then even aside from that issue, clearly, whether it's impeachment of this defendant, should he testify again, or if the defense were to present a new theory through evidence that would be refuted by this testimony, I think that the law is very clear that then it could be used for impeachment to sort of, if they change tack, then it would be fair game, regardless of the issue of the statute.
Okay.
Okay. Let me. Who's going to argue that?
He said he's willing but not happy.
Barbara,
He again, have we even heard a happy? Have we heard a single? We're how long into this? Over an hour. I haven't heard one single happy. Well, I think those are very interesting arguments. So just so I'm clear here on what he just said, he would only bring up, oh, it's Ashka. Oh, hi. I know who you are.
I was like, say,
Hi.
she wanted to say hi. You do have
It
the
took me a
best mom.
second. It's true. It's true. I tell her all the time. So he's saying, oh, we're only going to use this if need be about the financials and whatever, which I do not believe. Do you think they're going to play clips or just read from the transcript of what he said? I'm thinking, I know I'm comparing it a lot to Karen Reed, but I only say that because it's the last retrial we've watched together that is similar-ish, kind of, but not really.
If it's allowed, I want to see the clips.
I will say, can you imagine them doing like they did in the Karen Reed retrial, that like every time they go into a new like thing, like the segue is a
that would be hilarious. Actually, he should not have taken that stand. It was
He should not.
not good. Will he take it again though?
I mean, I
Is
love that he
gonna be
took
interesting.
it, but
I don't think that he should take it again. I think if he
mm-mm.
is smart, he'll just sit there and be quiet.
But hubris is a dangerous thing. So
It is.
Yeah.
It is.
But okay, so they're trying to use this only in certain scenarios. Okay. Though, if we're treating it as it's still the same, it's all usable, the state should be a little leery because then that means all of their witnesses and their testimony can be used to impeach them in this new trial as well. Which, considering Saled's history there, I'd be a little bit nervous. But all right, well, we'll see. Let's hear. I'm assuming the defense is about to argue next. I think what he says makes sense. But I don't know yet how I feel about it. I get it. I think they're still separate, but okay. All right.
Good morning, Your Honor.
Good morning.
Of course, we oppose this motion on two grounds, a statutory ground and a constitutional ground.
Oh, it's Barbara.
And I would like to address the statutory one first on the generally accepted principle that
He's the lawyer we forget that's there all of the time.
There.
He was around for the first trial too. I think he did one witness or something like
But
that.
he's
one
very,
or
very
two.
good.
He is very,
I like-
very good as well. Yeah, he doesn't have as much pizzazz
No,
as
but he's
the
very
others,
polished.
but he is very polished, very knowledgeable in things, and not very. He comes across in like, oh, we can have a conversation, sort of.
Okay, but
thing.
you always need the straight man
Right.
in a
That would be
threesome,
Barbara.
right? I'm not sure
Yeah.
who the straight man
Ah.
is in this threesome, but I'm just saying.
Yeah. But yeah, he did do a few, not do a few witnesses, considering what you just said.
Said. I'm
Um,
like, be careful with what you say now.
Anyway, it's always interesting when we get to hear from Barbara, is all I'm saying. So
constitutional issue could be avoided, that you should rest on statutory grounds. And the statute here is 1911-50, which, as Mr. Waters said, prohibits using his testimony in another criminal case. And so we're concerned on what is the same cases versus another case.
okay.
At 10:23 a.m. in this hearing, Mr. Waters, standing at this podium, said, quote, "This is a new case."
That's what I said.
That was his statement on behalf of the state on a different motion.
Also, Barbara, the judge said it like 3 times already too. Just
said
putting
it.
that out there. I understand why you don't want to bring it up, but like she totally said that like 3 other times. Anyway. One straight man and a threesome? What trial is this?
It's Friday.
It is Coupon
It's
Friday.
Coupon Friday.
I know it. We didn't do a Laura Owen stream earlier today because I wasn't sure if I had internet or not because of the storms we had last night, which I obviously do now, but we're like, whatever. We'll return next week. That's what I said, Barbara. That's what I said. But okay, let's hear more of his argument here.
He said, quote, "This is a new case." Now, for the purposes of this motion, it becomes, again, the same case. The defense's position is that a trial de novo is another case, that is the logical, rational conclusion from the statute, that the purpose of the statute is to protect the ability of a defendant to testify in one criminal case without a broad, irrevocable waiver of his Fifth Amendment rights.
Yeah, totally.
The state, as far as I can tell, takes the position that the indictment number controls whether this is another case or not anything substantive happening in a case. And I would point out that there's not a single case in which, with the trial de novo, because of an error by a state actor, not the prosecution, but certainly a state actor, that constitutes irrevocable waiver of the defendant's Fifth Amendment rights. You know, Tucker is the closest case. As Mr. Waters conceded, it's not really applicable to resentencing on the same conviction. Here we're having a trial de novo, and everything is new. As the court just went through with all those other motions, it's a new case. Even the protective order has to be redone. Everything is new. All the motions in limine have to be redone.
Yeah.
The one thing that is eternal and cannot be changed from the previous trial is one witness's decision to testify. Is that Fifth Amendment waiver is the only thing, according to the state, that's not waived. For purposes of the statute, we suddenly become the same. And before getting to the constitutional infirmity of that, as Your Honor knows, we filed a motion to dismiss the indictment shortly after this motion. It was responsive to this motion. If the state, it's a reductio ad absurdum argument. If we're really going to take the position that it's not a substantive question whether this is the same case or a different trial, well, if it's the indictment numbers under thrift, we clearly meet the standard under thrift for dismissal of the indictment. Now, is that a waste of the court's time? I would say yes, because they'll just go to a grand jury and re-indict it.
Okay.
But if we're going to put substantive import on the indictment numbers, the arbitrary indictment numbers, well, the grand jury, we have testimony from the first trial that the grand jury was presented evidence that the state admitted in its reply closing argument was incompetent, which the witness also admitted was incompetent. We
And he
have, if
lied.
you look at that very lengthy motion for sanctions that's still pending, it's a colorable claim of misconduct. I would point out in thrift, the Supreme Court explicitly held there was no misconduct, but because there's a colorable case for it, which is the least possible burden, well, fabricated evidence it's a colorable claim of misconduct. Okay, is it prejudicial? Well, it would be the only direct evidence linking the accused to the crime, the only direct forensic evidence, something that would prove his guilt that must be prejudicial. So we meet the thrift requirements. The indictment should be dismissed. They should have to go back and re-indict it. We'll get a different indictment number and be right back here with a different case if that's really their position, that a trial de novo is not another case. And this is just a statutory argument. There is, of course, a constitutional argument, and which is the Harrison argument, which is that because he was testifying to address evidence that was ruled to be inadmissible, that his Fifth
What does
Amendment waiver cannot
colorable
be,
mean?
uh,
It's a very nice way of saying there's a lot of drama and shit going on. That's my interpret. What are your guys' interpretation of the word colorable in
Same.
reference to?
It's just,
there's
yeah,
it's
dramatic.
Yeah, it's some stuff
Extra.
going on here. Very interesting arguments from both sides. Sorry, I'm like nerding out over here. I'm like super honed in right now, but this is another reason why I like Barber as well. Like he is very just in case you didn't
It's just
watch the first trial,
straightforward.
you're getting to know all of these lawyers. Like this is very Barber, a little bit soft spoken, but comes across as very, chill, noticeable, not trying to ruffle too many feathers, but has stuff to say. And sometimes that's very powerful as opposed to some other antics we see from the other attorneys here. But I miss these guys so much. I mean, I do hate that here we are with another retrial that, thanks to Becky Hill here. But it's nice to see them. It feels very familiar to all of them. We spent a lot of time with them 3 years ago. A lot.
I miss South Carolina.
I know. I appreciate so much about it, the way they do court, all the fun stuff. Angie says colorable is an adjective that means seeming a valid, genuine, or plausible on the surface, but potentially deceptive or false upon a closer look. Yeah, it's not.
Okay.
It's a very polite way of saying there's some shenanigans afoot there, is what how I interpret that. So
held in this new trial. I mean, that's the clear holding of Harrison. It clearly, and Simmons as well, which was a suppression hearing that in that case, someone testified in a suppression hearing and electing to assert that Fourth Amendment right in a suppression hearing, you're not required to waive other constitutional rights. The case law clearly held, and Your Honor indicated that you've done a lot of research on this, that a witness cannot be required to surrender his constitutional rights to address inadmissible evidence. And I think Mr. Waters agrees with that, and that the dispute is whether or not he was testifying to address the financial crimes evidence. But as our response motion, with many quotes and block quotes, that was explicitly preserved. In Harrison, it was just an inference. In this case, counsel repeatedly put on the record why he was testifying. On page 3 of our response, Mr. Harpoolian said at that time, quite explicitly, put on the record that our advice as to whether to take her stand or not would have been different had the financial crimes information that he was also renewing the objection to had not been admitted over objection. And the court held in response to that the objection was preserved. So here we are. Harrison directly prohibits this, though I would suggest to Your Honor that the statute would be an easier ruling because there's no reason to reach a constitutional question. This is another case which we just said a dozen times when discussing previous motions.
Thank you.
Thank you, Your Honor.
Any response, Mr. Waters?
Very briefly, Your Honor. First of all, just because I just got this from General Counsel at SLED that there was a 300 blackout that was used in Allendale. However, it was entered into IBIS and there have been no leads or no matches on that. So that's what I was just informed.
Is that going back to
the prior motion?
To
yes,
the prior where the blackout was
and I'll find out more, but it
said to have been used in another murder in Allendale or somewhere. You understand that, Mr. Griffin? Okay. Sometimes a real novel idea is to pick up the phone and call each other and talk. That's what we used to do when we were younger. Just call and ask if you've got a question. And then if you have a problem with it, I'm more than happy to settle it for you.
I missed what he
I hate
said.
that
Hold on,
we
I'm
have
coming
to
back.
do this in court. I do. It's easier.
I'm sorry. What did he? I'm trying to wake up little llama who next week has to start catching the bus at 6:43 in the morning. And it's 4:30
like
over
4
here. I know. I've been trying to wake him up for hours. This is going to be tough. Starting high school is going to be tough. I'm sorry. What did they say? What did he say that SLED said?
that they
Just now?
have not gotten any matches in the database and that he'll find
For
out
the
more
300
is what I
blackout.
for the blackout 300. Yeah.
Okay. Have they not gotten any matches because they tested it, or they just haven't bothered yet, or what do they mean by that? But okay. Thank
I
you.
don't
And then she
know. I
says
didn't get
just
to see
pick up the
report.
phone and call each other.
She said, y'all know y'all can talk to each other, right? You don't have to put a motion in front of the court. Y'all can actually
They-
just talk to each other.
These sweet summer child judges doing this one in the Judge Gilday and O'Keefe Reed one where he's like, oh, I don't understand why this is so hard for everyone. It's like, because people be petty. All right, get out your nail
It's like-
polish and your freaking, file your
I'm
nails.
like,
They be petty, girl. Okay. I understand what
Yeah.
you're saying makes sense. But not so much.
And they're like, yeah, but we don't even really like each other. So why would I call him? I don't even know that he'd tell me the truth. So I'm just going to ask you, Judge.
I mean, I don't think both sides here are near as bad working together as the Karen Reed civil trial. I
Oh,
mean, nobody wants to cooperate in those whatsoever. But it's always funny to hear judges be like their parents. Why can't you guys just get along? If you would just
Well, that's kind of what she sounded like. She's like, when I was a child back in my day, we picked up the phone and we just called, how you doing?
Right?
that's right.
It's adorable. Our sweet
And she
summer
gives the
children.
mom look every now and then. Have you noticed?
I know, right? Yeah.
I was nervous at first, but I fall in love with her more and more every day. And I reserve the right to change my mind. No, just kidding. I doubt I'm
I
going to
always
agree with
do.
everything that she does, but it's less about that and more about how she handles the courtroom in general, right? Because it's
Mhm.
okay. If you don't agree with a ruling, that they can still be a fair judge,
Mhm.
even if you disagree with one of the rulings. Now, there are some judges, however, that I think are disgraces. And it's a short yet long list.
Is there
But
any in Massachusetts on that list?
Yes, Massachusetts, Indiana, Arkansas. There's a list of very questionable decisions. No, I'm not a lawyer, and no, I'm not a judge. But you can still be like, that seems very
You can still have
suspicious
an
to me,
opinion.
ma'am. Yep, I can still have an opinion, and I have plenty, as everybody knows, because they're usually unpopular ones. But that's okay. Anyway, okay. Thank you for catching me up on what I missed. I don't even hear little, not so little llama moving about. Jeez. Anyway,
Mega horn, air horn.
teenagers,
works.
man. Woo. Gonna be tough. It's gonna be tough. All right.
Now we can email you if you don't want to talk to each other. You can just email each other.
I just want to say, ma'am, it is not easy for other people to send emails. You sound like Terry. You can just email them. What if they say no? And I'm like, that would be the worst thing that's ever happened to me in the history of ever.
But these are lawyers. Let's be fair. You're
These
not
are
an
lawyers.
attorney.
Yeah.
Yes. Angie posted, Water said he heard from SLED there was a 300 blackout found to allegedly have been used in another murder. You don't have to asterisk murder, do you? No. He's gonna look into it. That's the gist of what he said that I remember anyway. Okay. Interesting. Again, though, we run into the problem with SLED.
Do we believe SLED?
I'm just putting that out there. Remember too, this is all of the state's burden, no matter what. All right, beyond a reasonable doubt. And the investigation is also part of the state's case. Therefore, if you have a very big problem with the information that's been given by SLED or how they investigated things, that puts reasonable doubt pretty well on the table to a certain degree. As I said, I don't think it's as egregious as Massachusetts State Police, but for me, from the time this trial started, I was very surprised when this trial started how poorly they did of a job for a wealthy, prominent family. And that should make everyone nervous in that area because you're not probably wealthy or prominent. And if they botch that one that bad, ugh, yikes. Yikes.
You can
No,
always go back if you want to listen to what he said. Like,
no, that's okay.
just to make sure you understand.
Yeah, no,
Yeah.
that's okay.
I mean, we spent like 20 minutes trying to figure out whether it actually happened in Fitz News or not.
Right.
So,
But I mean, he said he's going to look into it. I think there'll be more information come next week regarding that, maybe. But again, I question a lot of and that's not saying everyone in there is corrupt and trying to do bad things but when you have a few people doing what they did, it unfortunately also calls into the work of good, honest people. So I guess what I'm saying regarding anything that SLED does or present, you should be ready to scrutinize it and then see if it holds up. But to each their own opinion. That's just mine. But they were garbage. Okay, it's not as bad as red Solo cups, but it's pretty not great. It's really not great. So
And
anyway.
Fitz News did just release the statement that SLED said on this.
What did it say?
As well.
Oh, like what
It
Angie
says-
just said, or?
Yeah, it says SLED was requested by Allendale Police Chief Jim Evans on April 25th, 2026 to investigate the murder of Frank Alexander. Fired 300 blackout caliber cartridge cases from this homicide were triaged and entered into the National Integrated Ballistics System. As a result of these actions, no investigative leads were developed to any previously entered evidence.
Interesting.
So that would say it's not a match because it doesn't go back to anything.
Interesting. Well,
but
who knows?
But who believes
I mean,
Sled?
the odds of that happening are very slim. All right, like it is. That's true. I'm not going to sit here with, hopium or anything that it's going to show up in another case. The odds would be wild if so, because I mean, somebody is real fucking dumb to go using a gun that was already part of a double murder. But people have done dumber things.
I'm still trying to figure out how the guns disappeared.
Oh,
that's me on
theories
another.
about that.
Yeah, I have tons.
Lots of theories about the guns.
It's in the same place Brian Koberger's knife's at.
Anyway, so yes, we will see more. But thank you, both Angie and Terry. Wasn't one of the Sled guys who testified related to somebody on the fucking jury. His brother was one of the cops at the crime scene.
Yeah.
I don't know why that doesn't get talked about enough. And it was the kid, because I call him a kid because he was in his early 20s. Was he the foreman? Because I kind of feel like he was. But he was very outspoken after the trial, and that his brother was one of the officers responding to the murder scene. It's fucking nuts.
And he should not have been allowed on the jury.
No, not at all. But that's never been brought up in the defense's arguments, so it is what it is. They had every opportunity to bring it up, and they didn't. Becky Hill did a number for all of us. So I feel like he was the foreman. I thought, remembering when they gave interviews after the trial, but I obviously could be very wrong. It's been a long time. But I know which person it is you're talking about. And yes, the officer was his brother. Because I mean, I wasn't on camera when this was happening. I was in a chat. I was in RA's chat, and I'm pretty sure I was like, what do you mean that's your brother? Like, how is that not a conflict at all? That's wild to me. But anyway. I have a long list of issues with this case that have literally nothing to do with Alex's guilt or innocence in this. My
Put them on a
problems lie
spreadsheet.
elsewhere. Girl, you know how many spreadsheets I have? You know I love spreadsheets.
I
Say, hey, you heard about this?
I have never not taken a call from these gentlemen. Love talking to them.
Yes, sir.
Love
Mr.
talking
Harpelian.
to him. I don't believe you, Poot. Oh, this stream is so much quieter than the other. Okay.
I did.
He did. So maybe you ought to pick up the phone and call him.
Hold on.
He did. Say, hey, you heard about this?
I have never not taken a call from these gentlemen. Love talking to them.
Yes, sir, Mr. Harpelian.
I did.
He did. So maybe you ought to pick up the phone and call him.
They need to start drug testing it. In all seriousness, though, I've never.
Oh my God. These guys, I love them. How do you not love them all? They just sit there, they rouse each other all day. It's adorable. He's like, you motherfucker, just sit there and see. I need a drug test. Their passive aggressiveness, I do enjoy.
I mean, look at
you
Creighton's
do?
face right now.
Oh yeah, he's like, motherfuckers.
He's like this motherfucker here. They need a drug test. He's saying I was trying to be nice, but now you're going to be an asshole. I got you.
Yes. So said my hilarious semaphore. I don't know what that word means, Lainey. Oh, Angie had to look up semaphore. Tell us the definition, because I would like to know too, because I don't know what it means. Oh, Amos says, "Oh, you just wait." Oh my. Oh my. Okay.
Question Mr. Waters' integrity, but as a result
Hold
of
on.
this case, I cannot help.
This is why I fucking hate long crime, because their audio fucking sucks. Oh wait.
Well,
Tell us
do
how
you
you
think
really
if
feel.
you go back to court TV, it might sound better since we're past the Skippy part?
Oh, maybe. Here, hold on. Let's 2:10:27. Okay, let me try that, and we'll talk about.
I'm just trying to get you some better audio.
Yeah, this is really bad. Real bad court TV.
And if it wouldn't have been such a long hearing and we didn't go live right after, I would have tried to boost the sound
Yeah.
outside, but there was no time.
Mr. Harpoolian,
Oh, that's so
the
much
rule that they-
better.
So much.
Oh
better.
my gosh, it's beautiful.
I just got this,
Hold on. All right. So I said 210. We'll do 209 just for funsies. All
Wow, you
right.
got to hear
You
that
guys are.
comment much better.
It's not even boosted, and you guys, this is how you're going to notice a big difference. Ready? Hold on. Okay, we don't need Court TV's chat, though not as bad as Law and Crime because you have to be a member to chat in there. All right, listen to this.
from General Counsel at SLED
Unboosted.
that there was a 300 blackout that was used in Allendale. However, it was
Oh.
entered into IBIS and there have been no leads or no matches on that. So that's
Okay.
what I was just informed.
is that going back to,
Going back to the prior motion,
to
yes.
the prior where the blackout was
And I'll find out more, but it does.
said to have been used in another murder in Allendale or somewhere? You understand that, Mr. Griffin?
Oh, thank you, Amy.
Okay. You know,
I see them now.
sometimes a real novel idea is to pick up the phone and call each other and talk. That's what we used to do when we were younger. Just call and ask if you've got a question. And then if you have a problem with it, I'm more than happy to settle it for you. I hate that we have to do this in court.
Your Honor, you know, and this is no insult to all of my lawyer friends who I adore and think is amazing, but you know that ego hubris plays a very big role in lawyers' lives. I mean, it does. Not for all of them, but for most of them. So it's so funny that she still says that. I'm still gonna laugh about it. Like, oh, that's cute. You're cute, and I adore you. It's a form of communication involving flags. I love flags, Lainey. Maybe I'll do a Llama Learns about flags. Flags are very interesting. Anyway, sorry.
I do. It's easier just to, now we can email you if you don't want to talk to each other. You can just email each other.
Yeah.
Say, hey,
Yeah,
you
Llama,
heard about
just email.
this?
Hey, girl.
I've never not taken a call from these gentlemen. Love talking.
Can you
Yes, sir,
imagine
Mr.
Pooh
Harpoolian.
emailing Creighton, hey girl, hey. I was just looking over this thing and like I don't agree, but like, do you want to go to like Top Golf or something and talk about it over some beers and nachos? It's a Laura Owens reference. Sorry.
I would like some nachos.
He loves talking to me.
I will take
He
nachos.
did. So maybe you ought to pick up the phone and call
Oh,
him.
I got hibachi in my fridge.
In all seriousness, I have never questioned Mr. Waters' integrity. But as a result of this case, I cannot help but question the SLED lab integrity and the SLED agency.
I understand, but
Yes. Same.
Fair.
Same, Pooh. Same, me too. Me too, girl. Let me email him. Hey, girl. Hey, I agree with you. Poots. No, one, that is a very nice thing to say about Creighton. And I agree. Like, I think Creighton does seem like a man who is trying to do the right thing, unlike a few other new prosecutors we've seen in some other cases where they just got paid $500,000 to do nothing. I do think that, though I do also think that he's a little naive and overzealous, but that's okay. Who isn't? I am. But that's a very nice thing of him to say. And again,
say.
my issues are with SLED, which then though Mr. Waters here relies on that SLED information, and that is kind of problematic because integrity means doing the right thing, even if everybody is against you and doing that. That's what the real definition of integrity is. You stand by your decision no matter what other people decide or have to say about you. I know a lot of people don't understand the meaning of that word, but use it all the time. But that's what that means. That I sometimes feel like I think he was a good person for the state to put on the case. Because he is from the state attorney general's office. He is not like the local prosecutor from that county. Because that was, oh my God, what was his name? His name was so funny. Duffy Stone, was that his name? I think so. Who was the prosecutor of Colton County. And so now they have the state stepping in. But like, I do have some questions. Creighton, is that what I keep saying? I'm sorry. But I mean, I do like him as a lawyer. I don't have very many negative things to say about him. But I got a fuck ton to say about SLED. And I think the defense is right in questioning everything that they do.
Agreed.
See how easy it was for him to make a phone call and turn around and give Mr. Griffin an answer.
So, okay, and the answer is SLED entered it into some database and got no matches. Did they pull the shell casings from the Murdaugh trial and compare them to the shell casings to this? And that's not what I heard. That's not what I heard. And remember now, and if you've read the sanctions motion, they misled Mr. Waters about the blood spatter for months.
Sure did.
Months.
Sure did, sir.
And, you know, and misled us and misled an expert. That was the SLED lab. And when we talk about DNA in a little while, that's the context in which we are approaching this case, because we were lied to. The grand jury was lied to by SLED, and he was lied to. So I appreciate the fact he calls, and I was a prosecutor for a while. Trust, but verify when dealing with police officers.
Well, I'm sure he'd be happy to do that for you.
I think I have personally
the
been
judge said
involved
it.
in the indictment of 7 sheriffs
judge
and
said
multiple
it.
police officers. If I had any evidence anybody intentionally fabricated evidence, I don't play that. There is a difference between, Mr. Hartwood, excuse me.
Let him finish. Let him
There is a
finish.
I'll play that. Crayon. Love it. I'll play
It's getting
that, Your
spicy.
Honor. No, he does
It's
have
like,
that
homie,
track
don't
record.
play that.
Yeah.
Homie, don't play that.
I'll play that.
Right?
Okay. I have, in fact, charged several sheriffs, which is true. And again, I do think it says a lot about Creighton. I don't have very many negative things to actually say about him. But also, this is kind of possibly one of his biggest cases of his life. There's also perhaps some reasons to stick his head in the sand. However, I do believe Creighton when he said earlier regarding this that if I knew anything, I would be calling you guys first and then I would call the judge. I actually do believe him when he says that. Maybe he's just that impeccable of an attorney, but I do get that his character and his integrity are very important for him. But he can also put up blinders very easily. It's an issue with many investigators as well as lawyers. What are they? Tunnel vision, right? Like,
Tunnel
well, I
vision.
got this theory and all of this. It doesn't really matter if this adds up. So I do think that's a factor. And you have the Attorney General of South Carolina breathing down your fucking neck every day. So anyway. I love them. I love them all. I love their weird cross the aisle relationships that they have. I love it. I don't play that game. Creighton. Oh, I love them.
difference between where mistakes or the 2 ships passed in the night and intentional fabrication. That might be their characterization, but that's not what the evidence reveals. And obviously that'll be something that we'll discuss later on. But I will obviously look into that more. But IBAN is the database where you put guns in, kind of like the fingerprint database, and then it gives you hits whether it shows.
He is also a lawyer where, you know, you got to look further into the words that they say because, you know, it hasn't come back from anything in the database can also mean, well, we haven't even put it in the database. So therefore we haven't got anything back, but we're just going to leave out that part. I'm not saying that is what happened or that's what he said. That was just an example, by the way. Right. It's so funny.
Up with other crimes.
Would it show if you put in
He does.
the casings or the markings from the case?
I'm going to find out more and double check, and we're going to run this down. But again, there is no, from what I was just told by SLED, that there are no leads or hits on that blackout that was used in the Allendale shooting. I promise you, though, that I'm going to find out more.
And if you got any other
I do
questions,
believe him in that.
and just email him, he'll check it out for you.
Sure will, Your Honor.
And I mean, if you want some kind of verification, I'm sure he won't have a problem giving it to you.
As long as, again, a phone call between him and an agent who has a stake in maintaining his conviction is okay for him. It's not for us. We want to see if they submitted it, what was the result? Is there a written result?
Fair.
And what I'm trying to tell you, Mr. Harpooling, is just ask him. I think he will give you just that.
Okay.
And instead of just throwing all these questions at him at one time, just send him an email. And if you want something verified, tell him, do you have a report to that? I understand you being distrustful. I got it. But if he doesn't know what you want, he can't give it to you.
We'll be explicit. Thank you, Your Honor.
Yeah.
All right, let's go back now. I'm sorry
Exactly.
about that, Mr. Waters. Let's go back to the defendant's prior testimony in his retrial.
Sure. And just to start out, he said at 10:23, I said new case. And I think he's parsing my words a little closely when I'm talking about, Your Honor, reconsideration of a ruling. It's still the same indictment. It's still the same testimony that's under oath. It's still the same evidence that's going to be presented. It is the same case.
I forgot what we were arguing
While
about.
Tucker is a bifurcated proceeding, it still was a brand new evidentiary proceeding de novo in that particular case. So I think Tucker is still applicable. Ultimately, again, I think that the appropriate solution is going to depend on your Honor's parameters as we get to that financial evidence. But ultimately, the Supreme Court said, we agree with the state that under the facts and circumstances in existence in the first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404, and went on to say, we hold the trial court acted within its discretion in admitting some evidence of his financial crimes. So that issue was in play. So it is not going to give them sort of a complete out, unlike Harrison, which I believe was a completely false confession that was played on TV and for everybody to see prior to trial. The financial crimes, according to the Supreme Court, were appropriately in play. The only issue was to an extent which Your Honor and the parties can clearly circumscribe that based on Your Honor's ultimate ruling as to those issues.
Okay.
Okay.
All right. I did.
So as quickly as he talked there, which was very kind of hard to keep up because he just he was talking about how the Supreme Court, was like fine with the financial stuff, even though Creighton, please listen to what they said and bring it down some. But so he is saying he only wants to use Murdaugh's testimony regarding the financial stuff. Am I understanding what he said correctly? Or okay, you guys don't know either. Okay.
I don't
There's a
know
lot.
what he's saying. He talks out of both sides of his, and it didn't help them interrupting to talk about something else to come right back.
Yeah.
So there was no linear flow of thought there.
Agreed.
This is fun, even during hearings. Absolutely. Absolutely. She does talk to them like they're kids. But
does.
but that is the kind of judge we need with both sides. I mean, I thought Judge Newman also did a great job as a judge. I do think that, though he was a little bit more relaxed and kind of like, we'll go with the flow sort of thing. And I do appreciate her,
This is her
just
courtroom.
being, like commanding, but also wanting to hear sides out. And Newman did that as well. But I do appreciate her like, no, we're going to do this now and this and this and this. I'll give you time to talk, but now we're done. And you really do need that with both sides. As you guys can probably tell, if you did not watch the first trial, this is exactly what you are going to see for 6 weeks. Exactly. Every day. They are not going to change overnight. Let me tell you what. There will be lots of passive aggressive. He did have an awesome, relaxing chair. He did. He had a great judge chair.
Mr. Barber?
Your Honor, just very briefly, we anticipated the argument Mr. Waters just made on page 9 of our response brief. It is under Harrison, it is the state's burden to show that its action did not induce the testimony. So this idea that you can parse out that they could have introduced some unknown quantum of financial evidence, we don't know exactly what would have been admissible or not, and maybe that quantum would have been admissible and therefore not triggered Harrison or Simmons. It's the state's burden to say that what they introduced did not compel his testimony, and simply saying that we perhaps could have introduced something is not sufficient to meet that burden.
Okay. All right.
Okay.
Well, I've read the case law. I've read the statute in this case. And I think it's pretty clear. A criminal defendant's testimony from a first trial is admissible at a retrial in the same case. And that is from 1911-50. The testimony of a defendant in a criminal case shall not afterwards be used against the defendant in any other criminal case. That is, our Supreme Court interpreted 1911-50 narrowly, and it limited its protection to the use in a different criminal case, not the same case. So I believe that his testimony may come in under 804. I've got B1.
Oh, that's
A1,
interesting.
I think it's B1, or for impeachment purposes. The court does not find the defendant's argument prevailing. I think you rely heavily on Harrison versus U.S., where the defendant was forced to testify as a result of the prosecution using illegally obtained confessions by the defendant. Here, the defense argues that the evidentiary decision of the trial judge to allow evidence of the financial crimes coerced the defendant into testifying.
Ooh.
However, I went and looked at the ruling again from our Supreme Court. The court ruled that the evidence of the financial crimes in this case is admissible in the new trial, so long as it is probative to the murders. Accordingly, this is inherently different as an evidentiary issue versus illegal conduct. Now, with all that said, I don't know, Mr. Harpoolian or Mr. Barber, what the state intends to introduce as in their case in chief. I don't know what financial crimes are going to be allowed in and what's not going to be allowed in. If it's not allowed in, certainly that testimony related to it.
By the way, so she also said that the Supreme Court of South Carolina did basically tell the state, hey, when it comes to this financial crime stuff, let's make sure it's important and none of these, let's get in our fifis about things to make him look like the worst human being ever. Which, don't get me wrong, let me make this perfectly clear. Alex Murdaugh is a piece of shit. Okay, he sucks all the way around. He does. But honestly, and this was my opinion when the trial was happening too, was that they spent way too much time in talking about financials to make his character look absolutely appalling. And the Supreme Court of South Carolina said the same, basically, during the appellate hearing that we listened to. So they did hand that down. So yay for us. We may not have to hear 2 freaking weeks of financial crimes. And he pled guilty to them. He had not previously. So do we need them as much? Probably not. Maybe like 3-4 days max, but we'll see.
I mean, it's all subject to rules of evidence. If it's not relevant, it's not in your case in chief, then that prior testimony is not coming in. Obviously, I think you agree with that.
Yes, ma'am.
But I do think, when you testify in a case, there's consequences. Testifying and not testifying, there's consequences. You don't get to tell your story, but then you're also at the peril of cross-examination, and it's sworn testimony. So I'm going to allow it in, subject to what is being testified to in the trial.
Okay.
Okay?
Your Honor, for the record, we would respectfully
Disagree?
disagree. Are you going to issue a formal written order? Or is
Not
that
surprising.
ruling?
That was going to be my ruling.
Fine.
It's for appellate
Um,
Of course, we
purposes.
would renew it when it becomes relevant, but I just want to make sure we're not perceived to waive an objection to that.
Sure, I'm not going to let you waive any objections. You can take objections to all my rulings at the end if you'd like, and we'll put it on, it'll be on the record. We'll revisit it again at trial.
Thank you, Your Honor.
So the state can only bring Alex's previous testimony if and when it gets brought up during the trial. If the door gets opened by the state, and it does sound like mostly financial crime stuff, which is weird, but I guess, I don't know, maybe they might take it to the Supreme Court. I don't know. I think it's an interesting clarification that might need to be made, but the judge says it's perfectly clear. So she's allowing it, but if and when it comes up, it'll be discussed again. It can't just, this is kind of similar to the polygraph, right? You can't just go yelling polygraph in front of the jury. So, did you have something to say, Terry? I'm sorry.
No, it just makes me think that if somebody lied to the grand jury, you should have just had it dismissed and made them go through the process of getting a new indictment.
This is, yes.
If
this has
this
been one of my
is right,
arguments.
because then it would have been a brand new criminal case then. So
Yeah, I'm still very confused about
Yeah,
how
I
this
could
is
be-
considered different, but also the same. But the
Yeah.
defense, they did a fairly good argument, but they're not really combating anything at this moment.
Yeah.
So I think it's definitely something that's going to be brought up when we are in the trial, because the state wants this to get in real bad. So just prepare for a lot of sidebars regarding this would be my prediction. It was like two full separate trials in the first one. He just needed some of it for possible motive. Yeah, because he hadn't even pled guilty to the financial crimes, which also is confusing to me. But yeah, I think there's going to be, I do think that this judge, because Judge Newman, full reign, they were allowed to bring whatever they wanted
Whatever.
to in, which I thought was a problem. And so did the Supreme Court. But that is not why he got a new trial. Let's clarify that. That is not why he got a new trial. But I think that this judge, because she's read what the Supreme Court of South Carolina said, is going to take that into consideration, or she should anyway, in her future rulings to avoid appellate issues again in the future. Just my thoughts as a girl who just likes watching trials.
All right. Now,
Whew, I need to heat up some food. Let me tell you what, you guys.
let me go to the state's motion as to the privilege review of the defendant's phone and the motion to compel defense to turn over the digital evidence.
Thank you, Your Honor, and may it please the court. Just to kind of set the table a little bit, and I know we have done so in our motion, the night of the murders, Mr. Murdaugh, although he was referring to his phone saying, see, hey, I called Maggie, see, I went, at that time, the phone was not downloaded. It was not until 3 days later on June the 10th that actually a 14th Circuit investigator, who's now a SLED agent, did an advanced logical download of that phone, of course. And so there was that. And then later on, after the side of the road happened, or I think it was maybe in August, excuse me, then his phone was seized again, and there was a download done by SLED at that point. Okay. Obviously, he's a lawyer, and like any case where we have a phone, but particularly one where there's a lawyer involved, we had in both instances that the first one was done prior to the Attorney General's direct involvement, but there was a privilege review done in order to protect the rights of the defendant, right? And so ultimately, the investigators only and the prosecutors only received the redacted parts of that phone, whereas the defense always got the unredacted copies with everything on it.
Right.
Same thing happened with the SLED download. It was privilege privilege reviewed by a taint team at SLED, and then the investigators and prosecutors only got the redacted portion, of which thousands of messages were excluded. The defense got the unredacted portions as well. The first part of this motion is, and I believe they consent, so I'm not going to talk too long about that, is that since that time, of course, there's been a number of developments, and we painted a broad brush because, frankly, Your Honor, the last thing in the world I want to do is to become privy to some communication I'm not supposed to. In fact, we did go through great lengths to ensure that doesn't happen. But we've since had, I think, 12 attorney-client privilege waivers from former clients of his. He, of course, has pled guilty to conspiracy with another lawyer and a banker. And so those things, I think, would require a reassessment of that privilege because of either attorney-client fraud or these waivers. And so we proposed to do that with the taint team. And then we also proposed, and I think they agree to this, that we would identify new community.
Oh, so this is just some funsy side news as I've been like collecting the documents for all these. One of the folders I named in our drive for him and the other lawyer and banker, I named it the Murdaugh Besties Crime Club because that's basically what it was. Lafayette and what's the other guy's name? Anyway, they all suck.
Communications to be released to the prosecution and investigative team, but give them a chance to review those without us seeing them and make any sort of issue they want. And if there is an issue, we'll bring it to the court.
Are these waivers, are they affidavits or what are they? Or
yes, during the course of the financial investigation, many of the clients executed written waiver attorney.
Okay, so there's a written waiver from these clients.
That's correct. Yes, ma'am, Your Honor.
Okay. Any objection to that being sent back to OGC and reevaluated?
No, Your Honor, we don't object to the process that was described in Mr. Waters' motion, where the taint team would bring to our attention and the court's attention any potentially privileged stuff before the prosecution receives it.
Okay.
All right. The next part of this is that early on, of course, we were told that there was a defense extraction that had been done. We've now, since their response, they've said that it's a logical extraction as opposed to a full file extraction. The thing about phones is that they really represent a snapshot in time, right? They are, I hate to use the word breathing, but they're sort of living items where the evidence on them can change through manipulation of the phone and just how they operate from one day to the next. And so ultimately the defense had that extraction. We never asked for it at the prior trial. They, of course, never used it and didn't call, the examiner who did that. And so we filed this motion to ask for it. I think, for the sake of right now, I think the defense has raised these constitutional objections while we have our arguments where we believe these things can be authenticated other ways and that there would not be an act of production Fifth Amendment violation. At this point in time, I'm going to state that that I think a better solution might be, because under Rule 5, of course, their disclosure obligations require them to disclose those if they plan to use them in their case in chief at trial. The problem that, as I see it, and why we ask for this, is that those things can't really be easily assessed, overnight, right? Because they are very large. And so what I would suggest and request of the court is that, and I understand that during trial things can change, but that there be, and ultimately there a scheduling order whereby at least it's this issue they can declare that intent, or at least give this information if they're going to use it to the state in a reasonable enough time prior to trial, so that we're not broken down with a jury on ice, so that we can assess a phone dump of 256 gig phone.
All right, so you agree that they don't have to turn it over to you unless they're going to use it in their case in chief.
I think,
unless it's provided that it's not protected by attorney-client privilege. It's not protected under the Fifth Amendment.
well, I think what I'm saying is we raised arguments as to why the Fifth Amendment would not apply in this case, why attorney-client privilege and work product would not apply in this case. And again, we're not asking for the opinions of the examiner or the impressions of that. But what I am saying is at this point in time, given their consent on the privilege review, am not willing to, push us into this particular thorny issue at this time, as long as maybe we have a remedy that if they are going to use it, it is provided to us in
You
sufficient
want
time.
notice.
That's correct. Yes, ma'am. I think that's a fair resolution.
Any problem in giving him notice if you're planning on using anything from this phone in your case?
No, Your Honor, we didn't use anything the first trial because the full extraction the state did less than a month later has that and more. So I don't anticipate that.
Do you think you just brought this up for something to say?
I will.
I mean, I have no issue with giving notice if we change our mind.
Because like,
Well, let me ask you this. I set the trial for April the 5th and I intend to stick by it. How about if you're going to use anything, can you turn it over to him by March 1st? That'll give you like 30 days to have any rebuttal or expert witness or any objection to that?
If Your Honor if this is only about the Chip Johnson cell phone extraction that we're talking about, if that's what's subject to that notice requirement, there's no objection.
Thank you, Your Honor. That's absolutely acceptable. The only other thing I would just ask, and I'm sure they would do that anyway, is that as we work out these issues, that any extraction be preserved during the course.
March 1st deadline.
okay.
Okay,
I
March
think that
1st.
takes care of that issue, Your Honor.
Perfect. But we're just going right through these.
I must say they are getting a lot of work done in one hearing. Usually it's like one hearing for like one motion and
All
that's
right,
it.
let's talk about the
impressive.
DNA.
DNA.
This is the defendant's motion. This was brought up at the status conference. The way I left it was to find out if there was any a viable sample to test. And I want to make sure I got this right. It looks like there was really two samples, a sample the state tested, and there's some leftover, for a lack of a better word, leftover stuff. I don't know that it contains all DNA in it, but leftover. Then there's a reserve DNA sample. So I want to make sure, because there's two. Am I correct in saying that?
Yes,
ma'am.
Angie.
So,
Yes.
these are, of course, the fingernail clippings.
Right.
And so you got the clippings in the package. As I understand it, a representative sample was prepared and tested. And from that, there's 47 microliters of extract remaining. And testing can proceed from that. There is also, though, the reserve portion of that sample itself that has yet to be processed, which
The same sample.
the same set of
same-
fingernail clippings.
Right.
But it's kind of like a shirt, or pants. You get the pants, you do cuttings from it. You don't cut the entire thing. And so there's still.
Bringing up a shirt, Creighton, is a very interesting comparison, considering how that shirt he was wearing that night really kind of fucked you. But okay, sure.
So I was getting ready to say, didn't the shirt kind of get him last time?
It sure did. It sure did. It was not great. Sled said there was like fine blood spatter on it from, murder. And it turns out none of it tested for human blood at all. So it was not great. Interesting choice he brings up there, but okay.
Parts of the pants that could potentially be cut and tested and that sort of thing. So it's
Right.
very similar. So we have extract and we also have the unprocessed sample. And so what we have, and we've had a discussion with their expert, and he said, that's barely even a mixture.
But he's talking about the leftover stuff though, right?
He's talking about the remaining extract. Correct.
The leftovers.
And we're willing to let them test that extract, even though he says it.
The leftovers.
Correct. But what we would want is at least some recognition to this.
I was
Dama, you're
saying,
muted.
I know, I'm sorry because I was eating. I was going to say, do we need to say leftovers 100 times? Why do we keep
It's
the
the leftovers.
leftovers,
We
though? Is it?
do.
It's the
It's the
it's the name
leftovers.
of the trial. This is the
Thank you,
leftovers.
Liz.
Hi, Liz. Long time no see. Hope you're doing well. Thank you.
You're the bestest.
The leftovers, though. The leftovers. Speaking of
But it's
leftovers,
the
I'm eating
leftovers. Are you eating
leftover
leftovers?
hibachi. Yes, I am from last night. I'm starving. I
It's
haven't
because
ate.
you said you had
Okay.
some hibachi leftovers. So
Mhm.
Leftovers.
The leftovers, though. The leftovers. We'll have to add
You know
leftovers.
what
the
we're
bingo
doing for
card.
dinner?
Leftovers? The leftovers, though. Is it the leftovers?
The
Sorry.
leftovers.
This gets me. This is hilarious. Hi, babes. Okay.
Did you tell him there's some
Because he said it's
leftovers
gonna
in
be
there?
There's some
consumed, that
leftovers.
That's gonna be gone. You know, we have preservation of evidence requirements and all the rest of it.
Are we still talking about the leftover stuff?
And then on the
The leftovers?
unprocessed, what we have said is that we will process and quantify that and then stop, okay? And at that point, we will know the quantification. We will also know the likelihood, which is highly likely, that there will be leftovers from that, from which the defense could have that as well. And so we're willing to do that in conjunction with and in discussion with the defense and their expert, which is an extremely fair way that all parties have access to all.
I read your motion. I was just, Mr. Griffin, you arguing this?
Yes, Your Honor.
I just wanted to make sure that they're willing to give you the leftover stuff. That's how when I read it, I'm like, okay, there's 2 DNA samples are all from the fingernails. They want to give you the leftover stuff, but then they want to go and do a quantitative test on the unprocessed sample.
Right.
And then decide what to do with it. If maybe y'all could share it.
Right.
Or do I have to give it all to you?
So that, and in that conversation, we asked, to what end do you plan to use it? And we've gotten no answer.
Okay, well, I'm gonna get to that in just a minute.
And so our expert says the whole quantitative analysis, it does consume some minute portion. So they would be consuming the minute portion. At Othram, they do the exact same thing. If they got, and to be clear, Othram has in the past, and I'm sure will in the future, they receive DNA samples from SLED. They're in chain of custody. They have routinely test.
From our lab?
Yes.
So there is a way, because that's one of my questions.
And so, and they're
maintain a chain of custody.
absolutely certified to do that. They do that with law enforcement around the country. And Your Honor, I've just watched recently the Idaho murder documentary
I
on.
haven't watched it.
But Othram is right there.
So have we? We just watched it and reviewed it last week, right, Terry?
we did. I was like, okay, this is like crazy.
You can find Terry and I's responses from last week's documentary watch on the new Idaho 4 documentary that came out. I also think that it's just very funny. She was almost like, spoilers. Like, I haven't watched it yet. Okay. I don't know exactly what you're referring to, but I'm gonna. Do you think that's on the judge's Netflix queue?
It could be. All I know is I'm sad that I've heard leftover more than you don't know what you don't know, and that we're happy and willing. What is happening here?
Have we heard either of those? I don't think so.
They said we're willing, but he didn't say happy and willing.
Okay. Wow.
So no, we haven't.
I do love the judge's raspy voice as well. I love it.
I just
So
love
leftovers
everything
and
about this judge.
I do too. I do too. There's Murdaugh still sitting at the turtle. Just beady little eyes.
I think he looks not troubled enough. I'm going to just be honest.
He always has looked that way, though.
I know, but I don't want him looking so put together coming from prison, I guess.
I understand the sentiment, but it does not surprise
I
me
want it to
because
seem
they're
like
really
he's having a rough time in there, and he's not.
No, I mean,
He hadn't
listen,
lost
I'll be
any
honest.
weight.
Most of the prisons in this country do not work how the majority of people want to believe that they do. Okay, at
I
all.
know, but like in
Are there
Texas,
some
our
tough ones?
prisons,
Yes. But
they don't even have AC. And like it's 105 today. They don't have
so
AC.
it's a weird thing to brag about, but yes.
But
Um, yeah, we think that's probably not appropriate. Because
no, I don't think it should be that way, but there should be, he should look like he's had some hardship,
well,
in
not
my
as true.
opinion.
Mm-hmm. He is. Now remember though,
Yeah.
yes, he is a felon for federal
Yes.
crimes, both state and federal level.
Federal.
That's why he will
Mhm.
not be getting out of prison anytime soon. Even if he's found not guilty for these murders, he will not be
Correct.
getting out anytime soon.
How old is he? I don't
Oh my
remember.
gosh. Oh, I don't remember either. Late
I have to look it up.
50s,
I was like,
I
I thought he was
feel.
my age or a couple of years older.
He's in his 50s, I do believe, but I don't recall.
Now, I get that amiss, but here, concrete walls and no AC, we have people
Mhm.
drop dead from heat exhaustion and stuff.
Yeah.
So that is not okay.
Mm-mm.
So I don't
Remember,
agree that it's okay.
not everyone is in prison for like murder and
Right.
whatnot. So
Okay,
58.
so
Thank
he,
you. 57,
okay,
58. Thank you guys.
okay, so he's around my age.
I was gonna say, I thought they were in their
I look
50s.
better than he does for our
Oh
age.
yeah,
I'm going to
girl.
just go on record and say
Absolutely.
that.
Absolutely.
I mean, they are the lab who does this, and it's
Well, that was going to be my next question to you. I mean, are they an accredited facility?
100%.
You know, I just can't be handing over DNA to somebody who's not
They,
accredited and they know what they're doing.
and when we were on the phone with him, and he says, we work with SLAD Lab, and they receive samples from them. They do that work. They do it work, on behalf of cold cases around the country, and they do some work on behalf of the Innocence Project. And so they are certified, and there's been no dispute about that. And what Dr. Middleman says is, what's their scientific purpose for doing quantitative analysis? What are they going to do next? Because we'll do quantitative analysis and we'll share that with them. And then we'll give everything back to them when we're done.
And we're talking about the unprocessed.
Both. We're talking about both. So there's, leftover extraction that was processed.
Right.
And we want to test that. And then we want to have the unprocessed and to do a quantitative analysis and then include that in the testing. I mean, and the question is, if you're doing STR analysis of the same DNA sample, why do you think anything different is going to happen? I mean,
Well, let me ask you this. If Othram is willing to process it.
Yeah, absolutely. Quantitative analysis and give it before they do it the next step. I mean, we'll do that and we'll share it with them before we do anything further.
Is there, can they do the other test, the STR testing?
I'm confident they do STR testing
They can do the STR and the SNP.
and the SNP testing. Yes, they can.
And that's what,
And we also,
and let me make sure I got this right, because the SNP is really different from the STR. Those results are based and compared against like CODIS. known samples.
STR is.
The STR. The SNP is a bigger, I want to say a bigger database because it's
Well,
genetic. So like all the people who
23andMe.
23andMe and all the other.
If you or I or anybody in the
Don't
courtroom
give your
gets a
DNA to
sample,
people.
submits it to 23andMe, that's a SNP analysis, and that uses a whole lot more of the genome, a whole lot more of the DNA.
Not that it's going to give you the one individual, but what it might give you, and no guarantees, is a family tree that you might can trace back. Is that right?
Absolutely.
Okay.
And in addition, what Othram can do, so we do know that this sample, this is male, the unknown male. So there's Y chromosome in that sample. Othram can test and analyze that Y chromosome, and depending on how much it is, they can go back to origin. Like, is it an Asian? Is it a white male? Is it, I mean, and they're able to do that. And so they have so much more capacity than the SLED lab. And it's expensive, and we're wasting time, and we want to pay for it.
They have
and
all
we
that
want to
because
get
they're
on
a
with it.
private
I
company.
already told you I'd let you
The
pay for
reason
it.
why the
That's a given.
government can't use it.
That's going to happen.
This is their
How long
workaround.
is it going to take them to do it?
Well, we put in our supplemental memo that it would take 60 to 90 days. I mean, honestly, he says, we'll make it a priority. We can do it in 60 days. And I said, well, how about, don't say that. Let me say 90 days. But what we'd like to do is have it all at one time so we can do it all at one time.
I understand that. But let me ask you this. What does your expert say about having something left over that they can give and share with the state? Do they think if they had it all, is there something going to be left over to give to the state? So they want to do their STR test again.
So we would know that, Your Honor, after the quantitative analysis that we would like to author them to do. And then we would like to share that with the SLED lab. There's no reason, because they're doing the same thing. And Othram says, why?
Well, if you're going to share the STR results, you're going to share the SNP results.
Well, Your Honor, I didn't say I was going to share any results. I mean, I said they could do that. The rule doesn't require us to share results from scientific analysis unless we intend to use it. But
Right, I agree with you on that. But I'm asking if they wanted you volunteering to do the STR, which they want to do.
They've already done it.
well, I'm not sure they want to do that, Your Honor. I haven't heard that. I've said, to what end do you want to use this after doing a quantitative analysis?
Yeah.
Well, what are you going to do with it?
The same test again?
You're going to do the same thing twice?
Yeah.
You expect a
Done it.
different result? I promise you they're not going to do
That's
that. because
insanity.
That would pretty much cause their lab to be, the credibility to be challenged at that lab. They do the same test, get two different results.
He's not wrong.
I mean, we're talking about the same sample, Your Honor. We're not, and they know the mixture. And they tell us the mixture is 99% Maggie Murdaugh and 1% unknown male. So, I mean, they've got that information. But we'll do the quantitative analysis. We'll come back and, share that with them. And then, if they, I don't know that, we want to do STR.
But you can't tell me that you can't share it with them because you don't know yet, because we don't know how much is there to share.
But I thought there was two. Okay.
Right. And so what I'm saying is we do the quantitative analysis, then we would know, have an idea of, if we're going to use it all or not. I mean, they didn't use it all when they took their sample. And so there's extract. There will be extract that can be sent back. And Othram will work off the extract that they mix it with a mixture. They put it in their DNA, holding devices, and Othram will do the same thing.
Okay.
All right, let me hear from you, Mr. Waters.
Thank you, Your Honor. This is, first of all, the first time that I've heard that they said they would share. In fact, what I was told expressly was that they would not share anything to start out with. But
Well, I don't think they want to share the results with you.
all right.
Okay?
Yeah.
Is what they're saying. However, if they want to do the STR, I think I'd make them share the results with you on the STR. They want to do the SNP for themselves, and they don't have to share it with you under the rules of discovery.
Okay. Well, and so first of all, I was informed.
Unless they use it in their case in chief.
Right. And hopefully with sufficient notice. But my understanding is, and I was just, texted this, is that they are not accredited in STR. They are accredited in the SNP testing.
Okay.
But to explain what this is, and so it's kind of, there's a bag full, as I understand it, and this was recently explained to me, there's a bag full of, the little fingernail clippings, okay? And they pick out a representative sample and put it in a tube and shake it up, and that's from what's generated. And then you have the remaining portions of that item that are in that bag. And so that's what needs to be processed. So it's not a question of necessarily doing the same thing over. It would be like taking a different cutting from an item of clothing.
Right. You might have a little bit of DNA over here, and then you might have it on the other side of your fingernail, a little bit more.
Correct. And so there is the chance that there could be something that comes out differently. And so SLED can turn around this quant in a couple of weeks. And again, there's nothing to indicate, and this is what I suggested, is that we would do the quantification and the processing and stop. Okay. We're not going to proceed forward with STR on it without calling the defense and letting them interface with their expert. And at that point, we'll know, which is probably likely, that there'll be enough for SLED to do STR or YSTR, and there'll be enough extract for them to do what they want. But their own expert has indicated with the quantification for the leftovers that it's 3 alleles. He's like, that's hardly even a mixture. It's over 99-1. He's like,
that's the leftover.
Right. That's true. But he says there's
not the unprocessed. They want it all, so maybe they can get something to test.
And I am happy to facilitate that, but we have to have a fair access to that second half as well. And that's what we're offering to do, and to do that with the defense. So again, SLED has the burden of proof. SLED, or the state has the burden of proof. SLED has custody.
You can't tell me either that if you prepare the reserve sample, that there's going to be enough for them to do the SNP test.
What I can tell you is that we will do the processing in quant, and that will stop. And that's when we will know. And then we can discuss that. Is there going to be enough just for STR? Is there going to be enough for one? If that's the case, then we can talk about that issue. Or what's more likely is there's enough for column A and enough for column B. But there's going to be no prejudice to that if SLED does the processing in the quant. And that's what I proposed to them, which is fair to both sides. And we will stop and have a conversation with them before proceeding, so that there's no prejudice to either side.
I'm very confused.
I'm not agreeing with him.
Let me.
They've had 5 years, and we're on appeal for a while, but from 21 to 23.
Just let the defense do what they want.
They did all the testing they wanted to do.
Welcome back,
and now
Buff.
we've come up and
Sorry.
asked to test it, and guess what? Oh, we want to test it. Well, they've already tested it, and now because we asked to test it, they want to take control of our testing.
Yeah. Yes.
I mean,
that's
it's
true.
that's not fair.
Life is not
I
fair.
know.
Hold on, let me pause this real
An
quick. Sorry, I'm
STR
outside.
test
Hold on.
from the same sample.
When I was watching this part of the trial, I was making some food listening to him, and he went, "But that's not fair." And I was like, "Is that a legal argument?" Because
I know.
No.
That's what my kids used to say. But Mom, that's
laughed
not fair.
I laughed so hard.
Fair is fair for anybody that loves the 80s movie, The Legend of Billie Jean, which is one of my all-time favorite movies. Fair is fair. That's so funny.
Somebody explain to me why they don't let the defense just do it.
Because they're trying to control the evidence, the state is, and they're worried that something else is going to pop up and make them look really bad. Will it? Who knows? We don't know that, right? We don't know that's what's going to happen, but it does not surprise me.
Yeah, well, because they don't want to be questioned on their own lab techniques, so it will be challenged.
Mhm.
and they don't but I don't understand. This is the part I don't get. In every trial, they do say, well, you have the opportunity to test the evidence
Mhm.
yourself.
Self.
So, the defense always has the opportunity to test the evidence with their own money.
Right.
Why
So
are
what's the
we
issue?
arguing this?
Well, and
Like,
it's my
why?
understanding that the crime lab can't do any different kind of tests than what they've already done,
They can only do the STR, right? They can't do the
right?
SNP.
Well, because they don't want to find out that there was something they didn't know.
I
Oh,
mean,
Right.
I
dang, we
agree.
got it wrong.
I agree. I
And
do
this
think that
test could
Jim,
use up what's left, and there would be nothing to double check with.
but I thought they were
Well,
leftovers. I'm so confused between what is like which they're
Well,
trying
the
to give them.
leftovers
Or,
it's the
has
leftovers.
1%, but the leftovers has the 1% male. They're wanting that reserve too, to see maybe if there's more in the reserve that hasn't been tested, is what I understood.
okay. So just so we're clear, because I am very confused.
I think they're
So
wanting it all.
there is one group of DNA, right? That shows there was like one male with 3 alleles, or
That's the
whatever
leftover
the
that they did the
argument was
STR
Monday.
on first. Yes.
But then there's another set of leftover
There's a
that
reserve
nothing's
that hasn't
happened,
been tested. Right.
and the defense wants that one. Correct?
They want both.
Mm-hmm.
They want both.
They want both.
Well, I don't know about that, but stay hydrated. Don't you worry, Liz. I would never let you down. Thank you for the jewels.
Just excited. I'm on my third glass of
hydrated.
sparkling water.
But I do think
I need to start drinking wine.
right. I do think that his argument is very fair. They've had 5 years to do all of this,
I
and they
agree.
didn't bother. Now, I'm going to say this on the other side is that the defense has also had several years to test this. Now, they don't have the state funds. They're willing to pay for it, but have they always been able to pay for it? Just now, I have questions on both sides here. My personal opinion is fucking let them test it. But who cares,
It's a
right?
new
If you
trial,
don't,
with
right?
Buffy, though. I
yeah,
thought they were entitled to it. I don't know why it's
I
a
would think so.
discussion. I thought they were entitled to it.
Well, Creighton's so
But
happy to do it.
he's
Creighton,
happy, but not willing.
But he doesn't want. He wants them to share the results,
Right.
and they don't want to share the results. They said
Yeah.
no. We're
And
not
they
gonna
don't
share
have
our
to,
results.
according to discovery rules, have to share
that
the
is true.
results unless they're going to use it.
Unless they're going to use it, which obviously, if it was something that was going to exonerate him, they would. If it's not, meaning that it's not clear coat at all about anything, they're not
I-
able to get something, then they don't want to share that, which I
I
get.
do think Creighton is worried about shenanigans,
Yes.
Sure.
and that's why he wants to be able to test it against. Both sides are. Both
Right.
sides do not trust each other.
Mm-mm. And that's fair.
That's why they want to
That-
make sure their own labs are testing.
Mhm. I mean, it's more than
Can't
fair
they
that
send the leftover to a cloning lab and clone it, and then there would be extras for everybody?
Oh, but then you'd have to have a whole new process
I know.
of
I know.
chain of custody, cloning. Somebody would have
know.
to explain that this is not the exact same DNA. This is a clone,
Right.
and then you'd have to and plus that's a lot of money.
it is
That's a lot of money.
I wonder how much this is going to cost them to do. I am curious. I don't know that number, but I'm curious about it.
Well, Carleton is a very poor county.
Several tens of thousands. I meant for the defense.
Oh.
Pretty expensive for the state with their they're the STR, right? STR is the state, SNP is defense, if I remember right. But you know,
I'm gonna need a class on STRs and
It's
SNPs and stuff because I'm not a DNA
5,000
expert.
5,000 to 7,500 for Othram is what they charge.
oh, that's it.
That's it.
Oh, okay.
That must be like a group discount. They must
That
have
is
got a Groupon.
Way cheaper than I thought it was. I thought we were looking at like over $50,000, to be honest with you. But interesting indeed. Well, I mean, I definitely, when it comes to this, I see arguments on both sides, though I will say I lean more to the defense because they've already had a trial. State could have tested it. All of a sudden, they want to do the same test again, maybe. I don't know. This is kind of a very messy argument, though, on
Mhm.
both sides. Of all the ones we've heard today, I feel like this is the messier of the two
Messy.
because neither is actually saying clearly what
Mhm.
each side plans to do. But
No, that's because they don't really know.
Because they don't know.
You
You don't
don't
know
know
what
what
you
you
don't
don't
know.
You don't know.
Yes, exactly. You don't know what you don't know. Is
But
Poot
they
gonna
are
interrupt?
right.
to say that?
Is if they let SLED test it again and they get different results, the SLED lab would have so many problems.
Yes.
So I don't know why they want SLED to retest it. Why, when you've already let them test it? Why open that Pandora box?
It's going to happen if Othram finds something that Slide didn't.
Mm-hmm.
Yeah.
Yeah, absolutely.
But it is interesting. Othram is not certified to do STR testing. They can do it, but they're not certified to do that test, and SLED is.
Oh, that's interesting.
Othram is
Yeah, that's one
certified to
that-
do SNP, but not the regular
STR.
STR. Right.
I wonder why that is. That's interesting. Okay. But then the state lab only does STR, right? I'm
Right.
still understanding
'Cause
that
it's the
correctly,
easier
right?
one.
Okay.
Yes.
Well, how are they not authorized to do the easier of it? Okay. I don't know. There's
Because
probably
they're
some
into
rules about things.
genealogy, not Othram sends they do all of their stuff inside and they focus on the SNP. So that's what they went to get certified for. They
Can they
do
not
the STR,
do
but it's not.
STR
They
because
can,
it
but
goes
they
into
can do
government
it.
databases? Is that
That's
why?
what I don't know.
Because the STR is basically for like CODIS DNA. That's
Yes.
it. So is it because the only government entities can be certified for that because it's a government
That's what I
website?
don't know.
Are private not allowed? I don't know. These are just questions. I don't know the
Yep.
answers.
Write down the questions you have, something to investigate for later.
Girl, if I wrote down all
I
those
mean-
things, I would never get anywhere.
I'm
need
making a note
somebody-
to see if
Make
Othram will meet
list
with
so we
me
can look it
if
up.
I would go to Houston.
They absolutely will meet with you. They'll talk with anybody. They'll come on and do a whole interview with you. I've seen it done on Web Sleuths.
Oh,
Okay.
shit.
I am going
Okay.
to reach out to them
Okay.
to
Of course you are.
explain why they're not certified.
I love that. I love that. Fascinating. Okay. Oh my God, there's still so much more of this, but that's okay. I'm having a good time. Oh, I love it.
I am, but I'm wanting
I
wine
l-
so bad.
Good court hearing. Don't you have any liquor? Can't you drink liquor?
I do,
Are
but
you out
I'm
of Tito's?
worried to try it. No, I got Tito's. But Buffy's not drinking, so I don't want her to be alone.
It's fine. She's used to babysitting me on Fridays.
I know.
I was about to say, I am not the drinker. I'm the one that makes sure everybody doesn't
You're the
take off their clothes on
friend.
stream.
She's like, I babysit Llama every Fukong Friday starting at noon p.m. Eastern until later tonight when I tell her to stop going on other people's shows. You're too drunk, girl. She doesn't listen to me, but I do it.
She tries.
Sometimes I forget I do have a mute button, so I can just turn off your mic if you start getting out of control.
That's true. That's true.
Okay, Lainey, I like that. Candy is dandy, but liquor is quicker.
I used to say that all the time when I was younger.
Candy
I've
and
never heard
liquor are
that.
nowhere close to the
It's
same
from
thing.
Willy Wonka. Candy is
Oh.
dandy, but liquor is quicker.
Oh, okay. That's adult candy. Anyway,
I don't know the
The
answer to that,
S&P
Your Honor.
first and then do the STR?
I personally don't know the answer. We
Do
can
you
find
know,
the
Mr.
answer out.
Rivers?
We can find the answer out. But
I'm sorry, Your Honor.
I was just wondering if he did the S&P, the SNP test first, can you take that same sample and do the STR?
As I understand it, we have to process and get the quants, and then we will have an idea of what sort of sample that we have. And then, as I said before, then we can have a discussion with the defense and see, what we have and whether there's enough for this, that, or the other thing. and we can have a discussion. And again, I'm here to be completely fair, and this is a fair process for both sides. And if there's a dispute, then we can come back to your honor. But I think SLED, who has custody of this evidence, should do that processing and that quant, at which point we will stop. There will be no prejudice to either side. We'll know what we're dealing with, and we can talk to Dr. Middleman. We can talk to the SLED lab and say, is there enough for column A and enough for column B? And I want to correct
Let me
something.
ask you this. Are you expecting a different result from your retesting of this sample on the STR?
I'm not expecting a different result, but there's always the chance, just like if there was a different cutting from the same clothing or a different part of the swab. It's always a chance.
Sir, that
But
t-shirt.
that's why with best practices, and I gave you the memo, that reserved sample is kept. And then we're talking about fundamentally burning it all up, and that's fine. It is best practice for a law enforcement agency, particularly with the Preservation of Evidence Act, to keep stuff in reserve. But if we're gonna burn it, then it needs to be burned in a fashion that is fair to both sides. We can rush job this quantum processing. There'll be no prejudice to either side. Stop there, and I'll talk with the defense. And if again, Dr. Middleman already said with the 3 alleles and the leftovers that there's unlikely that he can do anything with that. But we'll have that conversation.
We can do the quant analysis and share it with them, Your Honor. We can do the quant analysis.
Okay.
Give me just a second.
Guys, just Google SLED problems with their DNA testing lab, and
I'll bet
they've had some problems. So
listen, I am not being hyperbolic when I talk about how shitty SLED is. Okay, I'm not.
I'm still
they have a
dying
huge
at
backlog.
3 alleles and the
alleles.
leftovers. It's like 3 men and a baby, 3 alleles and the leftovers.
Write that down for future stream names, because we're gonna get to it, whether it's before in the hearings or the trial. It's gonna, those 3 alleles are gonna come up
And the
again.
leftovers.
And the leftovers. Maybe we should just rename this stream 3
3
alleles
alleles from the leftovers.
we're the 3
Accredited
alleles.
to do STR?
He says they're not. I don't know the answer to that.
And Your Honor,
I would accept that they're not, but
Okay.
I need to correct. I think I said they're not accredited in either STR or STP. It's just STR. They're not accredited in, according to what I'm advised.
Okay, that they're not.
Yes, ma'am.
but they are in SNP.
Okay.
we can have the 3 T's and the 3 alleles and the leftovers.
I love it.
Let's do it.
You're like, oh god, what is? That's interesting. Interesting. Snappy and the Turtle Heads. That's a great band name. Chat, go ahead and put your favorite band names in the chat.
We'll make t-shirts.
Yes. I feel like we had a clever name if the 3 of us
I
were
was
ever
also
on together,
advised
and I
as
can't
well that
remember what it
because
is.
of the FBI accreditation standards for law enforcement that SLED has to run the processing first. So it really needs to go consistent with their accreditation, needs to go from.
But you've already
SLED to
done
them.
it.
But that's why we're willing to stop and again do nothing without
You're fine.
any prejudice. But their general rules are it can't go the other way based on the accreditation and the FBI standards.
Have any response to that? He's saying that if I let you go, let Othram do the analysis first, that then their STR won't be accredited. You know anything about that?
I don't know anything about that, Your Honor, but let's step back and look where we are. We're at the defendant. He's asking for this. Who can
I
complain?
understand.
It's only us. And we can't complain if the court orders SLED to do something that we've asked for. I don't think it jeopardizes SLED's accreditation.
Still on my
because
list.
In one single case, which they've had.
It's not often that I get the defense asking for DNA. That doesn't happen very often.
DNA.
Well,
Where's my
DNA.
Jurassic Park fan?
you're going to find out it doesn't happen very often, but this is one of them.
Telling you, we need
And,
a video segue.
And so, Your Honor, they do quantitative analysis as part of their accreditation. I mean, it's not like they're doing something that's outside Otham's accreditation. I mean, they are
Let me
accredited.
ask you, I mean, what harm would it be? Because if I give you the leftovers, they've already done the quantitative analysis on it. Is that right?
Give them the leftovers.
If I give you the leftovers and let them do the quantitative analysis on that and then hand it over to you. So whatever left over, they did the quantitative analysis, you could give back to them and they can do their STR. What's wrong with that? That way they can keep their accreditation for their STR. I'm just trying, what if he gets a different result? And he wants to use it at trial. And I'm trying to make sure you get your SNAP test. And I'm gonna make sure that you get it.
You know, and from talking to Dr. Middleman, he says to me, what's scientific purpose, or do they want to do this? What's their next step? If there's no next step, then there's a risk when you do quantitative analysis that it will get destroyed. And why take that risk? Now, first time I've ever heard him say, and you talk about we need to communicate. I've emailed him. We've had conversations about this, and I've said, what's the scientific basis? What do you plan to do with this once you do this thing and stop?
Yeah.
And today, for the first time, he says STR analysis.
So the same thing.
I've not heard that before. But
Also, which they've already done. Also, I know I've had a drink or two, but your guys' microphones, since they're now pink and fluffy, look like they're glowing. I don't know if it looks this way for everyone else. I've obviously had 2 liquor drinks.
Well,
but it's
mine
like
does have a
glowing
light
orbs
on it.
between.
Mine does have a glowing orb.
Mine
yours,
does
Steffi?
because no, I don't have a glowing orb, but I do have my softbox that's hovering over.
Oh.
So it's kind of reflecting.
I'm like, wow.
So
those
it looks like a glowing orb.
Right.
Yeah.
I love it. I love it. Yeah, no, they're just going to do the same test. And I see that that's
Which-
stupid.
As the judge, I would be like, you've already done it once. You've had 5 years to run it again. Your time's up. And
But
if
what
by
they
doing
are-
the quantitative can make it not good for them to do the SNP, they've already had their chance. But that's just
I was going to say that is the problem, right? Because they're like, well, we don't know what we don't know until we do the quantitative. And then there may be some more. I want to go with coincidentally,
Right.
there's not going to be more. But also the state lab, right? So they can give stuff out to other places, third parties, but they cannot receive stuff from third parties, right? So like
right.
their argument is that if Authorham does this quantitative part and sends something back to the state can't do anything with it because it's against their protocol, their
Right.
what's the word they're looking
But-
accreditation, if you will.
But how do we know that SLED wouldn't accidentally on purpose?
That's
use it?
exactly
I
what the
don't know.
And
defense
I'm
is
just saying,
I don't understand how they can't look at what they have and decide whether it's going to use everything before they do it. They
I don't
do
either.
it. Didn't they do that with John Benet Ramsey? They don't test this DNA because they knew that if they tested this, it would use all of it up. So it's kind of just been sitting there until technology gets better. They should be
Yeah.
able to look at what they have and decide before they do anything whether or not it's going to use all of what's there.
Yeah, I'm very confused on that point that you bring up too. How do we got to do this test and then see how much there is? I don't really understand all of that, but I'll be honest, there's a lot of DNA testimony that I don't pay attention to.
I
'cause
I
it's
just
kind
don't
of a snooze
understand it
fest
all.
and I don't understand it. Yes, agreed. So maybe we just need Authorham on to explain it
I
to
think
us like lay people.
I should have paid
so
more attention in high school science class.
Girl, you know how outdated our science
That's
education
true.
is? Quite outdated.
we didn't have DNA back when I was in school.
I mean, I learned how to spell DNA in sophomore biology.
Oh, okay. Like the real meaning of it, or just
Yeah, like the actual
DNA?
for deoxyribonucleic acid.
Yes. Okay.
It was a bonus question on every test if we spelled it right.
Oh,
Gosh.
wow. That's
So
impressive. I can't spell that.
Yeah, well, I can
apparently,
spell it
according
really
to
good now.
Google, nail clipping DNA testing is different than your other DNA testing because it comes from a hard keratin, which is under the
Oh,
nails. So it's
okay.
different and it's harder to extract, meaning you can lose more,
Well, why don't they say
according to
stuff like
Google.
this? That makes more sense than why
I
it's
don't know.
so,
That's why I had
well,
to
because
Google it.
they're lawyers talking about it. And again, that's no
Yeah.
shade to any lawyers, because not only as a lawyer do you have to know law, you then have to become semi-experts in all different avenues for each and every
All of
case.
them.
All of them.
All of them. The way
Yes,
you
Bobby
say
loves how he
that.
says all. But, so like you do have to be more knowledgeable on things that you are not familiar with, that you do not receive proper, training or education. I think lawyers have one of the most impressive knowledge bases that they need to in
Mhm.
order to do their job. And so, like, I'm not knocking them because they don't know that. They're doing
I don't know that.
fairly good arguing it. I think they probably should have had the awesome guy come in, doctor guy. I don't remember what his name is. Maybe come in and testify, but we'll see. We'll see what the judge rules.
We'll see.
But why didn't they just say, yeah, it's a different kind? That's why it's problematic.
They just need the leftovers.
They
We're just
just,
gonna yell leftovers, polygraph,
I mean,
all
no
these
yeah.
things in trial.
no P word, buff. Nope. That's contempt right there. No P word. Mhm.
Leftovers.
I saw it in his motion. Did I not, Mr. Waters?
And also in an email to Mr. Griffin as well.
Well, I overlooked that too, but still.
I can find it.
It's not like a piece of paper. I can make a copy of it.
Right.
And it's just such a little amount, and I'm trying to make sure. I want you to have your test.
Oh,
Well, certainly we can get the
that's a good
leftover
sign.
extraction pronto. That would get us moving.
And Your Honor, if I could, this is an email to Mr. Griffin, Harpootlian and Barber and associated folks from July 21st, 2026. In which I stated, as we also discussed, I plan for SLED to process the reserve portion of the 70 and 71 samples where we can get quantification, at which point we would stop and consult with the defense on quantifications and the likelihood of remaining extract before proceeding with STR or YSTR. However, as I told you, I'll pause that process while we discuss the matter. This is a fair process for both sides and one I'm willing to work with you on, but I should point out, Dick made it very clear
Are you
that the
happy?
defense would not even promise to turn over results if reserve sample or extract was sent to you. I'm happy to discuss this further and ensure a fair
Mark it
process
down.
for both sides.
But you would agree with me, Mr. Waters, that he doesn't have to turn it over to you unless he's going to use it in his case.
Well, I will say this.
Hoots
that
like,
if
I'm
we're
ready.
Talking about, that's why we need to process.
It's like, I've been
the
quiet
items
for
of
too
reserve,
long.
Unprocessed sample, and then we can
Why
we
do
can
you
figure
need
out
access?
and
You've already done it.
almost certainly there's going to be enough for column A and column B. But I'm willing to do that and stop and then have a conversation with them. And that's what I've offered. That's the fair result. It doesn't prejudice anyone. And of course, the quantification is going to, determine how much material we have. And at that point, the
And use
scientists
up
can
some.
analyze what is likely and what is reasonable. And I'm willing to involve them in that process. We just got to get the step one, and SLED can turn that around in just a couple of weeks. And then I will stop and give them a call and we'll hash it out.
Okay.
And I'm 100% willing to make sure that there's no prejudice to either the state or the defense.
Your Honor, to respond to that email, we discussed it. You have to understand the context.
Okay.
Before we tried the last case, they indicated there was blood spatter on a T-shirt.
Mm-hmm.
We wanted to examine it. We wanted to have it tested. SLED violated every rule known to man and destroyed the T-shirt in the process of processing.
It's not
Now,
great.
it turns out that they also, when they processed it, determined it wasn't human blood. We didn't find that out till very late. But the point is, we want Ofram, who is the gold standard, to do the quant
Like a
piece.
magician.
We want them to take that piece they've had for 5 years. Did they check it to make sure the first one was right 5 years ago? No. Now, when we have Ofram, we better
Thank
check
you,
that,
Mary.
so make sure we didn't screw this up. This is just a CYA. This has nothing to do with seeking justice. So I would say, let us have the unknown sample, hadn't been processed. Let Ofram quantify it. Let them, and if it's not going to result in them losing their certification.
Accreditation.
Don't test it. They've taken 5 years and not tested it. Why should we run the risk of them screwing that up? That if we screw up the quantification, we accept that. If they screw it up, we don't have a sample.
Ooh, that's a fair point.
I understand.
And that's why I'm so passionate about it, because we went out there to SLED. We dressed all in, Mr. Waters with us, had on lab coats and went in there and examined the thing and took pictures. And then, we couldn't test it. I don't have any faith they won't screw this up. But
I'll be honest.
Pictures.
Yes, right. But also, I'm surprised Poot wasn't like, Your Honor, I was around in the first case that used DNA. Because he loves his history lessons.
Yeah, well, I'm surprised he didn't give like a history of DNA.
Right. Don't worry. I'm sure it'll be good. I do want to see them all, though, in their goofy gear.
I know.
together.
He should have brought chalks. I think that's what they're called in Massachusetts. Chalks. I want to see the visuals.
Yes,
This
chalks.
is
Yes, they're
us in the lab.
demonstrative.
This is us in our lab coats. Don't I look amazing?
Look, we're besties. Oh, we need to Photoshop them into lab coats. See, if they don't give us stuff,
you
then
know
we gotta
what?
create our own.
That's what's gonna
Dangerous.
happen the next time we have a DNA trial
Yes, please.
or a hearing.
Yes,
it's
please.
just gonna be all of them in DNA.
Could you do that for the
I will make that
thumbnails?
happen. I absolutely can.
I absolutely can, and I absolutely will.
And I'm gonna put Mr. DNA in the photo too. We're
Yes.
gonna make it completely off the wall. Everybody's gonna be like, "What is this channel?"
Okay. Should we put out a trigger warning? Llama's taking her clothes off slowly here, piece by piece. And she's
It's
had
just like-
cocktails.
That's true.
It's
no, I'm
after
Just
five.
saying,
It's
It's
after
after
5.
five,
My
what?
house gets warmer, guys.
not
I keep
here.
telling.
It's not. Nope, it's not 5 yet.
I'll do what I can for the clicks and
On
the
the
views.
East Coast, it's 5, and it's
If
happy
anybody wants
hour.
to see more, drop some super chats, some jewels. You never know what you're gonna get.
Well, I have to keep my hair back on one side so people know I'm wearing a shirt, because otherwise it looks like I am wearing no shirt.
Well, I had a tank top on before this stream, and I got in front of the camera, and all I saw was like my hair like this, and I was like, "Oh no!"
Oh
I
no.
was like, "I have to go put on another shirt."
Yes.
I did that
Yes.
yesterday. I had on a little dress that had little bitty straps, and I was like, "Yeah, that doesn't look good when you put your hair down."
There you
Mm-mm.
go, chat.
Do the
What is
stripper theme.
Llama's stripper theme song?
I mean,
Oh
is
my
Llama
goodness.
not a good stripper name?
I mean, I think
Would
it's
you not
great.
throw money at a llama?
Yeah. Welcome to the
Wow.
stage, Lady Llama.
Llama to the main
apologize to the
stage.
replay I apologize, replay crew. It does
Yeah.
go downhill from there.
Yes. Yes, it does.
I'm gonna have to
Dollar,
break
dollar
down and
bills,
get a
y'all.
cocktail.
Congrats, Mary, for being a member for 1 month. Happy memberversary to you. And
Thank
this
you
is
for
what
being
happens
with
during long streams.
We make our
On
own
And
Friday.
after
hours,
5 o'clock.
Yep. Yep.
and there's alcohol.
I hereby order everybody. It is happy hour officially, no matter your time zone.
And that's what we
Uh,
should just call evening streams from now on. Happy hour.
Happy
Happy
hours.
hour.
All right, let's
I like
keep
that
going.
both
Oh
of
my
their
goodness.
hands, where you've paused it, their hands are
Uh-huh.
out. They're almost holding hands, it looks like.
Yeah,
Aw,
what-
they're praying.
I think they're all going to end up besties one day. That's what I think.
They do like to talk to each other on the
Okay.
phone.
They do. They do. It's adorbs.
Whether you have faith in them or not, why don't we have an independent right to examine the untested DNA? Why don't we have that?
Your Honor,
Except there's some procedural issue about their certification. We have a right to a fair trial. We want
Okay,
to.
you have somebody
I'll
from
allow it,
SLED
Mary.
here that can tell me about, if I
Yes,
give them
ma'am.
this sample, you can't do an STR?
And they can.
we do have Lieutenant Stanley from SLED.
Oh, we got a
Come
sled
up here
person.
and, speak with me, but I'm gonna put you under oath.
Okay.
We have a
It will
Stanley
help.
from SLED.
It's science. It's going to help with your headache because you're not going to be able to feel it after 2. And then your problems
Okay.
are tomorrow, Terry's problems,
Talked me
not
into it.
today.
It will
And then-
definitely thin the blood and reduce the amount of tension in your head. I don't
And then
know. I'm
future
not a
Terry.
doctor. I made that up.
Future Terry will be very upset with today's Terry, but don't worry. I deal with this all the time with future and past llamas. They're not
Just
big
blame it
fans.
on past Harry.
Mhm.
Tomorrow
Blame it
is
on Buffy.
Saturday.
Everybody does.
It's all Buffy's fault.
It's always
it's our
my
fault.
fault.
Yes, Terry, go. I'll
Okay,
will
I'm
allow it
going.
while we swear in this woman from SLED. How do they have a SLED person here? Were they like
Don't
preparing?
forget, we haven't even gotten to the 15-minute recess and what comes after.
We haven't. Because you said that's when things get crazy.
And then I was like, what is happening? Why are we talking about the Cracker Barrel?
Oh my God. What? Cracker Barrel? Okay.
Oh, man, she's
Terry
gonna drink
brings
it.
the bottle.
She's drinking straight from the jug.
No, I'm not.
Like,
I've
I'm
got my
ready,
sparkling
ladies.
water.
No, I need
gonna
you to drink straight from the jug. It goes with the aesthetic. Yes.
Terry, we haven't even gotten to the
clip that.
15-minute break yet.
I know. I
And
heard.
apparently it gets wild. Oh, did you? Okay. I wasn't sure if you had it in your headphones or not. So we're going to need that big bottle of juice.
It's fun time Terry, guys. It's
Fun
fun time
time
Now we're gonna
Terry.
add Jolly Rancher watermelon to it.
Do you just add it to the liquor or you got water in there too?
No, I had sparkling water that Double H brought me,
Okay.
and
then you
now
put
I
the
just
Tito's
added
in,
my
and then the-
Tito's to that, and then the Jolly Rancher watermelon.
Oh, I might have to do that because I'm out of juice. So
I'm gonna have to start a drink.
0 calories.
If I
0
hang out
Well,
with-
can I tell you a secret? I do the watermelon stuff just in water, and it still makes me think I'm drinking. And they also have a rosé flavor, so you feel like you're drinking rosé, but there's no alcohol
Oh, that's
and no
interesting.
calories.
Y'all don't want a drunk Buffy.
These people are Texas represent. That's right. These people have very unrealistic opinions on Charleston after the break. What? Okay, all right. Let's
Okay.
continue
How
on.
far away are we from the break?
I don't know, but this is our life now. We live here, Terry. Sorry.
Those-
I'm okay with
we
it.
can turn a 2-minute hearing into a hour
Yes.
stream.
Oh, yes.
I do believe I said maybe I shouldn't go on the live because it's going to turn into a 6-hour stream.
It would have happened either way. While I was gone, didn't we get a comment too from somebody being like, those two love to hear themselves talk?
We do.
Yes, we
Dumb
did.
shit like that.
But
And
ironically,
yeah, we
we
I
had a
don't
lot,
like
and a
I
lot
I
of
don't like the
opinions.
sound of my own voice.
I don't
Right.
either. And that's why I have a hard time listening to myself. Terry, have you ever had Lano wine? I have. And there's only one of their varietals that I can do, and it's their Chenin Blanc. Everything else gives me a headache.
Mm. Bells has told me many a times about that wine. It's one of her faves.
Yeah.
We don't have
Am I
that here.
going to have to start drinking? Dang it,
I've
you
been
guys,
there.
So much peer
Maybe.
pressure.
Maybe no peer pressure here, but I want
No
to see
peer
good
pressure.
time Buffy.
I
I won't
say,
be
could you
opposed
wait
to
till
it.
we're all together? Can you wait till we're all together? I
Right.
still
To
want to
watch
do a
me
New
drink?
Orleans. I'd want
Yeah.
to do a New Orleans live show, and then when we're done, go act like dumb tourist.
Y'all will
Wow.
unfriend me if I
Never.
drink.
Everybody's
we won't.
doing it. All right.
They'll
So
be like, we don't even know her.
we don't even know. Mm-mm. We have the same name, but I don't know who she is. It's very weird.
Don't know who she is.
So they're swearing in this sled lady who I don't know. Did she show up to testify? It's kind of weird that sled is there, but
Oh.
okay.
Bells, honey, I love you, and I know you want your wine. I've been where you are. Please don't.
There
Please
you go.
don't.
You'll probably get very
Please
sick.
don't, love. Please don't. When you're all clear, I will buy you 6 bottles and I will drive there to bring it to you and we can share it together.
That's right.
Please don't.
No, I am not an angry drunk.
Oh, no. I'm thinking she's a wild dancing on top of tabletops girl. Am I wrong?
Yeah.
Sweaty drunk.
Huh? Would
I'm
you
a sweaty
say?
drunk.
You're a slutty
See, I
drunk.
am too. I am
I'm like-
too. And
like, you don't
according
wanna
to
take me
Jeffa
in
today, dark rum makes him slutty.
Mine's tequila.
Yeah.
Whiskey, we will fight.
Tequila?
We will.
Tequila
matter
makes
who
my
it is.
clothes fall off.
Mm-hmm. Yep, that's how I got pregnant. It was all tequila's fault.
That's how I got pregnant with my youngest.
Oh, well, look at that.
I mean, I was completely sober when I got drunk, but I do a lot of things I don't remember.
Wait a minute.
Wait,
You were sober when I got pregnant.
Wait a minute.
I'm pregnant.
You were completely sober
Completely
when you
sober.
got drunk.
Wait, are you
Most
not
of
sober
us-
when you get drunk? You start
Most
sober.
of us are.
Right? Oh my goodness.
Harry, I don't need you to point out when I say something stupid or I'll
No,
not
I
talk
loved
anymore.
it.
She's
I
getting our
loved it, but, you
contact
know-
buzz.
One thing I'm learning is that, like, Double H, when he drinks whiskey, he's mean. He's not nice at all.
Oh,
Me
yeah.
too.
Give him tequila and vodka, and he gets
Same.
funny and horny.
Mm-hmm. Same.
See, it's weird what different alcohols will do, right?
It is for different people, do all sorts of different things. But yeah, I will fight you on whiskey. It doesn't even matter. Doesn't even matter who
definitely
you
doing
are or
it.
what
Somebody
it's about.
Did somebody
What?
just play a noise?
No,
No.
no.
Maybe you should put the drink down.
No, I'm
Shot
wondering
it
if
right out the bottle.
I'm now using battery instead of plug-in, so maybe that's it.
Oh, yeah, it must be part of your things. All right, so they're
Not-
swearing in this sled
let's get
lady.
back. Why is she
Interesting that
You have
there?
to focus.
I don't know.
Okay. All right, well, tell me how you lose your accreditation if I give them a sample and then you like take the leftovers and, yeah, you can go right there,
Leftovers.
Cody.
Is that a new drinking
And
game?
you can't
Maybe.
produce an STR that could be admissible in court.
An
Is that what you're
STD?
telling me?
Good morning, Your Honor. I am the quality manager for the laboratory. So my job is our accreditation and
Oh,
making
okay.
sure that we are complying with accreditation standards. The DNA laboratory is accredited by the same entity as Othram, but in different capacities.
Okay.
We also follow the FBI quality assurance standards or FBI QAS standards that are put out by the FBI for DNA caseworking or testing laboratories, as well as DNA databasing laboratories. In order for us to accept data from
Becky.
or accept a sample
Thank
from
you, Bells,
another laboratory, they need to
yes.
be accredited in the same services for us to continue our testing.
That's very true.
So it's not necessarily losing accreditation because we just wouldn't be able to accept it and perform the testing.
Well, let me ask you this. What if you got a sample and it was the only sample you had that had already been processed? Just hypothetically, are you going to tell me that you're not going to do an STR on it and try to admit it into court?
We may not be able to, is what I would like to tell you. We share samples with Othram, for example, or third-party laboratories, but we're typically giving them the extract or the remaining portion, and they're able to work with that for their samples. We are unfortunately not able to work with theirs.
Why?
Right.
It's a one-way
I'm not
deal.
as familiar with the SNP testing, so that might, my understanding of that is it has to do with the standards that are followed for the accredited laboratories.
Okay. All right, thank you. Mr. Griffin, let me ask you this.
Okay.
If I give you the leftovers and I give you the unprocessed sample, you have it
Right.
quantitative and you do your SNP test, and then you give them the leftovers and they can do their STR test. Would you consent to it being admitted into court?
Yes, Your Honor. We wouldn't raise any objection as to the
To accreditation or
accreditation, chain
anything
of
like
custody,
that?
thing like that. Now, if there's some other irregularity in the process, sure, but not because of it flowed from Othram back to SLED. No, we would not object to that.
Oh, so she's saying, wait, is the judge implying that? Okay. SLED just said, the lady representing the laboratory who deals with accreditation, which is totally fine, says, hey, we can't receive stuff back from Othram. Like, that's not how it works. And then the judge just asked him, hey, are you going to like complain or cause a commotion about the chain of custody if Othram sends it back to SLED? Because if that's what she's saying, then she didn't understand what SLED said.
Well,
Because
that's
SLED then
what-
won't be able to do anything with it, is what
I feel
SLED
like they
said.
keep saying the same thing over and over again, and nobody is understanding what is being said.
Okay. So, all right.
Now,
Yes.
to fix this, I've heard of this in other evidence testing. Couldn't a SLED person go to Othram and supervise the testing to keep the chain of custody?
Perhaps, but I think it's still, if Othram does anything and wants to send a sample back to SLED, they cannot, because of accreditation standards, use it for anything, right? It's like, for example, even though Othram is accredited in different ways, it would be like you and I sending a sample to SLED and being like, they're not going to do that, right? Because it's not reliable. There's not a chain of command. There's a lot of error and contamination that could come to play.
But I agree with Mary. I think the judge is saying to the defense, if it comes back, are you going to object to SLED retesting it, even though it wouldn't be an accredited sample? Are you going to complain? Are you just going to let it go? That's what I'm gathering.
So
Like,
why
Mary.
would it be an
But-
accredited sample?
Exactly. SLED is saying if it comes back to us, we can't do anything with it. Period. We're not going to,
Yeah.
and we can't
But I'll
because
say
of
the
our
judge-
accreditation.
The judge keeps getting hung up on it coming back, but
Yeah.
it can't come back. That is literally what that SLED person just said. We can't take it back. So the judge keeps getting
but
stuck
couldn't
there.
they test it without
No.
the accreditation? They could do a one-off and say, we all agree this is not an accredited STR test because it came from Othram, because they already have an accredited version of it.
I think that maybe they could, but I
Because
don't
they've
even
already
know if it's
done the
worth it.
test. They
Well, they
already
can all
have the
stipulate
results.
to anything, I think.
That's what I'm thinking. Couldn't they just stipulate that, yes, we agree you can test it?
Well, that's what the judge is saying. But I'm confused by the state and what that lady said of whether or not what the judge is saying is even a realistic possibility. That's why this so far has been very confusing from all the different angles. Because it's like, wait, I thought we were agreeing on this one thing and how it works. And then another person's like, no, we're going to try. And it's a mess.
But I do understand
I'll be
what
honest.
Terry's saying. Can we just all stipulate that the unaccredited lab is going to test this, but you can't raise a stink later that the lab you wanted to use was not accredited, is what she's basically asking, is what I think you're saying.
That's what I'm thinking.
Which
the
I would
judge
think
is saying.
should be understood because it's your lab. It's the one you picked. You shouldn't be raising a stink about anything. You picked it.
Oh, see, I thought the
And
raising of the
SLED's
stink was
already
SLED.
tested it. But SLED's already done the STR. So why not just stipulate and say, fine, you go do it.
I don't
and
even
then
know
we'll
what
come
we're
back and
arguing
do the
about.
STR.
This is so stupid. I feel like they should just be able to
I need
do
a
it.
picture chart.
But
Mhm.
do we? I mean, I get where their defense is coming from. We know SLED is screwed up. Let's think of the
Yeah.
T-shirt. Why would you want them to do this quantitative test when they've been proven to screw up before? Let's
Right.
send it to Othram. They can do it, and we will stipulate without accreditation, SLED can redo the STR test because they already have an accredited version.
I think they should
I'm
just let
too
the
simple.
defense do whatever the fuck they want to
No,
with the DNA.
I feel
It's his
like these things
defense.
make sense. It's just
I mean,
just
guys,
very
it's
confusing.
not going to change the outcome, in my opinion,
True.
of everything.
What do you mean by
No,
that?
We have him on audio being there. So the DNA might
Being
just
there
tell us
doesn't
who the
mean
shooter was
those are two very different
that
things.
Alex knew. I know.
Two very different things. It doesn't make
Oh,
one.
so you don't think it's
First degree
none of this is going to make a difference in the outcome of the trial? Is that what you mean?
That's because maybe it's different in South Carolina, but in Texas, if you are there and you're an accessory, you are charged with the same
Right.
crime.
No,
So
you're
even if
charged
the
with
DNA
felony
test,
murder. You're charged with felony
but
murder, which is not the same as the other murder charges. They're charging him with first degree murder, which means he
but see, in
planned it
Texas,
ahead of time.
it would still be first degree because he planned it. He did everything. We have audio that he was there. We
But
would
there
just
is
also find
felony
the
murder.
other stuff.
And usually that has to involve another crime, though. So wait, no, hold on. Sorry, I was drinking. Felony murder means you were planning on conducting a felony and then a murder
Felony.
happened.
Right.
Right? That's
Right.
what that means. You're right. I'm sorry. I had to rethink about that. Like if you're going to rob a bank, that was the crime, and then somebody died. That's
Right.
felony murder.
Right.
Right.
So to
Okay.
me,
Fair point.
he's still guilty of first degree murder if he planned it
And he was just
this
there.
other
And
DNA
even if
person pulled the trigger.
even
But
if he
that's not the
didn't pull the
state's
trigger.
case. That is not the
Right.
state's case, and that is not
But
what
it
they're
also
telling
could
you to
just prove
happen.
she was
So,
having an affair with a stable boy.
but all of that is
I know,
reasonable doubt,
reasonable doubt.
because that is not the
Or
state's
she
story
just
to
went
all of
to
you.
get her nails done or she touched
But
something or she
you've
brushed up
got to
against somebody and
okay.
accidentally scratched someone in the store. I do it all the time when I'm reaching down to
Okay,
grab
but
something.
go
accidentally,
listen to the nail technician talk.
well, I'm not just talking about the nail technician, but you know how easy to get crap under your nails is? Like it's so easy.
It
Yeah, I
is
very
so
long.
easy.
But then wouldn't there be more than just one
I suc-
rando male with 3 alleles if it's that easy?
That's on the
Touch DNA
extracted
is
leftover
easy.
version.
Touch DNA is a
And
very sneaky, weird thing.
but what if you scratch her with these two nails and this has like a lot more alleles, but these only had 1%? Because when you
This
scratch
is the
somebody, you don't
next
necessarily.
episode of misinformation, speculation, and theory.
Okay,
I
I'm
love
with
it. All
Belle.
right.
Why are you scratching people in the store, Buffy?
I'm not saying like I walk
Yeah,
up to people and
absolutely.
scratch them, but you ever go to grab something out of somebody's hand and actually
And you
brush them
do.
up with I have long
Yes.
nails. And like
Right.
you
Yeah.
reach out and grab something and you're like, oh, I'm so sorry. I didn't mean to scratch you. I do it to my kids all the time.
All the time.
All the time.
All the time.
All
And
the
I
time.
scratch myself in my sleep all the time.
Can I ask a question? Does
Only if it's
anybody,
all the
when they
question.
wash their hands, use a nail brush and clean under your nails?
No.
See, I do a
No,
couple of
Is that a
times
thing?
day. It
Oh,
is. I use my nail brush
not
because
with a
I
nail
pet the
brush.
dogs and I'm allergic to them. I go plant stuff, I get dirt or food
oh.
because I have long nails. I scrub underneath them so I don't get
I'll be honest,
salmonella
I
or something.
have never considered that outside of like doing like a really like dirty project. You know what? I've never once considered that doing. I guess I'm a dirty ass.
See,
I'm
Bells is with
nasty.
me.
I
Maybe
just
it's,
use
I don't know.
soap like regular people.
Yeah.
I do, but that doesn't get under your nails. I
Okay.
use a brush.
Wait, you
Yeah.
don't get soap under your nails? But my
I
nails
do,
are
but
so
it
long, I hate soap in there.
doesn't clean all the goop out.
What are you doing? What are you doing with your hands that your nails are so dirty?
Scratching my dogs, digging in the dirt, cleaning things. Okay,
you have to
I'm
go.
not
All
the
right,
only
so-
I wonder
one.
why you scratch.
Nope, it's just Llama who is the dirty llama. I didn't even know, y'all. Okay, it's fine.
Guess
I don't really
what?
do much.
Christmas gift for all of staff: nail brushes.
It'll just go in the drawer with the other ones I got in there.
Well, wait
today I
till you
learned.
get salmonella.
Llama
and you
learned
will
about
change
that.
your mind.
Never had
I-
salmonella.
Mm-mm.
I didn't do
No.
under my nails, so I got salmonella.
Oh. I mean, that makes sense. I've never thought about it ever in my life to do it,
And for
like,
those of
on
you
a
that have
regular
litter
basis.
boxes, if you clean a litter box, clean under your nails with a brush.
I do. I clean.
because the
I wash my hands right after cleaning the litter box every time. Always.
But you need
because
to
it's
use
so
a
gross.
brush because the soap doesn't clean, that doesn't get rid of salmonella. We'll have a separate discussion.
Okay. Llama learns
Soap
about her
doesn't get rid
dirty
of
ass
salmonella?
fingernails, apparently.
That's how
So-
I wound up in the hospital for 2 weeks with salmonella, was because of cat litter. One little granule was under my nails.
It's kind of relevant, Angie. We are talking about
It
nails.
is.
No, I'm kidding. But she's right. Let's move
half-assed
on.
fashion. That's what I do. I wear
yeah.
gloves.
All right, let's get on to this because we still haven't got to the break yet. My goodness. I think we're almost there, though, probably.
We're having an educational discussion.
As they say, I am learning a lot.
Your Honor, just as to that last hypothetical that Your Honor
Right back.
stated, I think that the same thing would have to happen, that after processing, you have to stop, because only then are you going to know whether there will be leftovers. And that's the whole, what I'm proposing is we process and we stop. And at that point, we'll know whether there's going to be enough for STR on SLED and enough for them to have the leftovers of that. And that's exactly what I'm saying. But if they go ahead and run the SNP without consulting with us, there may not be any leftovers, is what I'm saying.
Well, let's talk about that, because
Let's talk about it.
why even get it processed if we're going to stop? Then what's going to happen?
So we'll know at the quantification point, we'll have an idea at that point that if we proceed with STR testing, whether there will be, like there was in the other examples, 47 or however many microliters of extract remaining for then to be provided to Othram, which again, the original leftovers were willing to provide. But the processing in the quant is where we kind of know what we have, and what if we do further with it, do actual testing with it, what is the consumption possibility at that point. And so that's why I'm proposing that we process it, we'll know what we have, and then we can actually have a discussion of who can do what with what. And that's what I'm proposing to do, and have SLED do that. We can turn around in a couple
Well,
weeks.
this is their motion to do their SNP test.
Sure.
And that's
Because you've already done
what
this.
I intend to rule on today. Not get halfway through it and come back and hash this all over again.
I absolutely, Your Honor. But once we get that quant, then we will, and their expert will know exactly, first of all, is SNP viable? And secondly, the amount of consumption that will be necessary for that. And so that's why we're not kind of like stopping. We're just, I don't know.
What is your position if the SNP test destroys the whole sample? There's nothing left.
So Your Honor, what we want to do, we want it all to go to Othram. The unprocessed, they will process it. They'll do a quantitative analysis, and we'll share that quantitative analysis with SLED. And then we'll know whether there's enough to do both. If there's not enough to do both, they'll know that, we'll know that. But and we want to do the SNP testing with that. We may have to be back here and having the same back and forth. But what we don't want is SLED to keep it, SLED to do a quantitative analysis, and then say there's not enough for you to use. I mean, that's what we don't want.
That's my whole offer, is I wouldn't proceed without having that discussion and with them. So that's the whole point of what I've made, is that we'll know what we have at that point. I'm not going to do anything to prejudice anybody, but we got to process it to know exactly what we have and what we can do with it.
And we want to process it.
I understand.
She's like, what do you think about that, Joe?
Angie says just fold it in.
you just
fold it in.
fold it in.
I
Just split the baby in half. I don't think you can do that. I don't think it works like that.
But here's my thing. Why do they want to redo the STR when they've already
Griffin.
done it?
I'm gonna grant your motion. I'm gonna let you take it. The leftover,
Oh.
the new. Y'all make sure you make a chain of custody. I'm gonna let you have the analysis done, quantitative. Then I want you to report back to the court and tell me if there's leftovers before you do your SNP test.
Yes,
I want to know beforehand. And then, because I've got to get this started. You need 90 days at least. So we need to get it started. I want you to report to the court, let me know, and then I'll have a discussion with y'all on what we're gonna do.
Wow. Okay.
Thank you, Your Honor.
Granting
you.
it. I mean, I think that's
All right.
wise. Who knows what it's going to produce, but if the defendant's asking for it, quite frankly, I think they should allow it.
They're gonna hold up and let me know. All right, let's talk about transfer of venue. Who's,
Your Honor, before you do that, we have a 5-minute recess.
Oh.
I'm sorry, I have a bad habit of keeping right on going.
Me too, girl.
Absolutely, we can. Court's gonna be at recess.
I got that stamina
for,
too.
let's say 15 minutes, so I can give everybody else out there a break too. All restrooms are located on each floor in the same
Okay, hold on.
place, over to the right. And thank you.
Thank you, Your Honor.
I adore her. Big fan.
I
Big
love
fan.
her.
All right, hold on.
And Llama and Buffy, I both sent you problems with not cleaning under your nails.
I know. I got it and almost sent you a really mean gift back.
Because I didn't until I got salmonella.
I'm teasing you.
Well, I
There's the
didn't
oil
know.
painting.
Oh, okay.
Now, Llama, you remember we talked about on Monday that when all this happened with Murdaugh, they went into the courthouses and took out the oil paintings of his family members.
They did. That's right. Because there were 2, maybe it was just 1, but I feel like it was 2. Oh, they're back. Yeah, they had an argument in court about taking them down because it would cause, perhaps prejudice in some way, shape, or form. But yeah, the courtroom had pictures of his ancestors. I feel like there were 2.
And I did Google it,
Maybe
and
just-
it's mostly southern states or historical, really prominent people do they do oil paintings.
I
Oh,
only remember
okay.
it being one, but I'm not saying you're a liar because I don't really remember a whole lot from this trial.
Lie. Just kidding.
Liar.
Write a motion about it, Buffy.
If you walk back and forth, that painting's eyes follow you. That's what I was
Probably.
doing. He was like, whoa.
Hey,
Well,
I'll give the South this. They are having oil painting artists, giving them jobs still. So I appreciate that and their support of the arts because it's a dying place.
I love that y'all noticed that. I sent y'all on Discord when somebody was talking earlier. I think I'm not sure who. I think it was Barbara. That it looks like there is a gun hole, a bullet in the
I saw
door.
it.
Yeah. that's
I
weird.
I took a snapshot of it because there was a shooting in one of the courtrooms. And
Oh,
I'm
wow.
wondering
In Lexington?
if that was the bullet hole. Yes.
Oh my goodness.
That's why I
Oh,
took a
wow.
snapshot and everything. Because I'm like, is that a bullet hole?
You need me to do a deep dive if anyone from the defense is connected to Oprah or
Okay.
in general. I think they're hoping for something else, whether or not it happens or not, who knows? But I do appreciate, like, because there have been other cases where there's been evidence that has not been tested. One of the biggest ones would be the West Memphis case, right? The West
West
Memphis
Memphis.
3, they wanted some DNA tested on some items. I know they won that argument eventually, only recently, and that case was forever ago. I don't know what, if any, results they got from that. I haven't looked it up in a really long time. But usually the answer is no. But that's in appeals. This is a different trial. This is a
Right.
trial. So I'm thinking maybe that is the leeway here, because people do claim this in appeals all the time. And usually the appellate judge's decision is, well, you had the chance to ask for it then, but you didn't. So the answer is usually no. But again, this is a brand new trial. So, well, I'm sorry. Let me correct myself. This is not a new case or a new trial for one motion and argument, but for other ones it is. I don't understand the difference, but fine, whatever. I get it. There's one indictment, but they make it very confusing. Oh, it was of Buster Murdaugh, right? So that would have been his great grandfather, right? I think.
Think so.
But interesting. All right. Now, apparently, this is the part where it starts to get real off the rails. Apparently, they took a break and they came back just ready to let loose, I guess. Formalities are out the window from here on out, or so I've heard. So you will see.
Well, I mean, it's more just ridiculous.
Thank you, Your Honor.
You're welcome.
Okay.
I remind you of my age.
I mean, we're going to talk about Cracker Barrel.
And how old is that now, Ms. Hartbilly?
We're going to talk about the cost
Really?
of the
On the
sandwich.
record? I'm old, okay?
You're not underage. You're not underage.
I'm
All
35.
right, do I have everybody? Okay. Mr. Waters, you got everybody at your table?
Yes, ma'am, I do.
All right,
No,
then let's
me.
proceed with the defense's motion to transfer venue, please.
Your Honor, let me at the outset, and, we've attempted to try to negotiate something with Mr. Waters, which has not been successful. But the only person in this courtroom that has a constitutional Sixth Amendment right to a fair trial is sitting right there. Now, the state has some due process concerns if we wanted to try it somewhere that was totally, for instance, inaccessible. We wanted to go to Oconee County.
I'm going to be there next week.
Well, hopefully you'll get back. But, we understand that, but they don't have beyond that due process right any
It's not
pick, if
funny.
you will.
It's
They're not
funny.
entitled to the venire they would like to have. The venire we have to have
Venire.
is the venire that's the fairest to him. The venire we have to have is the one that's more likely to either have not formed an opinion, or if they have formed an opinion, it's such that they could disregard it and base their verdict on what you tell them and what comes out of that witness stand. That's black letter constitutional law for the last 200 years. Now, this is a complicated situation because the media coverage of this has been, in my experience, unprecedented for a number of reasons that go beyond just the fact of the notoriety.
I wouldn't know my vote is yes.
A death penalty case in Newberry County 25 years ago,
Oh.
covered gavel to gavel by Court TV,
History
watched
lesson
all
by
over the
poop.
country. There was no social media. There was no internet. There was no, we actually had newspapers where people got their news, and
Social media wasn't invented then.
wasn't even
An
invented.
old time case 25 years ago, Your Honor.
We all sat around
Oh,
a campfire and stoned them to death.
right, chiseled our court sketch artist chiseled it into rocks, actually, Your Honor.
Is he saying he wants to go back to the prehistoric days?
No, that's just Pooh. History lessons with Pooh. That's one of my favorite
Yeah.
times. He wants you to want to know how old he is and how long he's been around. Always, at least every day that we have a hearing, or even during the trial, it will happen every time. But I just want to preface, I am always for venue changes. I thought it should have been changed in the first one. It wasn't. Here we are. There are several cases that, even ones in Ohio, where I'm hoping they change the venue to my city, because when you do have crimes that happen, big deal crimes happen in smaller population counties, I do believe it is very hard to get a fair trial reasonably. While you would think, oh, everybody's heard about Murdaugh, right? There's nothing wrong with somebody hearing about this case, but whether or not they can set it aside. And there's one trial in particular, the George Wagner trial, that I'm hoping they move up here from Pike County, because we have a county of 1 million people. While
Right.
some have heard about the Pike County massacres, people in
They don't
cities have
know it all.
bigger things to do. All right. They really do.
Yeah.
And that is not an insult to smaller population counties, right? But when something big happens in a small county, everybody knows about it. Everybody. It's all they ever talk about. Where when you get into the bigger cities, there are tons of cases that happen every day in my city that they could call me as a juror and I don't know shit about, because that's just how it is. Not everybody hears the biggest things. So I'm always a proponent for moving it, because I do believe everyone deserves the right to a fair trial. And what pisses people off a lot are usually the victims' families, right? Oh, they'd have to travel. And I do get that. I respectfully do get that. But you do not want to end up as a victim family member looking at a whole retrial because somebody whose job it was to not interfere in that small town county and get a retrial. And here we are. So I understand that it creates an undue burden on the family, the victim's family and whatnot, respectfully. But unfortunately, the fair trial does supersede that. But anyway,
It does.
yeah, I mean, there's plenty of people that did not actually watch all of this, but I feel like, ooh, girl, I can't wait. January, it's starting. It's either going to be here or in Cincinnati. If it's here, which all of the legal team is from Columbus, Ohio, all of them. So I have
But I
a
thought
except for the judge, who, by the way, was the judge from my home county. Uh, but I feel like it'll probably get moved up to here because of cost, et cetera, to put all of the legal teams up and everything. But we'll see. They have not decided yet. But anyway, so let's see.
And yet we had three networks, three television stations. And it got some notoriety. It was a pretty famous case. The son of the Episcopal bishop of the state was charged with murdering his wife, who was the daughter of a state senator. Got a lot of coverage. And Henry Floyd heard the case and had a jury from Oconee County seated.
Yes.
He didn't even have because of the
Come up, we'll hang out.
Everybody in the county knew one or the other. So I've been through this process before, but the most notice it got was I get a call from somebody from Arizona who watched it, and when I got back to the office telling me what I'd screwed up that day. But nothing like what we've seen in this case. Wall-to-wall coverage, internationally, nationally,
nationwide,
and the state,
international.
when you start talking about, and they talk about media markets,
not wrong.
It's irrelevant. Whether you were in Greenville or Charleston or Beaufort, it didn't matter. It permeated everybody's consciousness. 10 million people watched this. And if they didn't watch it live, they watched it on YouTube or Court TV that night, or with the feed on their phones. I mean, it just permeated everything. So what's the solution? Well, first of all, I don't believe the state is arguing we should go to the 14th Circuit and try to pick a jury. And we have enclosed a copy of an order issued by Judge Kelly,
I don't think so.
I think yesterday or the day before yesterday, in a civil case where the defendants in that case, with a lot more resources than us, developed all kinds of factual bases as to why that case, which is related to the boat death case, the Parker case, should not be tried in the 14th Circuit. And he moved it to Spartanburg. And we would ask the court to allow us to introduce all the exhibits relied on by Judge Kelly in that matter into this matter, so that Your Honor will have the ability to review all those. We'll get them and
From
get
your
them to
case
you
from
as
25 years
necessary.
ago?
There's statistical studies. Judge Kelly's order is a work of art.
I
Oh,
read it yesterday.
And like you, I think you probably
I
would
read
agree
it.
with me. Well-reasoned, factual basis is extraordinary. And that's a civil case where
Right.
I like
Oh.
there is
Spartanburg.
no
Let's
Sixth
go
Amendment
there.
right on either side.
Oh, he was talking about the boat. Oh, I missed that between his 25-year-old case and then he's referring to the civil lawsuit
Right.
that they've decided to change the venue on. Oh, okay.
Let's go to
Okay.
Spartanburg.
Hmm. The triple T's are available to be on the jury. We are. And I am more than willing to put aside my beliefs to see what they do. I've already said that before. Let's see what they can convince me of this time. So we're available. We're not residents of South Carolina at all, but
But they should bring
we don't
yours in
qualify.
from different states.
I don't think they're allowed to do that.
They're not, but they should.
Mm-mm. No, I do think that they'll be able to find a jury, but it's about the size of the jury pool.
We
I
just
think.
got an offer for a place to stay.
Yeah, party at Mary's house. Love it.
That's
Let's
right.
do it.
With no cameras indoors following us.
That's true.
So I would say, and I don't believe anybody's going to seriously argue that we go to Colleton County or even Beaufort County and try to pick a jury and waste our time down there.
That's true.
That's number one. So where do we go? Now, we suggested Charleston. And why did we suggest Charleston? A whole number of factors. One is it would be convenient.
Is Charleston the capital?
30 or so or more witnesses from Colleton County that will be testifying in this case. They won't have to travel, go somewhere, spend overnight, or travel 4 or 5 hours in a car one way and back. That's number one, convenience of witnesses. Two,
No, it's
the jury pool in Charleston is larger than the entire
Bigger.
jury pool for the 14th Circuit. More people. And why is that important? Because once we got through the questioning of the hundreds of jurors that were brought into Colleton County, only 14% remained. 86%
okay.
went away.
It is not the capital.
And so if you're
But
going to
it's
have to bring,
the biggest
again,
city.
being as old as I am, I've been through this exhaustive process before in a case I tried in 1983, a death penalty case. We went through 400 jurors to get 12 in a death penalty case.
Oh, it's
Took
about the
4
size
weeks
of our
to
city.
get the jury. So this will be complicated and we're going to, closer to trial, we would ask for attorney conducted voir dire, but we would concede that's not allowed by the statute. But we're going to ask you to conduct individual voir dire of each and every juror with some very specific questions.
Pardon me real quick. For locals there. So they're in Lexington County. Is this county in the circuit that they're referring, the 14th District Circuit? Like, why not have it here? Is that because it's the same place, my South Carolina friends? I'd like to know. No, I did think it was Charleston. Well, Columbia does ring a bell, but Charleston is the size of Columbus, Ohio. It's about 870,000 people, which I think is a fair jury pool. It sucks. Okay.
And allow us to approach you if we think there's additional questions needed. But everyone's going to know of this case, and everyone is going to perhaps have a preliminary opinion. The question is, can they put that aside and base their verdict on what you tell them, what they hear from the
That's
jury?
right.
So the second reason for Charleston is not only is it convenient, they've got a courthouse with 16 courtrooms in it. It's not going to shut down the county judicial system to try that case there. They did the Slager case there. Court operated normally, nationally covered
What case?
case. They
What
courtroom
case was
packed every
that?
day, and it got a lot of
Slager? I don't know.
attention. And right across the street, they tried Dillon Roof for 3 or 4 weeks.
Oh,
Didn't shut
that's
down.
federal, though.
Shut down the city.
I'm pretty sure.
Now, to that suggestion, the Attorney General has suggested a number of other counties. But before I get to that, I'd like to address, and they have handed us an affidavit this morning, which
I didn't say I was admitting anything.
You're not putting this in?
I didn't say I was putting that in. I just gave you that as a courtesy.
What are
Oh,
you gonna do with it?
Waiting to hear what you do. It's your.
I'm gonna say this is wrong. You're gonna put it in?
I'm waiting to see what you do.
Okay, well, I'm gonna offer it.
wait, what?
Oh,
So-
Do
shebang.
these guys seem like they could email each other and talk things out?
No. No.
So Creighton writes an affidavit about this venue, gives it as a courtesy to Poot, but has not submitted to the court and was like, well, I was waiting to see what you're going to do with it first. So what? Okay. Then why can't you
Okay,
boys
so
just
Mary's
be nice and email one another? Colton is 14.
telling
Yeah,
us.
but they're in Lexington. That's where this judge is. Is that the same circuit as Colton is what I'm wondering. And why they're not having it in the judge's home. Because that is a very nice courtroom that they're holding hearings in. It's plenty of seating. She obviously has things under control for hearings and such. That's why I was just wondering why.
And they said it's been great. There's a bullet hole in the door back there.
It must be the same circuit though, is why that must be it. But I don't know how all the circuit things work. Circuits are very confusing to me. I don't really understand them.
Can a judge go outside of their circuit if there's a venue change?
Yes, they can.
Okay,
They can
that's what I
go in
thought.
any state, yes.
That's
Or
what I
any
thought.
part of the state. Yes. It's southwest of Columbia. Interesting. Interesting. All right, so they want to go to Charleston. Creighton Waters. I just say his full name to say it right. Has this affidavit, which she has not submitted, but Pooh is like, okay, well, what am I supposed to do with this then?
I hear
So,
Charleston
all
is
right.
beautiful.
Okay,
Well,
sure, I don't,
I object at this point. As a courtesy, I gave him an affidavit of our investigator that I potentially was going to admit depending on their evidentiary presentation and did that as a courtesy.
Okay.
Now he's gonna put that in. If we're gonna do that, that's fine. Let's go ahead and admit the real affidavit.
The
But I
real
What's
affidavit.
in the real affidavit?
No, there's a signed notarized one. I just gave
do
that to you as a
tell.
courtesy
Good, I'll put that in for you.
because I don't play ambush.
Ah!
Oh, wow. Is this
Oh.
getting spicier? Is it the Tito's?
Yes. Yeah, no.
He said he doesn't play ambush. The implication is he just got ambushed.
Mhm.
Right.
Which is so funny because I'm not going to play ambush, but I actually have a signed and notarized copy here that I haven't told you about. But don't worry, I'm not ambushing you.
And I gave you this as a courtesy to see what you were going to do and say.
Oh, I love these guys. See, I told
So
you
again,
both sides.
I submit the question to you. Do these guys seem like they can email each other and just work things
No.
out?
No.
No.
I mean, I
Mm.
would prefer email because then it's documented instead of a phone call.
And Poot's like, I'll put it in for you. It's fine. I don't really. But I like how it's like, we have the real affidavit here. Well, what the fuck did you send me? What are you
And it's like,
talking
did you
about?
send me what was it, boondoggler?
A boondoggler. I forgot that word.
Maybe it was a
Learn-
boondoggler they sent.
This is why they just go straight to the judge instead of like, look, I don't even, we're going to fight. We just go straight
This
to
is
mom.
why we don't
Mom,
talk to each
tell us
other.
what we're going to do. Mhm.
Yes. Oh, Poot's face. Oh no. Oh, they took a break and got their sassy pants on. Is an ambush lawyer any different than a clickbait lawyer? Asking for a friend.
I think they're in the same tier.
Oh, okay.
but
Okay.
different circuits, right? Like
Look at
just as bad.
look at these two back here looking at each other like,
They're like, oh yeah.
our faces would get us in
Mary?
so much trouble.
Yeah, we
I
would get
kinda
thrown
love
out of the courtroom so
Spartanburg
fast.
and Greensville. The in-betweens are meh. I agree.
Oh. You're gonna have his hand out for a hot minute. Oh man, I love it. Love it.
I
Yeah.
just want to
Okay,
go on
well,
record and say
one of y'all.
for
needs to-
77, he is very well put together. His brain is still working.
Yeah.
I'm going to
it
just
is
tell
quite
you
impressive.
there is He's,
I mean, he has his moments, but like, okay,
I mean, he does, but
he's good.
It in, you could wait for, Mr. Waters to put it in or Mr. Harpoolian.
All right, we would offer, this
It's like
is
just
State's
somebody
Exhibit 1 for purposes.
It's
I would offer this as a State's Exhibit.
it's my affidavit.
Probably out of turn, but go ahead, Mr. Harpoolian. It really doesn't matter who puts it in. It's in evidence as I would assume, Court's Exhibit number 1. Is that State's Exhibit number 1? You want it to be an exhibit or a court's exhibit?
We'll make it a
We'll
joint.
put it in as the State's Exhibit in support of our response. Again, Your Honor, I gave him a courtesy because.
And he just jumped the gun on you. Is that what you're telling me, Mr. Waters?
And I told him I didn't know if I was putting it in or not, but as a courtesy, I was going to go ahead and give that to him, so I wouldn't be handing it to him right in the middle of the hearing.
Okay.
But I was waiting to see what, if any, evidentiary presentation they made before deciding.
How's that an
Harpoolian, he didn't
ambush?
want you
That's
putting
not what
in his
ambush means.
exhibits. So he's going to jump the gun and put in State's Exhibit number 1 for you. So could you?
You get to see it.
Yeah, I'd like to see a copy of what it is y'all are arguing over.
she's like, I'd like to see.
Okay,
Thank
so
you.
and I can
Why
summarize
didn't
it.
she get a
It's the same
courtesy
argument
look?
He makes in his brief that Charleston is too expensive. Although he didn't get an affidavit saying it floods, that he did put that in his response.
It floods.
So,
Okay.
As to the flooding issue, we've checked. Nobody can tell us the court down there, other than during a hurricane, has been suspended in any way because of flooding. And of course, I'm sure the state will take judicial note, or you should take judicial notice that galoshes, or wellies, if you will, can be placed on your feet
Wellies.
to get you through any sort of
That's right.
sodden street in Charleston.
Y'all can wear
Okay, pause
galoshes to court.
I mean, that is petty because you can wear your wellies.
Oh, that's so funny.
And April
Nice.
is not hurricane season.
Galoshes.
Galoshes. Did not
I
have
call them
galoshes.
wellies.
I've never even heard of them called wellies, but
That's
okay.
the British thing. I call them wellies.
But also, like, weather can happen literally
Anywhere.
anywhere. Like, you can't control what happen. Like, if a hurricane is coming to the East Coast, like, hell, I didn't know I was gonna lose, power for 3 days over a storm. Like, you can't. That's kind of unpredictable things. I think
It
for
depends on Mother
her
Nature.
state to bring up. But okay.
Oh,
Galoshes.
Mary is saying that when it rains, it literally wipes out roads and shuts everything down in Charleston.
Oh, it is
So
called
that's
the
a
Low
common
Country for
problem.
a reason, I guess. But is it
Okay. So
is it not
do
all
they
Low Country?
so do they not hold trials there at all is what I'm asking.
Ever. I'm like, Houston floods and we still have trials there.
Well, if we go in the spring, we better bring our galoshes, okay? Noted.
Wellies on the packing list.
Get some cute
I've
ones.
got my pink wellies already.
Oh, can we make our own? Can we brand our own? Can I get some couch
Put
carpet llama
jewels
ones?
on them.
Ooh,
I
yes, to a
will look
varsity
into
Chris building.
that and get that. If we all agree to go, because between 3 of us, one of us is likely to win the lottery to go in.
That's true. We have better odds. I'm not camping outside, just so y'all know. One of y'all are. I'm not doing
I
that.
will camp outside.
You guys can go inside. I'll report on the outside. I'm not waking up at 3 or 4 o'clock in the morning.
But you can
Bring
wear your
galoshes.
wellies.
And my is Wellies a brand?
I don't know. I just like saying it.
Okay, all
I
right.
say
I didn't know-
wellies is what I have always called them.
Oh.
And then I was so happy because nobody where I grew up wore wellies. And then when I started working over across the pond and I went to an event and they were like, "Oh, did you bring your wellies?" I was like, "I didn't." I was like, "But I'm so excited you call them wellies too." And they're like, "Well, yeah, it's England."
Oh, that's funny. Okay.
Wellington
Did not know
boots are
that.
named after the Duke.
Lamashes versus or Galoshes versus Lamashes. I love it. Yes. They're named after the Duke. Okay. All right.
Try
Okay.
saying it
Guys,
after a few more drinks. Lamashes versus
Lamashes
Lamashes, yeah.
versus galoshes.
Yeah.
How funny is
I
that,
will
everybody?
Not
guarantee
gonna come out well.
I will bedazzle our wellies or goulashes, whatever you want to. I
Okay.
will bedazzle the rubber boots.
Done. Done and done. Look at that. We're getting our packing checklist under wraps here. Okay. Don't worry,
Wellies,
Pooch.
hack sandwich.
We'll bring them.
We're coming to meet you.
They're too expensive.
Mm.
To get to the courthouse. So I don't think that's a serious objection, although they made it. The major objection they have is it's too costly.
Okay.
So I'd like to call a witness, please.
Okay. Wait, so
Sure.
Bill Barber to the stand, please.
Bill Barber. His
You want us to swear in Mr. Barber, the lawyer on your side?
He probably would tell the truth anyway, but that's probably
What the
safe
fuckery is
process.
happening?
the judge.
What?
You want us to swear in a lawyer from your side? What is that? What?
What?
And I got to let Zoe
The
out.
fuckery. What is happening?
Why are we calling
I
Barber
told
to
you.
talk about a
just
I
video?
jumps the
should not.
shark.
I should
Jumps
not
the
have
shark.
grabbed the Tito's.
You should have. See, this is why we needed the Tito's. About to do
It
shots.
jumps the
himself.
shark after the break. We were like,
What?
what is happening?
Why?
What is
Okay.
happening?
This is all for a venue? To
I
argue
know. I'm like,
venue?
for venue.
Just
I
wait
would
till you
love
hear the
Angie's-
argument.
Okay,
Oh,
I've got to give Angie credit. He'd probably tell the truth, Your Honor.
but just for funsies, because it hasn't been long enough. We're going to
Oh,
put one
is
of
the
ours
trial
under oath.
during the Masters? So if it is during the Masters,
I don't know what that means.
that will raise the cost up.
Masters, what does that mean?
It's a golf tournament where they.
Oh, golf. Okay.
It's golf.
I don't do sports things. But also.
It's okay. It's golf.
Well, I mean, listen, I'm going to
No.
say this
No.
before we even get into it. The population of Charleston is about 870,000 people. All right. That is very close to the size of my city. All right. And we have huge events come in all of the time. I mean, we have the Arnold Classic weekend, which brings in hundreds of thousands of people for a weekend. The Ohio State Fair brings in millions. But here's the thing, is that it is very centralized to certain parts of the city. The city still functions and is just fine.
Well, it can still function, but the cost goes up.
Book them now. You know when the trial is going to be. You wait till the last minute and then, yeah, it's going to be kind of expensive. But I don't know. We also have a golf tournament here. Forget what, babe.
Do you know what golf is?
We have here. Yes, I know what golf is.
Golf is a sport, Lainey. It is a sport.
I know. Oh, the Memorial
I mean,
weekend,
men like
whatever.
to play
It's a
with
very
their
big
balls,
deal.
and now women do it.
I'm just saying, a city that size is used to very large groups of
It
people. I
is.
mean, we have conventions all the time. It's not that
They're
weird.
just talking that it's going to be more
Um,
expensive because it's going to be a higher rate.
For whom?
Yeah, I don't know.
Because like when ACL comes to Austin, we can handle it, but the prices double and triple
I don't think so. If you pick 'em
on
in
hotels and
advance,
Airbnbs.
We'll see. Let's hear what Barber's going to stay as under oath on the stand. I don't understand why this is happening. I have never seen
wait.
this.
You got to hear the arguments.
That's true.
They're
That's true. Right? Those of us that live in bigger cities, we're like, yeah, it's not really a big deal, but
Okay. As a girl
true.
who lived in Dallas for many years and Double H is from there, Dallas can handle anything.
yeah. I mean, that's just how big cities roll, yo.
I
but okay.
understand the taxpayers, Angie, but I guarantee you they've spent more on dumber shit. I'm just saying.
Probably.
They have. They have.
Absolutely. Oh, yeah. Okay. All right. Let's see.
And
This is wild.
do you solemnly swear or affirm that the testimony you give before is the truth, the whole truth?
She's laughing. Look at her smirk and look how red he is.
And Your
Do you-
Honor, as he takes a stand.
Do you think he knew this was going to happen?
He is
Surely he
red.
did, right?
Look at his ear sticking out. His right ear. His blood pressure's up.
Like, what the fuck? Oh my gosh, that's so funny. Okay, all right.
And their allegations are so ludicrous, I have to respond with my own ludicrous.
Did you hear his joke? Oops. He said, I'm pretty sure he said their claims are so ludicrous that I feel the need to ludicrous. I'm pretty sure that's what he said. I love these guys. I mean, come on. Are you not
Mama, you've had a lot of cocktails.
I have, but also that's a good joke. This is why I'm not a lawyer, because I would see things like that and be like, oh no, that went on the record. That's embarrassing. I love it. I appreciate it.
Can I just say the judge has not opened her bottle of water and has not hydrated at all?
No, but I
Just
enjoy her
saying.
face. Like,
I do, but
yes,
she needs hydration to help her skin.
Right? Half-ass? That's hilarious.
It is.
I love a good pun.
I wonder what
Oh, love
Ludacris
these
would
guys.
think of it.
Luda. Just kidding.
Oh
They've
no.
got to continue on, Mr. Harpillion.
Mr. Barr, where do you live?
I live in Mount Pleasant, South Carolina.
And where do you work?
Okay.
Where's your office? We have an office in our.
I principally work in an office in downtown Charleston within walking distance of the Charleston Courthouse.
Okay.
Your church in Broad?
It is on State Street near
Ours
Broad Street.
too. Ours too.
And do you
Okay.
drive to work every day?
I do.
Yours too?
Pause
'Cause
it real quick.
I did pause it.
Do you know why the other microphone is hanging down? It just
Why?
hit me thinking of Double H. That is for the streaming. So they're not having to pull the audio from the speakers in the courtroom. That is why they are dropped, because Double H had to drop those at City Center for an event because it was being recorded from an outside source and
Oh.
it would have reverberation in the room because it wasn't set up for that.
Night, Liz. Don't forget about the rest of this
Night,
for replay.
Liz.
I'm sure it's going to get better.
So just had to throw that in there.
Yeah.
That's what I'm thinking.
Okay. Our courthouse is also on State Street, which is like 2 streets over from Broad Street. What are the odds? It's interesting.
Okay.
And how long does it take you to get from Mount Pleasant
Or State
to
Street.
basically 2 blocks, 3 blocks from the courthouse?
It takes 15 minutes.
Okay, and that's rush hour?
A
Yes.
drive?
Now, also, before you get on the bridge to come over the Cooper River Bridge, are there any accommodations that someone was in a trial in Charleston could stay in?
Yes.
And just give us a sample of what those facilities would be.
Is this guy a travel agent?
There are, I believe, at least 9 budget hotels clustered at the base of the Ravenel Bridge on the both north and south of 17.
And you can get
Okay.
a room there at a reasonable price?
Yes, there's a Comfort Inn, a Holiday Inn, a Hampton Inn, there's an Indigo Inn. There are various, economy, extended stay suite. There's 9 of them total. There's everything you can
I'm
imagine.
sorry. Is Bill Barber secretly a travel agent by night? Like, is that his side
I don't
hustle?
know.
How does he? This is ridiculous. Why is he testifying about? Okay. All right.
Because-
It's fine.
I mean, I know what hotels cost in my area, so
They're outrageous everywhere. Just to put that out there. It's not cheap to stay nowhere. So
There are more in the vicinity, correct?
Yes, and I pass those every day going to the office.
Now, when we tried this case in Colleton County, do you know where the state folks stayed? They rented a big chunk of a Hampton Inn, did they not?
They stayed at a Hampton Inn, I believe it was at the Interstate 95 interchange.
Okay. And do you know how, and if you Google how long it takes to travel from that Hampton Inn to the Colleton County Courthouse?
I have not. I know that it took at least, I've driven it before. The Cracker Barrel was there.
Oh.
We went to there. It was a good,
Cracker Barrel.
a comparable 15-minute
Forgot the
Drive.
Cracker Barrel.
Oh, that's not too bad.
Yeah, it's about 15 minutes, right?
I think-
About the same time it would take you to drive from one of those Mount Pleasant hotels, budget hotels, to the courthouse.
Yes, if you wanted to get in early, there's a lot of the hotels north of 17 have a highway on-ramp that's right there at the hotels without even having to stop late.
Okay, and does the Charleston County Courthouse have a parking garage?
It does.
And if we went to the Charleston County Courthouse, do you believe that we could get some spaces set aside for the prosecution and the defense and perhaps even witnesses to park?
All I can say
Objection.
is it would be incredible to me if attorneys for the state of South Carolina could not obtain parking spaces at a
Can
South
we
Carolina,
pause
you know,
for a second?
judicial
Yes,
facility.
yes, Terry.
And the
What
we
do
can.
y'all consider a budget hotel? Because I just went on my Hilton Honors app, and I'm a Diamond member, and it is the cheapest I found was $337
A night?
a night.
Holy shit.
So
Well,
how
in
is
fairness,
that a budget?
our
hotel?
Airbnb last weekend was like $600 for 2 nights. So
But
that's like
how is
pretty much
that
the same.
considered budget? Is what I'm trying to figure
Girl,
out.
I don't know. I just don't understand. Why would this guy, we know who he is. He's Bill.
Oh wait,
he's
I
Bill
take that
Barber.
back. There's one that's 206, but it is 35 minutes away.
From
Oh, check
Charleston?
April 15th. Okay, that's it. I just checked
That's
current
probably important.
dates.
But how is he objection, speculation? He doesn't know for a fact that spots will be reserved. He is not the courthouse that can do these things for the parking garage. I say this because we have a parking garage. This is ridiculous and stupid, and I love it. I love it very much. So, okay. Well, Mr. Barber, if law doesn't work out for you, you might be able to make it as a travel agent. So far, so good.
There's a solicitor's
6
office
week
in the courthouse, is there not?
It's either in the courthouse or adjacent. There's actually a collection of buildings, so there's 16 courtrooms, in the actual judicial center, but that doesn't include, I believe, magistrates courts have a whole separate building adjacent to it.
And so the solicitor's office would be available. The solicitor works for the attorney general, right?
Your Honor, I object, and that's also legally incorrect.
I would
Okay.
answer no that the solicitor does.
Well, wait a minute, he just objected. Be glad to hear from you.
Well, Your Honor, the only point I'm making is that solicitors certainly make space for a prosecutor from the AG's office to
They
prosecute. When they're down there doing statewide grand jury cases, I'm sure they cooperate with the
Reasonable.
solicitor's office. They're all in the same game.
That's true.
They all both have constituted.
Well, I don't know that you know that for.
That's
to be
cheaper than our
true.
Well,
Airbnb
that's been my
was.
experience. I was
Your
12
experience,
years
okay.
as a prosecutor.
Do you want to talk
I
about
wouldn't
your
call it
experience? That's
economy.
fine. I just don't want any testimony saying that's true. Y'all don't know it to be true.
All right.
Go ahead.
So, based on your driving in every day and based on those hotels, do you believe it's a 15-minute drive from those hotels to the courthouse?
Yes, I pass the hotels every day.
And now this affidavit, you read this affidavit?
I have glanced at it.
And in the affidavit, their investigator says that there are
pages.
no inexpensive hotels within walking distance of the courthouse, correct?
That's correct. I don't know all the hotels within walking distance of the courthouse are certainly expensive ones. I never really thought of that because after all, when we were at Walterboro, no one stayed at a hotel within walking distance of the courthouse.
There are no
If we
hotels.
had a trial in, say, Richland County, I would imagine that the Columbia area prosecutors would stay at home and not rent
Exactly.
a downtown hotel. So when I looked at hotels, I immediately thought of the 9 affordable extended stay hotels I pass going into work every day to the courthouse.
Which are within 15 minutes of the courthouse.
Yes. And I have Googled the price of those. I did that the day before yesterday.
Objection. Did you Google them in incognito mode so the cookies didn't charge you higher prices or however that works? Just
Okay.
wondering.
I will give him credit because I just Googled that date instead of going through the app. There are some rooms you can get under $200 and you share a bathroom. with other guests.
Ew, no, let's not. Okay, no, that's unacceptable. What, in a hotel? I've never heard of
Yep,
such a thing.
there is a couple. Yeah,
Ew, no, thank you. Hard pass.
And different ones and different prices. The prices are not elevated because of the Masters tournament, because the Masters tournament, no one stays in a Hampton Inn below a bridge in Mount Pleasant to go a 6-hour round trip to Augusta.
Okay.
And the prices are comparable to the Hampton Inns anywhere. They're not significantly more expensive, with the exception of sometimes the weekend prices are higher, or they're usually higher because you're near the beach. So there is some peak then.
They would go up on the weekend, but
It's the same price as
Shadow
any
puppets?
other Hampton Inn or Holiday Inn.
did we have any weekend court sessions in Colleton County?
When we were in Colleton County, everyone went home for the weekend. You only had a chance to go home.
So if there is an increase in price on the weekends, that would not affect the price they would pay during the week. Anybody would pay during the week, including us. We may stay actually in one of those budget hotels.
Diane staying in one of those budget hotels, y'all.
We're on a budget.
Okay.
we're on a budget.
Yes.
Okay.
Yeah,
Okay,
presumably
this
it
is
would-
insanity.
The weekday prices would be what would be relevant.
Okay. I believe that's all I have for Mr.
Oh.
Barber. I'd like to continue with my argument. You want him to be able to cross?
Well, he might want to cross-examine him right quick.
Fine with me. I just.
Oh,
with the
no.
Affidavit thing, I'm sort of confused as who's going what, when.
Would you like for him to cross-examine
He's
him
like,
now?
I'm confused by it because nobody would do this ever. I don't know when this is supposed to happen because this is crazy. Your Honor, I know it's crazy. I know it's crazy, but we're doing it. I don't know.
And guys, are they really going to go home on the weekend?
Probably, but oh wow, this is okay. Now this is what is great. Great has no idea that this is coming. How is he going to be prepared to
wanna know what-
question this wild ridiculousness?
I want to know
This
what
could have been
Buffy
an
thinks
email.
because she saw this earlier and now it's had
Yeah.
time to percolate.
She's like, it's still just as fucking nuts.
This sounds just as dumb as the first time I heard it.
I'm like,
Oh my
I'm
god.
like,
find this
is this
insane.
really
Am I the-
what we're doing? We're talking about parking garages and hotels. We're on a budget. We'll stay at a freaking like Quality Inn. I don't know. The shadiest hotel in the worst part of town. Put us there.
Yes. Oh my god, this is crazy. I have
This
never
is
seen this
insanity.
over a venue. But okay, this is why y'all who didn't watch the first
Is
trial
any of us thinking
expect
that
a lot
these
of this.
attorneys are really going to stay in a budget hotel?
No,
And
ma'am.
I'm just asking.
One, in fairness, budget hotels do not have good Wi-Fi. And respectfully, they do need good Wi-Fi to work off of, when they're off out of court.
They're going to need room
whatever.
service too.
I'd love to see food at the La Quinta.
I was like, say, they're going to need room service. I mean, granted, there is DoorDash nowadays.
The La Quinta here is like one of the shady ones. I don't know if it's like that everywhere,
It
but
is,
it's
yes.
definitely one of the shady ones.
I mean,
Like,
the
you're
stays are
only there
nice,
for 2 reasons.
but exactly, everybody knows what the La Quinta's for. I mean, they're nice hotels. Don't get me wrong. I've stayed. They have lovely pools. They have a lovely hot tub. But we know
know
why half the people there are there.
But you know
There's
what?
a reason they're right off the
Maybe
highway.
Maybe they can get something to help Alex get through the trial.
He's not going to
They
be
can
staying
purchase
there.
what they need. I know, but they can purchase it for him.
Oh my goodness. Oh, this is too weird. Oh, you guys, this
They're
trial's gonna
arguing
be.
this.
His partner is under oath right now, testifying about the city
About
of Charlotte.
hotels,
Or I'm sorry,
parking
Charleston.
garages, Cracker Barrels, and wait till we get to the price of a sandwich.
Oh my God. Oh,
I mean, I will also say that as somebody who is in the corporate world, you can reach out to the hotel and say, we have in a group coming and
Yeah.
staying. and
Yeah.
they are here for this reason, they will
Yeah,
give
they'll
you
block out rooms.
huge discounts.
Exactly. 100%.
You get blocks.
100%. This is wild.
I don't know if the
Okay, and if a
pizza does
price
that,
of a
though.
sandwich is more of a discussion here, I need to hear it.
Well,
it's
all
gonna
right.
happen.
Then let's get to it. Well, I make myself another beverage that I probably don't need, but I'm going to anyway because it's Friday. Spook on Friday. Oh my God, this is so ridiculous.
And then you can continue.
Yes, please.
All right, go ahead while I have him on the stand so I can let him down. Go ahead, Mr. Waters.
So I can let him down because this is wild.
Good afternoon, or morning.
Come on, Mr. Waters.
How you doing today?
Sorry.
Good, sir. It's just in the afternoon.
Yep.
I didn't even get up out of my chair. Good morning, afternoon, whatever it is. He's so pissed and annoyed right now. Like, what is happening here? And
Guys,
I'm
the
supposed to take this
trial
seriously.
is going to be amazing.
Oh, has he checked?
Look
I'll
at
look
Buffy.
prices.
She's looking down. She's like, I am over these ladies.
The shame.
Oh,
The
I'm
shame.
not over y'all, because the best part of this testimony is about to come up.
Stop. Stop.
It is
Okay.
time for us to start a GoFundMe and ask people to pay their or Venmo to pay for us to have a hotel for 6 weeks. We'll negotiate a good rate because we definitely have to go and be in person for these shenanigans.
But I'm not staying at the La Quinta. Let's just be clear.
No, we are not staying.
But
at
I
the
am
La
a cheap
Quinta.
bitch. It's fine. I don't need bougie.
I'm a cheap.
That's Terry. But
I don't need bed bugs.
or who
It
knows
sounds
what.
like we're gonna
fluid.
get washed away by floods,
Oh.
and we can't afford to eat because the price of sandwiches and also hotels.
Oh gosh, that big city. He's just a small town country lawyer. How does he know how much the price of a sandwich is? Oh my God. Honestly, as somebody who lives in a very large city, turns out our prices, very little difference from when I go back home, which is in the middle of fucking nowhere. It's bad pricing everywhere, friends. Don't know how to tell you. Break the news to you, but that's just kind of how it is. All right, I need this drink, and let's hear what apparently is going to get worse, according to Buffy.
When was the last time you stayed in a hotel in Charleston?
Look at his face.
It's
I know
been a
he's
while.
over it.
I will say that I had my best friend visit 2 weeks ago, and I put him up at the Hampton.
Oh.
And I paid for it.
And you mentioned
I'm
that
available to be your friend, Mr. Barber, if you want to put me
Why
up
didn't
in
he
the
stay at
Hampton
your
Inn.
house? If he is your
I
best
know.
friend, why didn't he stay at your house in the guest room or on the couch?
Sometimes you don't want to stay with your friends. You need to be able to walk around naked.
True.
You need to be able to like pick your toenails and not be judged for it. I mean, it's just a thing.
Not my girl best friend then, because us girls, we would do that in front of each other.
I just want y'all to know 2 of my internet besties came in town last weekend. And guess what I didn't do? Pay for their fucking stay. I split half with one and the other was on her own.
Did you walk around naked in front of them?
No, but there probably could have been that opportunity. I almost did see one of their boobs while they were feeding
Okay,
their
Buffy,
baby.
we will make
wasn't
sure
me.
if we get an Airbnb or something, we're going to have separate spaces.
I did not see any of them. She thought I did, but I was like, no, I did not see your boob. So
It wasn't my boob. Wasn't me.
You weren't there.
Wasn't
No.
me. I wasn't there. Let's just be perfectly clear.
Exactly. Oh my gosh. And you thought the Master's Turney sandwiches were affordable. When will people think about us and our lawyer salary places?
parking
Oh,
garage
God.
there.
All right.
uh,
right back.
in Charleston.
I can't believe
near
people
the
are still listening
courthouse.
to us.
Do you park there frequently?
Me either, but
It's been a while since I've parked there.
It's been a while
Oh.
since you parked there, so you don't have.
I have parked there in the past, so I've seen it with my eyes, but I haven't parked there recently.
Right, and so it is true then that parking garage is built to the max.
Your Honor, I'd like to
Very early in the
testify.
morning.
I do have eyes,
It'd be very hard to get a spot there, is that correct?
but they don't see all the things.
I don't know. I will say this, I have parked there on occasion, not for just because it's a parking place, and it's been about 3 years since I've done this, but just as a place to park. And I remember one time I had to go to the clerk's office for some personal affairs. The probate offices are in there.
Oh,
And It is mostly full, but that's because it's mostly reserved spaces
That's right. It's mostly reserved spaces.
for
right?
people who work, for the state of South Carolina.
And when you testified earlier, you haven't actually talked to anybody at the court administration or at the clerk as to
But where are we going to
who
park?
manages that parking garage as to how many spaces could be, if any spaces would be reserved for anyone. Is that correct?
I have not spoken
Yeah,
to
that's
the
fine.
clerk about the parking.
All right. You would agree
Are they
that
not going to carpool?
Charleston, on a larger scale, probably has the most big city traffic of anywhere in the state?
I would not agree with that.
All right, where do you
Personal
think
experience.
has more traffic?
If you've ever driven through York County, the Charlotte traffic going into York County, I probably nominate that as the worst in the state.
Okay, so.
Oh.
Second one?
The traffic here in Columbia, especially around the what's called Malfunction Junction, but also coming in, when I do come into Columbia, sometimes I'm staying a little north and come in down Bull Street. That is a nightmare.
Malfunction Junction. What's your function? Getting stuck in rush hour in Charleston. That's a bad song. I'm sorry, but
Do you think the judge is texting her friend right now? Like, you're not going to believe this shit. I'll tell you about it when I get off work.
this is so good. What is your thoughts about rush hour and traffic? Like, what?
Right?
These are really factors you're taking. Why can't one y'all carpool? All right, it's better for the environment. You don't need that many parking spots. But like, I'm sorry, this seems like a very first world problem. But where are
There's-
we going to park? I don't know.
When they did this in the Idaho, like the Koberger trial, like they actually had like people go out and do like surveys and stuff. Like it was like sample size. It was like data and now like this is just
What?
the lawyer testifying. Because when they were talking
Right.
about changing venue, they actually had somebody like pull data and like made a whole data analysis about where to put the venue.
You mean it
If they
wasn't just a
That's what I'm
lawyer
thinking.
going on the stand under oath?
No, that's why
This
I'm
is
like,
just
what
a local.
backwoods stuff is this? This is like country as hell. It's like, let's stick our fingers in the armpit and tell it what the temperature of the body is.
Oh my gosh.
Park down at the Piggly Wiggly and walk for 2 miles down to the courthouse. It's fine.
The horror. I mean, I will say this. We actually do not, our city is pretty well with rush hour traffic considering our size. But we're also a newer, I don't think Charleston is a very new city, if I recall. Like it's kind of like an OG city in America. So
It's an OG.
they are built very different. They are not built for population and convenience for driving because that's not how the city was founded in the first place. That's a problem with a lot of the East Coast cities is they're not spread out like ours is. Like we have even though traffic sucks and I won't drive during rush hour, it is nothing compared to what I have seen in coastal cities or Atlanta. I will never drive through Atlanta ever. It sounds like hell. If there was a circle of hell just for llama, it would be driving through the city of Atlanta. I've seen that. No, thank you, ma'am.
Driving anywhere in traffic.
But I do feel like these hotel stays and traffic, this is kind of stupid. These sound like inconveniences for you guys, but like, does this have anything to do with him getting a fair trial? Because that's the whole point of moving the venue. Like, I do understand it's to accommodate everyone, but also, what? You might have to sit in traffic longer, like the rest of us peasants or something. It's just, I can't with these trivial problems, but okay. Don't drive through Knoxville, Tennessee, then llama. You won't if you don't want to drive through Atlanta. Yeah, no, thank you. No, thank you.
Every day.
So you're saying the traffic in Columbia is worse than the traffic during rush hour in the Charleston metropolitan area?
I'm saying that it's worse than the traffic coming from the Ravenel Bridge side of Mount Pleasant into Charleston.
Would you at least agree with
I want to, if I can finish, you had a
Oh.
very broad question about the Charleston metro area. It's certainly true that if you're coming in from Somerville, right, down I-26 in the morning, that is extremely difficult. But I don't think that that's a No one's
Creighton
gonna be
looks
doing
so
that.
fucking annoyed.
And I don't have experience with that. I've seen it.
Yeah, because this
But
is a
coming
stupid
from those
argument.
hotels in Mount
This is like
Pleasant
something
every
you
day
take in like a high school law
Charleston,
studies class where
it's a
you get up there and
consistent
have a
15
mock
minutes.
trial about traffic.
Well, it was a simple question. Would you wouldn't say it's the worst, but you would agree that the traffic in Charleston during rush hour is a lot. Would you agree?
Rush
with that?
hour in any city
I
sucks.
would agree that it is typical of a city of its size.
And traffic downtown, particularly during rush hour during the business day, is a lot. Would you agree with that?
Honestly, it's a bit dead down at the Broad Street area. If you go up to King Street in that area, yes, but down where the courthouse is, no, it's really not.
Would you agree that parking is difficult in downtown Charleston?
Okay.
I would agree that parking is difficult in downtown Charleston if you're not permitted to park in the, I think, 9-story parking deck that the courthouse has.
And you would agree that
Take an Uber.
Spaces being reserved for maybe a prosecution team that doesn't include witnesses and law enforcement.
Breathe,
and all of
breathe,
that,
llama.
That would be
This
necessary
is
for the
ridiculous.
state to do what it did in the first trial, and that is to not let court break down once for 6 weeks. In fact, the only time court did break down was after 2 witnesses in the defense case. Is that correct?
I'm sorry, you were speaking fast. I didn't quite catch the question.
You would agree that if there are parking spaces being reserved for a large prosecution team, that doesn't include spaces that would be needed for witnesses and for law enforcement and that sort of thing, that would be necessary
Like his opinion.
to prevent court from breaking down in a large complex.
Nice Big
trial.
Lebowski reference.
Did y'all
No,
catch that
I-
he told him he talked
If
too
you're
fast?
asking my agreement, I guess then my opinion is that the parking deck is available for people there at the behest of the state because it's the state's parking deck.
Would you agree that the Charleston area is one of the most expensive, just generally expensive areas in the entire state?
I don't understand what you mean.
It's a tourist.
Expensive what?
Cost of food, cost of groceries, cost of hotels, cost of anything down in that area, as opposed
Where
to
where do you live?
Newberry or Lawrence.
I don't believe that groceries are any more expensive. I've spoken to the hotels that I've
Aren't the
spoken of. are no
brewers
more
gonna live
expensive.
there?
If you went to a fancy restaurant, they have
Yes.
more fancy restaurants certainly than most parts of the state
So
does.
you don't think the cost,
So that would cost more if you chose to do that.
you don't think the cost of living is higher in Charleston?
McDonald's is the same price in Charleston as anywhere else.
You listen to my question. You don't believe the cost of living is higher than Charleston than in
I'm
any
on
other area
mute.
of the state?
I
I
said,
believe
yeah,
that it
they're
is
from the
because
area.
the real estate price.
Wow.
What
It's so
the
funny.
hell?
Half-ass. I guess we
He's
can't have
right.
trials anymore because the traffic. Trials are all canceled.
Cracker
Think of-
Barrel and McDonald's. And if you go to the expensive restaurants, it's going to cost you more.
Mm-hmm.
Uh,
Typically.
I'll say this, Ange, regarding your comment here that they're not, they said they're not planning on sequestering the jury, so it's their cost to drive, eat,
But
and
they would
park.
go home.
Well, also, I can just say this because I have been called for jury duty in my city. I don't know if it's the same in Charleston, but we actually did not have to pay. Like they vouched our parking, like they gave us parking vouchers, so like we
Same
didn't
for
have
me.
to pay. But we did have obviously had to pay for our own food, but like that's with a lot of jury.
They don't pay for
like
our
area.
food. I mean, they pay
Yeah.
for our
My
food.
parking
They
was
fed us
paid.
lunch.
Oh, we only had like one. We had
Oh.
a Subway next to ours. It's pretty stupid, but
They fed us. Our parking was paid. We just showed up.
move
Went
it
to work.
move it to Texas. Fuck it. Why not?
You don't get. They didn't feed you, Llama.
No, we had to
I
go
didn't
pay
get
for it.
fed.
Like we got lunch break, but yeah, no.
No, wait,
I
wait.
was not
We
picked
had
for
to
a jury.
Okay, you don't. They don't pay if you're not picked. Once
was gonna
you're
say,
picked for the jury, that's only
just
for
be
jury
clear.
selection.
Just be clear, I was
I
not
was
picked.
picked.
I never did voir dire or anything. I just sat in a room for a whole fucking week. But I did not have to pay for parking. They left us vouchers. And
I was picked.
we were, if we showed up early, we had parking. If we showed up at a certain time, they could not guarantee that any prospective jurors would have, like we had to show up between a certain time frame because they wouldn't let other people in. So like we had a place to park. They were very kind to jurists. But I do understand it sucks.
Yeah.
But also whatever.
We got free parking. We had to pay for our food, but we were able to show our jury pass and we got half off. at any.
Wait a minute, you had to pay during your jury service?
Yes,
Or-
You're
Texas
getting
does
screwed
not
over.
provide food unless it's a death penalty case in Texas. You're
That's
not
very
given
specific.
food, but they
Well, here,
increase
they fed us.
what you get for your daily stipend, but they get you discounts.
Oh,
Did she just tear us?
I think so.
She
Which one
did.
of us are you talking to?
Bells.
Oh, Bells. Are you La Tara? I think you are La Tara. I'm
Just
O
La
Tara.
Tara.
You're La Tara. I just
But
realized
even when I got picked for the grand jury in Dallas, they told me, you had to do it for 6 months. We'll take care of your parking, but food is on your own. But we have a refrigerator, we have microwaves, you can bring your own food.
Yeah, like I said, all we really have is like right there is a Subway. You could walk a little further to Chipotle. There's some fancy restaurants, but like we don't have a lot of options. But it also, oh well, you could bring in your own food. That wasn't a
I
problem.
live in a
so.
little tinier place compared to where y'all live, and we had restaurants right down the street. They would walk us there during like jury duty, like during our breaks. They would walk us to the restaurant. They would bring us in there. We would order our food. We would sit there and eat during jury duty.
But how much did you get paid per day?
I don't remember. I don't know, because I was just shocked. I got a check at the end of it. I was like, "Whoa, they pay you for this?"
Mine was a whole
So
$75.
here, a lot of people will donate their daily pay.
Nah, you're gonna pay me.
I think we had the option. I was like, no, thanks.
I donated mine.
To who?
Oh, there.
I donated it to our local animal shelter.
Oh,
to save the
okay.
animals.
I donated it to my bank account.
Your bank account.
Oh my God, this is so wild and ridiculous.
I mean, the fact that they're arguing this and they're not sequestering people.
Yet, that's what they said. As of right
Yet.
now, they're not planning on it. I wouldn't be surprised if perhaps they do ask for that later. And I'm not saying they're going to be granted it, but I could almost tell you, because we know Poot very well, they're eventually going to argue it and they're going to bring up Becky Hill and all of that. And that they want a very fair jury later on when it gets closer. Mark my words. They're going to use it and they're going to argue it.
My understanding, if you're sequestered, you get 3 meals a day. Like if you're traveling for work, you get per diem. So if it's sequestered, you get breakfast, lunch, and dinner. And
Now,
no
whether or not that'll be
cocktails.
granted, I don't know, because it's very hard to get sequestered juries, but it does happen. But that is going to be an argument. They said, and
Why
I did
would you
say earlier,
sequester this jury when they know this case has been around for years? Why would you sequester people now?
Well, probably because of all the problems they had with the last jury
But
during
Becky,
this trial.
but even if they sequester, Becky was the problem.
Becky was
And
not
the
the only
egg
problem.
Jury.
The egg juror, the whole fucking
The
egg juror
Oh, we
scenario.
forgot about the egg juror lady.
Like they do have, I don't necessarily want to say that they're valid arguments, but they do have past experiences that are going to be what they're going to argue, and they are going to argue them.
Okay.
So what if it was like the Big
I
Brother
think
house?
if they sequester it, they should put cameras in every room like Big Brother to make sure they're not doing bad stuff.
Mary, have you ever seen Jury Duty on Amazon/Freebie? If not, you should.
I
Great, good
have,
stuff.
and it's great.
What a shit show this is. I'm living for it though. What are these buttons behind the chair mean? See those?
They push the button and the guy falls through the trap door.
Okay, let's keep going. Oh my gosh, this is crazy.
Prices are higher, so I don't believe is relevant here.
All right. You mentioned something about people going home on the weekends. So do you know if all of the prosecution team went home on the weekends, or do you know if they actually had to stay and work because they had the burden of proof for 6 weeks?
Yeah.
I have no idea what the prosecution team did over the weekend.
What kind of, that's your problem. That's your
That's-
job.
That's a you problem.
Sorry, government. I don't care who you are. I'm not going to feel sorry for you. That you should absolutely. The burden is on you, please. Thank you very much. Do you know we didn't get to see our families because the burden is on us? Yeah, it should be. You work for the fucking government. Stop it.
Okay. But if you're staying in a hotel, bring your spouse and kids. Let them hang out at the hotel during the day and play in the pool.
No, I don't think she'll sequester the jury either, but that they
I
are
don't think
going to argue it.
either.
Bet they will. Is that one of my dogs? No.
I mean, part of me.
Because, you would
thinks in
agree
this
that a
case they
complex
should.
trial is pretty
It'll be an interesting argument to have. That's for sure. They absolutely will.
much a 7-day-a-week job. Would you agree with that?
Oh, absolutely.
Let me ask you this. Charleston, you would agree, has a lot of tourism. Is that correct?
Yes.
It's probably the premier tourist
Okay.
destination in South Carolina, or one of them.
One of them, certainly.
I mean, it's a great place, right?
Yes.
Most historic city we have, right?
Yes.
Okay.
And Charleston has a lot of events. Is that correct?
What a lot means, there are several events during the year.
Okay. All right. And would you agree
What?
that
Okay.
the spring season is the busiest tourist time
Objection.
in downtown Charleston?
Does he work for the city of
It is.
Commerce?
Did you research that?
I would, the spring, the winter
Or Chamber of
is
Commerce.
less. Beyond that,
Uh-uh.
there are tourists pretty consistently through the year.
Did you look at the fact that the weekend prior to the trial being scheduled, then there's the 50th anniversary of the Cooper Bridge?
No.
No, I did not look at outside the
Would you agree that that brings a lot of traffic and a lot of people to the Charleston area?
No
Okay.
trials. There's tourists.
It brings people to the Charleston area who run the bridge.
Think of the bridges, people. Think of the bridges and the bridge. The 50th.
So
anniversary.
if the Super Bowl is happening in New
Forget about it.
Orleans, you cannot have trials
Court
because the Super Bowl's
canceled.
there. Or in
Bridge
Dallas.
celebration canceled. I'm sure these are probably valid arguments for the locale, but it is so funny
But
to hear
it's
these
not
words thrown
because trial.
out. Oh, think of the
How did they
bridges,
survive
Terry.
the first trial?
Nobody will be paying attention to the celebration of this bridge. They're all going to be preoccupied with Murdaugh. How is that fair?
Mary,
This is America.
I get it, but I've lived in Dallas for many years, and we didn't stop trials because we had all the different runs there.
Oh, that's true. Here, like downtown, shut off all summer long, where the courthouse is, for a ton of marathon races. Like every other fucking weekend, it is shut
But
down.
it's the
for some
weekend. Trials are
marathon.
not happening on the weekend.
Well, if you worked for the state, the burden is on you, Terry. Hello. Have you not been paying attention here? This is very inconvenient for the state. Very inconvenient. Just kidding. Oh, wow. This is something. Okay.
Bridge is closed for a few hours on the weekend. I don't know about traffic, but it brings people in, certainly.
Did you also
The bridge does bring people. Point of the bridge.
look at?
Oh, look,
the
somebody's coming up
fact
to show him
that,
stuff.
That very weekend as well, there's also the Credit One tennis tournament in the area as well.
No, that's not anywhere near the area we're talking
You don't think
about.
that affects the traffic in downtown Charleston? Or in the Charleston area?
I've been to that tournament before. It's in Daniel Island. It's nowhere near. It does not affect.
Oh, no,
the Broad
Mary.
Street downtown area.
Would you agree that that same weekend?
Don't
also
drink and
Flower
quilt.
Town in Somerville?
It's not safe for who?
Somerville is very, very far away. I don't know what happens in Somerville.
So
It's the
It's a different city and
weekend.
different county.
as a Charlestonian, you would not say that that particular weekend in particular, much less April and May, are not busiest tourist times with the most influx of people than probably the rest of the year. You wouldn't agree with that?
No.
Okay.
No.
All right.
I mean, you can ask Amy and
So you-
Annie, who came and visited me this weekend because the Ohio State Fair was going on, which is a huge deal. Like 1 million people go to this fair in 2 weeks. It is a huge deal.
Did you have any
And all I-
problems?
No, all you have to do is avoid one highway throughout the entire city where everything happens, where all the traffic is, and you can move about freely throughout the entire city. You just don't go to that area during that time. It's pretty easy. Again, though, I will say, Columbus is a newer city with lots of space. All right. We actually
know,
have a
but
very large square mile footage for a
I
city,
know, but
but
I was
still.
born and raised in Houston, then lived in Dallas, and we have huge events. And now I live in Austin, and we have South by Southwest. Traffic is a bit much, but if you stay downtown, you can still walk everywhere.
Our downtown is
It's not
dead
a problem.
all the time. Actually, downtown traffic only sucks at around 8:30 in the morning, and that's it.
Now, if we were to go to LA, I would have a different conversation.
I mean, maybe traffic sucks there. I don't know. I've never been there, so don't know.
I really want to go on a road trip with y'all. I bet y'all would be super fun to hang out with.
You could be our driver.
That's hilarious.
Because you would be
Do
our
you know what
designated driver.
Yeah, that you're better off getting behind the wheel intoxicated. I'm not a good driver.
She rode
I
with
just have to
elbow
tell
feet,
y'all,
though.
I just got a text message that cracks me up. Mama, you've been going for hours and hours.
We're champs. All right. We're trying to learn more about Charleston, South Carolina. Okay. This is law. This is a very
She's
serious
having
court hearing.
fun hanging out with the other TTs. Okay.
So, guys,
Columbus is
just so
weird
y'all
name for
all
it.
know, I am going and I am going to start finding accommodations for us.
Okay. All right. Well, we're not that old of a city. I mean, actually, we're not the original capital of Ohio. Anyway, we'll get into Llama learns about it sometime. Anyway. Okay. I guess I understand we're over 200 years. Oh, geez. Never mind. We're not getting into it. Let's get back to Charleston and the bridge. Okay. It's a big deal.
We have a personal tour guide. So,
That's right. That's right.
just so you know, Lig could
Seaweed would be
probably
one of
meet us in Charleston.
Oh, nice. Yes, she could.
Party.
Maybe Mr. Barber will show us around the city. He seems to know a lot. He's the expert of Charleston, South Carolina. I can't believe this is happening, but okay.
Yeah. It's a slog, ain't it?
So I just have to ask Mary, is it a Subaru or a Lesbaru? Because you typed in Lesbaru.
Subarus are Lesbarus, and they're excellent cars.
Oh, are
If you're
they?
going to buy a car, get a
I was gonna say, I love
Subaru.
Subarus, but I didn't know they were called Lesbarus.
Yes, because a lot of lesbians own Subarus. Why? Because they know how to invest their money in good stuff. That's why. But I only know that
Mary.
because I used to have a Subaru,
They're
and
Lesbarus? I have
Sai's
never
dad
heard that.
would
They're so
always call
cute.
that, and I loved wearing flannel. So, but yes, if you're going to buy a
Isn't she
car,
adorable?
buy a
She's so
Subaru.
pretty.
Mhm.
You
Go ahead,
are.
ask anybody.
See,
True.
Lady in Gray has a Subaru, and she's not a lesbian. I know a lot of people that have Subarus, and they're not lesbian.
We
That's why I
know
was
that.
shocked
That's
with that.
not what that means. My God.
It is just a joke, guys. It's a joke.
Okay, I just swear.
By the way, yes, whatever car you own defines your sexuality, obviously.
What does the Buick say about me?
You got a dried up Grand Heap. Hoo-ha. That's
Okay,
what
but
that means.
isn't that part of Lincoln? Because if so, then you're all right, all right, all right.
Oh, is that it? No, I still think
Because he's a
so.
spokesperson for that.
Oh, is he?
Lainey,
like
you
Yes.
need to secure a gig there sometime during the 6 weeks and come hang out with us.
Absolutely. All right, let's get back into this because we're
Let's
never
get
going to
back to
finish it.
Wait,
I love
which one
Subarus.
would be?
They're fantastic, and lesbians have great ideas.
You would agree that the state has an obligation to try its best to be good stewards of taxpayer money. Would you agree with that?
Yes.
And you would also agree that the statute specifically states that in considering venue changes, that what must be considered is the logistics and expense, and that at least one of those, the most convenient one of those should be chosen. You agree with that too, don't you?
No, you added on what should be chosen. I do not agree that the state of South Carolina cannot afford to try a case in Charleston, South Carolina.
But you don't agree that section 172185 says that in making a determination whether to proceed as allowed by this section or to order a change of venue for trial, the court shall consider all the logistical and expense elements and consistent with the demands of justice, choose the method that results in the least expense and greatest convenience for all parties. You don't agree that that's what the statute says?
It's
objective.
Man, I missed it.
All right.
Alec
And I
looked like he was
understand
sleeping.
this is within the interest of justice.
Look at his face, like, I don't know what the fuck is going on right now.
I know, but if
This
you
is
back it
so
up,
weird.
he was like sleeping.
Because this is ludicrous. Also, has the state suggested where they wanted to go? Like, at all? I don't think they put in a suggestion, but they're just like, Charleston, fuck no. That city is trash. It's not good enough for our trial. That's not their words, but that's pretty much what they were saying.
Has anyone Googled to see if Charleston has ever handled a major trial before like
Yes,
this?
they just said they handled 2
I
major
know, but
trials.
I'm
I didn't know the first one,
us
but Dylan
individually.
Roof. But Dylan Roof, the federal trial for him, he was the white kid who shot up the black church. Remember that?
Oh
hate
yes,
crime?
I for-
Yes,
I
that was
thought
a
that was
very
North Carolina.
no. That was a very. I mean, talk about a
That
high
was big.
profile case.
They can handle
So
Murdaugh.
they're fine. Yeah, that's what I'm saying. Like that was talk about a very contentious case and protest, all sorts of things going on there. So yeah, they can handle it. I don't know why it must be very far from where Creighton is, maybe. I don't understand his arguments for these because it sounds like Colton County is out of the picture on both sides.
Okay, Buffy's laughing, so there's something
know.
that's coming up.
I guess.
Yes, Lainey, you're
Act-
hearing my goats
Actually,
yelling.
Oh, what's the mail? That's elbow feet. Sounds like a goat or sheep.
Oh, I thought it was my goats because my goats are at my window because they're wondering why they're not being fed.
Well,
So
I didn't
thought it
hear
was the
them.
goat.
No,
It
I
could
knew it
be.
was
I
elbow
did.
feet, and that's why I started laughing.
Okay,
People think you sound like a goat or sheep, babe.
because I was texting Double H and I said, could you get the boys in the back 40 and out of the yard?
Nope. It's just my own personal goat who lives in my house, who's also elbow feet. He does
It's
a
my
great goat
raspy
impression,
smoker
though.
voice.
That's it. That's it. Oh my goodness. Okay, let's keep going.
Let's go.
That Charleston is one of the most logistically challenging counties in all of South Carolina.
Absolutely not.
Disagree?
Absolutely.
All right. And would you agree that Charleston, downtown Charleston, is one of the most expensive areas in all of South Carolina?
Okay.
Again, that's a very difficult question to answer when you're not saying what's being purchased.
Food.
No, it's expensive.
Depends on where you buy your food. As I said earlier, the same places cost the same amount of money. There's plenty of food.
Okay.
McDonald's doesn't cost any more. The fast food costs what fast food costs. If you go to one of the many
Bullshit.
expensive restaurants, it will be expensive.
So it's your testimony here today that spending weeks down in downtown Charleston would result in no greater expense than if you were in many of the other counties of the state.
Exactly.
Absolutely. And to your earlier question about logistical difficulty, the logistically difficult counties are the counties that don't have the infrastructure to support the trial. You know, there was no place to eat. There's no place for us to stay, for example, in Walterboro, right? There were no hotels. There were hardly any restaurants. You know, you were bumping. There was a
Stay in an
huge crowd.
Airbnb,
That's why they had the
cook your
food
own
trucks
food.
come out. Those were the logistical difficulties. I eat lunch in downtown Charleston every day. If you want to get a sandwich, it costs what a sandwich costs. It is not especially expensive.
Agreed. Oops, sorry.
Let me ask you one last question.
Sorry. Bells, my McDonald's is cheaper than yours.
That's wild. But
Would you
also, stop
agree-
fucking eating at McDonald's. It's garbage and it's trash. It costs way too much
They
for
have
it being
really
trash. That's all
good
I'm saying. Nope,
oatmeal.
it's trash.
You don't
Oatmeal.
tell me
I
what to
love
do
their
with my
oatmeal.
life, okay?
I'm
You
going
just
to.
And I'm
don't.
like, I
You gonna do
love
it
their
for me?
freaking oatmeal. It's got fruit. It's got raisins.
You
Okay.
don't get to decide what kind of trash I put in my body. I put all kind of trash in my
Exactly.
body.
Thank
Well,
you,
it's trash.
Buffy. Thank you.
I'm very. I don't like McDonald's. I like nothing about it. French fries, get out of here. They're not that great. Anyway,
Oh my God. their
and
french
now we
fries are
lose
great.
20 subscribers because of Llama.
Okay, wait a minute. Buffy and I agree. Pause this shit. What are
It
you
is.
saying? McDonald's doesn't have good French fries.
Not really. Compared to what Wendy, any of the other one? Pick one.
Wendy's
Any
are
other place
soggy,
except Burger King. Burger King
soggy
has
and
the worst.
mushy fries.
Okay, maybe it's because you don't live in the South, but our French
Yeah.
fries.
Oh, maybe it's because y'all don't live in fucking Ohio where Wendy's is from. Maybe that's it.
Yeah,
Where
because
we
we
have
get
good.
soggy, mushy fries from
Hmm.
Wendy's. I don't care for Wendy's
How
fries.
many of your favorite
Yeah,
restaurants
McDonald's.
that you eat at come from Ohio? Anybody?
I will go to McDonald's just get French fries.
Mm-hmm.
No, thank you.
Llama, you need to come to visit us. I'm just saying.
Okay.
You need to learn
To
what
go to
the real
McDonald's,
world
you know
is
how
like.
pissed I'm gonna be. I came all this way and you're taking me to McDonald's.
I
my
will
least favorite.
serve you McDonald's French fries, and you'll think we cook them, and you'll be like, "Damn, these fries are good."
If I take you to New Orleans, I'm not feeding you McDonald's.
No, you're not going to McDonald's in New Orleans. No.
As I said, I always have unpopular opinions, and it's fine. I stand by them. I said
That's okay.
what
We
I
can turn
said.
you.
I don't
We
think
can
you
turn
can,
you.
girl, but you don't know how stubborn I am.
Give me time.
See, Lainey's on my side. Thank you. Vindicated. There's dozens of us, Lainey. Dozens.
She did that wrong. She put the shit. Wendy's is shit. Was
Shit.
perfectly
Rude.
fine.
Rude.
I mean, they have. I like their Frosties, and I will say their chicken nuggets are better than McDonald's chicken nuggets because they're real chicken.
They're all gross.
We're gonna
Okay,
have
let's get
fast
back
food
to
wars
this
in the
crap.
comments if anybody ever makes it this far into the replay.
We'll just keep going with the
That
trial.
The United States District Court for the District of South Carolina recognizes the high cost of Charleston lodging in its reimbursement schedule and has a price of $380 per night, by far the greatest in Charleston from March through May. Would you agree with that?
I have not looked at the GSA
$380
schedule for their per diem.
Or you wouldn't dispute what I
380.
what I just told you.
He just said, okay, but did he say that the state allows up to $380 a night? And you're saying that there's nowhere in Charleston you can stay for less than 300. Do you know what kind of
No,
butts
but
are?
their per diem includes food and lodging and parking.
You can go to the grocery store. Figure it out like us poor people do. You're fine. You're not going to starve to death, I promise.
Jackson and Yannetti and all them stuff, they cooked in their Airbnb.
Mm-hmm. Grow up, state. Just kidding. But seriously, that's a really weird argument. $380 is all we get a day. What? B has to work, Elbafy has to work away. He gets like $75 diem, including all of his stuff. And they're whining about $380 a day.
Okay, you need to have Elbow Feet reach out to me and help him renegotiate that.
Ugh, I know. Don't get me started. Anyway, I'm just saying, I think that's wild to me. Live like the rest of us. Just kidding. Anyway.
Would you just say no? I'm not going to offer an opinion on what I would or wouldn't dispute. I haven't even seen it.
So you don't know, being a lawyer in downtown Charleston, that they reimburse by far the most during March through May in Charleston than anywhere.
What I know, based on being a downtown lawyer, is what it cost me to go get a sandwich.
Wait, hold on. Before we get into Sandwich Gate, they reimburse the most between March and May, which is when your fucking trial is. And you're like, buddy, it's only $380. What? Did I just hear that
But
correctly?
can I ask why you're asking someone who lives there locally and it's an everyday occurrence. So to him, it's everyday expense. But when you go and look at like LA, then you're like, oh shit, that's expensive. It's his everyday cost. So he
There's
thinks it's
also
normal.
no way that it can be that big of a difference. I refuse to believe that as someone who has lived in the city for 20 years and also visits outside of the city. As a matter of fact, you want to talk about groceries? I get better deals on groceries than my family back home who live in a rural town where all they have is a fucking Walmart and a Kroger because all their
Well,
local places are gone. So there's actually
I
more
will
competition in bigger cities for better prices than there are in smaller ones. So
not always, because
there.
we lived up in the Bay Area and it costs more here
Okay,
for
but you're
me to get an
talking
avocado and stuff.
from California? Like, I'm sorry, you
From
said in
California, it is
Texas.
cheaper in Texas for me to buy fruit
Yeah.
and produce than it is in California.
Well, yeah, because it's fucking California. You
I know,
can't
but
compare California to anywhere else in this. I mean, that's just a fact. You can't. It's
my
like a
wine's
whole
cheaper in
different place.
California too.
Well, because they also have a lot of wineries, so it's a local thing. But in fairness, in most of the other states, particularly
But
smaller ones,
Charleston,
it's pretty average.
Charleston is a huge tourist area, and my friend, my gay that lives outside of the city, he's like, it costs more than Texas. So I've
For
not been
what?
there, but I'm going with him. He just says the prices are more expensive there.
Of what though? Houses?
I
Yes.
don't know.
We were looking at new places to live, and it was $1,600 a month for what is. When I saw the location, I was like, "What? Are you
I am
kidding me? It's for
texting
here?
him
Like
right
the
now
worst
to
place."
ask.
I think the price of housing is atrocious, but other stuff, it's no better than back at home here in Ohio. I don't know elsewhere, but it's not like we're living large in fucking Ohio. So there's that.
I know how long it takes to get to the office. I know how long it takes when I pass the hotels. I know what those hotels cost because I just put somebody up in one of them. That's what I know from personal experience.
Right. Nothing further, Your Honor.
Briefly, Mr. Harpilian.
Nothing.
Barbara, you heard the Attorney General ask you specifically compared to Newberry and Lawrence, right?
Right, Newberry.
Newberry and Lawrence. Newberry County has the same number of population as Carlton County, right?
Yes, we
Very small.
39,000 some people
Ooh.
in each county.
Okay. And Lawrence is even smaller.
That's small.
So based on our experience in Carlton County, is your opinion, having been through that there would be sufficient jury members after we go through all the, and remember now, that was before the conviction, before the movies, before the 6 books. Would that have an impact on our ability to obtain a jury in either one of those jurisdictions? Do you have an opinion as to whether or not there be sufficient jurors?
I think it's common sense that when you have a jury pool that is 10, more than 10, I think that would be 11 or 12 times bigger in a county, that you are proportionally 11 or 12 times more likely to be able to pull a jury. And I would also think that those considerations would
Is it?
carry more weight in picking a venue than it's how much the prosecution has to pay for Hampton Inn.
And do you understand that the solicitor for those 2 counties is Mr. Stumbo, who will be the new Attorney General in January, and his boss, and has been the elected solicitor from those counties for about 20 years. Do you understand that?
All of that, except I didn't know it had been 20 years.
And that he would have had the ability to, running for re-election, to have a much more knowledgeable and relationship with jurors than we would ever have, than Mr. Murdaugh. In other words, it would be home cooking to have him.
Wait, so their
doing it.
argument is that the future Attorney General of all of South Carolina, these are their home places, and they're going to have much bigger pull for the state? And you're talking about, I need to move this for a fair trial. What kind of fucking argument is this? This is not a good. How is that saying that's a fair? Oh no. Okay.
And why is an attorney
Are they drunk?
on the stand giving this kind of information?
I don't know. But okay.
Somebody from the Chamber Economic Development Board, but an attorney?
It's like, hello there. I don't know.
us.
Ryan is weird.
Those counties, don't you think?
Okay, so
I honestly don't know what happens. I've never driven through Lawrence, but I would assume that the local prosecutor, who's been there for 20 years, has tremendous knowledge of the local population.
Okay. Thank you. I have
Okay.
no further questions.
Nothing further,
All
Your
right.
Honor. would like to commend Mr. Harpootlian on going ahead and conceding the election, the general election in November.
Can I excuse this witness?
Yes, ma'am, Your Honor.
All right. Now, let me ask y'all something, because
He
here
did
we
not
are talking about
stop.
counties and where we're going. Am I correct in assuming that y'all have agreed to transfer venue from Colleton County, and not only from Colleton County, but out of the circuit?
No, Your Honor, we have not agreed to that as our motion states.
Oh,
And-
okay.
And again, I don't want to jump the gun. I'm responding to Your Honor's direct question. But of course, our point was we actually tried to negotiate without conceding anything, and we're essentially told Charleston. And there were no other counties
What?
that they were willing to consider.
So are you telling me that you would have conceded had they picked somewhere else?
I said, just as I said in my motion, that I'm always happy to
I
have
said what?
a reasonable
happy.
discussion. What I can't
First
do
time.
is
First
just have
time.
the defense dictate.
No, I think
the
this
most
is the third
expensive and
time.
What we consider the most logistically difficult county
He
in the
has
state. That's the point that we're making.
not
And then I
added
think I put in my
happy
motion
in
as
front of
well.
it.
We're happy
one
to
I
have
have.
discussions.
There's another one.
Absolutely. The state has an interest in picking a fair and impartial jury as much as the defense. And despite what he says, the state is entitled to a fair trial as well. That says in our appellate opinions all the time. I want to get somewhere where we can get 12 in a box and get a process that win, lose, or draw is going to be one that sticks. And that's the state's goal.
Okay, but you haven't offered any other
Based on his
place?
filings and our discussions, I'd assumed that we were going to leave the 14th Circuit. First of all, if you want me to walk through the rationale Judge Kelly had in his order he issued yesterday, I'll be happy to do that. But I think our filings make it very clear.
I've read your motion. I read your memorandum in support, and then I read the state's response.
She's like, please don't
Then
say
I
it
read
again.
your response again that you filed with the court. I've read it all. But if you would put your position on the record for
I've
me.
only let this happen because
Well,
it's
the
weird as
14th
fuck.
Circuit, which is Colleton, Jasper,
She's like, I was bored.
Beaufort, and Allendale, is where the defendant is from, where his law firm has operated for 100 years. The Murdaugh name is well known throughout that entire circuit. And so that circuit, the movies that were filmed, the 5 movies that were filmed in Colleton, Jasper, and Beaufort. The Murdaugh case is a local freak show.
I can hear B.
You have people being interviewed on the street in all those counties, commenting on whether they thought he was guilty or not, or whether this happened or that happened. I mean, it was so outrageous that Buster Murdaugh is suing Netflix for accusing him of murder. That's a civil case that's going on.
He is, and we will be covering that
So,
lawsuit eventually, I promise.
There's no, I mean, do we have the money to have some sort of poll or do what they did in the Parker case? No. And that's why I want to rely on what they found in terms of their ability, Parker's ability, to get a fair trial in this community that's permeated with this pretrial publicity, the movies, the books, 6 books on this, and many written, a couple of them written by folks down there other than the clerk. So,
And I also read in your motion, Mr. Harpootlian, that there were fewer than, correct me if I'm wrong, fewer than 1 in 7 prospective jurors were qualified to serve. That was during the first trial.
correct. Before the conviction, before the movies,
Exactly.
before the books,
And before Becky Hill,
before Becky Hill.
which is something totally different, but also very prejudicial to the defendant, would you not
Becky
say?
Hill, shout
Your
out.
Honor, I concur completely. And so Carlton County is poison. I don't think he, with a straight face, the state would argue that we should go back to Carlton County. The courthouse, no offense to my friend the clerk over here, but the courthouse is the scene of the crime. We can't go back there. So once you get that out, Allendale and Jasper are smaller than Carlton County. In 1 out of 7, if that, and I think that's probably what's going to happen in that entire circuit. Beaufort, Beaufort is a county where their firm operated. He's well known, and he's a local guy, and so he's vilified. He's convicted of murdering his wife and child.
Well, it's been overturned.
Horrendous. Stealing $12 million. Horrendous. And so, but he's entitled to a jury that can put all that aside.
I respectfully disagree.
And base their verdict on what you tell them and what the witnesses say. And that ain't going to happen in the 14th Circuit. That ain't definitely ain't going to happen in Carlton County. And it would be an exercise in futility to go down there, set up all the infrastructure, and try to pick a jury. Right. You know, after 3 or 4 weeks of not being able to get a jury, or people, you know, most normal people would run like a scalded dog from this case, because it could be 3 weeks taken away from their, we're not moving for sequestration.
Run from a skull of a dog. What does that even mean? What?
No, he said they would run like a scalded dog.
Oh,
That means a
I was like, a skull from a dog. What are you
Harry
talking?
and I will be your Southern
Southern
interpreters.
Translator.
I'm like, doesn't mean what you think it means. Just, yeah.
Scalded dog. That makes a lot more sense than skull of
You know,
a dog.
Mama, bless your heart.
Thank
That's all I
you.
gotta say. Bless your heart.
Thank you. It's the Southern version of you are so pretty. It's much
It
nicer.
is.
I don't
We
get
can't help it. You guys are wrong.
because we don't say weird shit like run like a scalded dog.
If you burn a dog, it's gonna run fast and far. That's the explanation of the saying. You
I think if you
a
burn
dog, it runs.
anything, anything,
that's
not
not-
even dog specific.
Okay, well, you can interchange the animal. If you don't like that one, pick another animal.
A scalded llama.
It's gonna run like a scalded llama.
A skull, a skull of a llama.
No, a scalded. Oh. Bless your heart. That's all I got.
Oh, I know what scalded means. Okay, Mary. Okay, but only one of us has raccoons. That's me. That's Ohio. I love you, South Carolina.
At this point anyway, taken away from their family and their jobs. No rational person wants on this jury. And that's going to be tough, especially in that community. And now I'm not telling you that we go to, and we say Charleston, that there won't be a huge number of people who know about it and have made up their minds. But if you have a
Well,
potential,
that's due to all the publicity.
due to all the publicity, you know, it's just that we're going to have a huge. We went through 400 jurors in the Gaskins case, 400 before we could get 12, and it took 4 weeks.
25 years ago.
And so I've watched this process, and if Your Honor's voir dire is as incisive as I believe it will be, folks will come off the, well, you know, yeah, I think he's guilty, but you know, I
think it's
going
gonna
to
take 2 weeks.
or I know all about the case. I watched all the movies. I've read all the books, but you know, I can put that aside. I mean, that just doesn't. I mean, somebody like that should not be allowed on the jury, and we're going to see many, many, many more of those than we saw in Carlton County 5 years ago. Now, their counter is Charleston's too expensive. There's no evidence in that record that you can't get accommodations within 15 minutes of the courthouse that are the same as you pay in Gaffney. That's number one. Number two, convenience to getting there, it's 15 minutes. Number three, he says, well, we don't know we're going to have parking allocated by the clerk down there or by the court. You know, this morning, Mr. Waters and I drove into, we had two reserved, I think he may have had more, two reserved parking places right out in front of the courthouse. It happens.
Me too, like.
That's what happens. So yes, they can accommodate the parking, the drive, cheap hotels. I mean, he's asking, and by the way, if it did cost a little bit more, let's say it did, he has a right to at least have access to jurors who haven't made up their mind, who have read about it perhaps, and could honestly say to you, you know, I haven't made up my mind. I'll listen to you and the witnesses and follow the charge. And that's the acid test, not whether you're going to have to pay $20 a night more a night there than you would in Newberry.
Why is it a giant piece that looks like a butt?
Prosecuting a case, or Lawrence. I mean, it's, and of course, we would say to you, we need a big county, not a small county. We need a big county. So you're basically limited to Greenville, Columbia, and Charleston in terms of the jury pool. Greenville, for all the witnesses, would be, every witness would have to spend the night. Carlton is 45 minutes, Walter was 45 minutes away from Charleston.
Harry, put this water tower on our list of places to see.
So there's the cost of putting witnesses up is gone. If you have an expert witness coming in, very easy to get them into. I mean, of course, we had the problem in Walterboro, no airport. They had to fly into Charleston, drive down, fly into Savannah, drive up. So you need someplace that has good access to airports, because we're going to have several out-of-state experts.
Both sides.
I'm not sure what experts they're going to use.
I would
So
prefer to
Greenville
fly into
logistically doesn't work. And by the way, if you're going to stay at a Days Inn in Greenville, they're charging the same price in Mount Pleasant.
Okay, I like
Same
Spartanburg.
price. And of course, if you are looking for a jury pool where you can find those 12 or 14, however many alternates you're going to have, the bigger the panel.
I suggest more than
easier that will
14.
be. If you use that 7%, let's say it's 5%. If you summons 1,000 jurors, which you could do in Greenville or Charleston or Columbia, and 5% are qualified, that's 50. We can get a jury out of 50 people. But you go to one of these small counties, you can't get I bet you can't get 1,000 jurors to show up.
True. Are there even
In my
1,000
experience,
people
the rural counties are
eligible
a
to
little
be
less
jurors?
willing to come in, and they don't want to be gone for 3 weeks or 2 weeks from their jobs. And I mean, it's going to be tough. Getting a jury in this case is going to be extraordinarily difficult. Why make it more difficult by limiting your choices? Why make it more difficult? Because, and again, there's no tactical advantage to us in Charleston. He's not from Charleston. I'm not from Charleston. The Charleston is going to give us a larger jury pool. It's more accessible to 30 or 40 witnesses in this case from Carleton County. So when you look at the cases on this issue, they all come back, and I understand they have a right to a fair trial too, but he has a Sixth Amendment right to a fair trial. And that Sixth Amendment right means, and let me say this to you, you know what else you get with Charleston? No appeal. I'm putting on the record, if you give us Charleston, we will not appeal the venue issue.
We won't appeal the venue issue.
Will you put that in writing?
Not that
You're requesting the change of venue.
I know.
Just want to make sure that I've got that right.
Okay, well, if you deny the motion for change of venue, we're going back to Carleton. So I don't really think, correct me if I'm wrong, that is a viable alternative. I think we've got to move it somewhere. And we're suggesting Charleston because we think that will be the most expeditious way to get a jury that truly has not made up their mind.
Okay.
Now,
Hey,
he's
Lana,
arguing cost.
I don't know if you're where you can pause this.
Trying to get Mr. Barber to say it's Charleston is expensive. And when I'm
not.
there,
Give me just 30 seconds.
not on business, well, sometimes on business too, I stay at really nice hotels and eat in really nice restaurants. But we won't be for this. He's broke. He hadn't
No,
had a
he's
job
not.
in
The
4
money's
years.
hidden.
He's a
And
broke
if he did
bitch.
have a job, the feds or the state would be seizing the money. So, and we have
Hold on.
and let me say this,
Sorry.
we have an office in Charleston within walking distance of the courthouse.
Oh, there, and the truth shall set you free. Sorry, I was not within walking distance or
But
pausing distance.
didn't I, because I don't have my notes from the appeal hearing,
Mhm.
didn't they, when they talked about the hearing at the appeal, they talked about how nice the courtroom was, how great security was, and how great it would be to have the trial there and how well they could handle it?
You mean for the courtroom they're in now?
Yeah.
Yes, they did. They did talk about that. But I'm thinking that Lexington, I don't know if this is true or not because nobody's confirmed. I feel like it might be in the same circuit that they were referring
Oh,
to.
and
They
they're
keep bringing up
wanting.
circuit. I
Okay.
think it's part of the 14th. And that's why it's easily been moved to Lexington because it's part of that. Circuits are very confusing to me. I don't
They are.
quite understand them. But I think that is why Lexington, because I believe this is Lexington County or something along those lines, it is not on the table
No, it's
because of
city.
that.
I don't think it's the county.
Well, the county itself is going to be part of the circuit.
Yeah. Yeah.
So city, county, Lexington County. Oh, Lexington County. So that
And
could
I am
be.
going to address this comment because it's from my family member. By the way, he did not get off on a technicality, Brett.
Mm-mm.
And I agree with you. A lot of time lawyers are the problem. I am not saying he's not guilty, but I am saying he did not get a fair trial because we had a court person get involved
An
with
elected
the
official.
jurors. I don't care how guilty the person is, they deserve a fair trial.
That's why I said you can thank Becky Hill for that.
Mm-hmm.
Yeah. So
Mm-hmm.
I just had to call that out because I'm texting with him on the side here. And
Oh,
I can always drop by and say hi, but I wanted him to know.
still hi.
That
Thank you. We
is
do like
my
differing
nephew.
opinions, but that
Yeah,
is
he
that
is
is the
the
case.
that is the case.
It's
And he probably
it's
he doesn't
Becky
follow
Hill who got
crime,
that for him.
doesn't follow this. So it
Okay,
is
so Angie
Becky
said
Hill.
yes. Lexington
It's in the
County is
14th
part
circuit.
of the 14th circuit, and
Okay,
they
that's
are
what I
trying to
thought.
move it out of that. Because I wondered the same thing, but I was like, oh, maybe
Now,
that's the reason why.
because I'm uneducated, if they move it to a different circuit, do we get a different judge or does she
No,
just go to that court? Okay,
she'll go
that's
to
what I
that one.
thought,
Yes.
but I just wanted to
For
make
example,
sure that
Judge Newman was not a presiding judge over Colton County at all. He was an outside judge brought in. So judges can go to the different counties within a state. Normally
I
they
knew they
try to
could
stay in
in
their home
counties,
spots, but yes,
but they can go to a different district.
I believe so. Yeah.
Okay.
I don't know 100%, but I believe
So I
that to
said
be true.
that's what
Um,
I
just like
thought
you
you had to
can,
stay within your circuit, but you could cross
no,
county.
there
Okay.
are specialty, like she was assigned this by the Supreme Court.
Right.
This
So
was not
she
just
will
some
stay no matter
rando.
what.
The Supreme Court assigned this judge to the case, and she will most likely stay with this case no matter where it goes. And just like not only the judge, they can bring a jury from a whole different. They could bring them from the
Different, right.
clear other side of North Carolina or South Carolina. I'm
And they
sorry,
bust them
and
in.
bring them in. That can happen too. It's harder and more of a problem to do that than it is to move all of these people to where the jurors are, right? Because these, attorneys and whatever, all of them, they're used to traveling and being away and they
Right.
understand. Whereas, like civilian people, it really does come to a great
Yes.
cost to a lot of people to serve on juries, daycare, children, all of the above. So they try not to do that, but they can. So
So
there's that.
I am going to ask an uneducated question, but it's one I need to know. Because some cases are so huge in a state. Have they ever moved one to a different state?
No, they can't.
Because
I don't
I
believe they
don't think
can.
they have.
I don't believe they can because again, this is the state bringing charges
Yeah,
against
that's
a
what I
person.
thought, but I just wanted
Um,
to make
I have
sure.
never heard of. I'm not saying that it's not the case, but I've never heard of it, and it doesn't make a lot of sense.
I mean, I
Um,
just think because Texas, Oklahoma, Louisiana, we're so close. And if you're on that border
mhm.
and there is so much, like, say, if you are in Lake Charles and it is so big and you need to pick somewhere else, could they pick to come over to Beaumont
No, and the reason
and
too
change?
is because it's supposed to be a jury of your peers, which means people who live in that state. All right, so that would be the
Okay.
argument, one of the many arguments had there, but no, I don't believe that's at all possible to do. And again, here's the thing: everybody has heard about Murdaugh. Okay, you can
Oh,
hear about the case. That is fine. And that's with any case, right? But you have to be able to
right.
set your personal feelings aside and listen to the evidence and then decide. I think that I was very impressed last time that they picked a jury in like 2, 3 days, which is wild. But
I was shocked.
For Karen Reed's second trial, it was 20 days. I think it started April 1st or April 2nd, and the trial started on the 22nd. It took almost 2.5 weeks to see the jury. And that's in
But
Boston.
can I play devil's advocate thinking about Becky? Did
Well,
they
that's why they
pick a
went fast.
jury so fast because of Becky?
I think perhaps that's one of the arguments Poop brought up was we don't know who was removed before they came in. Because apparently that was Becky's job. I don't really know how that whole process works to really say if that's how it's done everywhere.
Okay.
I think that I don't know. I have a lot of opinions about the jury in this case. I thought they came back in 30 minutes with a guilty plea or a guilty
I do.
verdict,
And
and I thought that was way
jury
too
selection was
short.
too fast.
No, I'm talking about the verdict itself
I know,
was
but I mean the whole trial. They picked a jury very
yeah.
fast. The jury came back.
Mhm. Yeah. The state has a right to a fair trial. Is it fair to the state to have the trial in Poot's backyard? Just asking to be fair and all. Yeah, but at the same time, remember that these are state DAs. Creighton Waters is a state district guy. All right. He is not your local county prosecutor. So in fairness here, all right, we are dealing with a different caliber of prosecutors. Okay. So just in fairness, and yes, the state sure deserves
Is
a
that
fair
elbow
trial as
feet?
well. Yes, that is elbow
Is that
feet.
elbow
He was
feet?
being very loud
Tell
and
elbow
not listening
feet
to
if
me.
he's not singing the tick song, he needs to be quieter.
He does. He's
I
a
love you,
little.
elbow feet.
We love you, elbow feet, but my goodness, he's not even listening to me. So that's fine. He apparently can't hear me through his
Lainey,
microphone.
he just needs to. Yeah, we need to find a mute mic for elbow feet. I love elbow feet, but
He's very loud.
Go back to baseball bat if you've got extra baseball.
He's very loud.
go back to the baseball
But-
bat because that's where you need to deal with
Are you
it.
holding axes right?
I'm like getting ready to pick up my phone and text elbow feet and be like, "Hey, dude."
About that baseball bat. Anyway, yeah, so I think no matter what, they cannot have it in that same area. I think both sides do agree on that based on what happened before, because not only do you have to factor in, have they heard of Alex Murdaugh? You also have to factor in, have they heard about Becky Hill? Because
Right.
if you keep it in that area, you could have people who knew Becky Hill that would
Right.
want some form of
Of revenge.
justification
Right.
or whatever. And I'm not yes, people shouldn't be like that. I understand that. But
But we are
humans
petty. Come
are
on.
complicated.
We're petty.
Okay.
We're petty.
Right. So, we'll see. I do think moving it is the best thing. I do think that's going to happen no matter what. Where? I don't know. I'm not from the area. I do think a bigger city is a better choice, because they do deal with higher profile cases, are usually held in capital big cities, if you will. So they're
Mhm.
used to these sort of things, and so is the staff. I know staff is a lot of places. What Becky Hill did is, quite frankly, yes, a one-off. There are
It is a
many,
one-off.
many clerks of the court who would never, ever do that. They take their positions very
Oh.
seriously, as they should. It is not very often you hear about this ever occurring,
I
ever.
have never heard about it. Lady
No.
in Gray YouTube is sucketh.
Why?
And I'm like, I need to know why. And I have to tell y'all,
Well, Lady
I
in
am
Gray, for a 6-week trial, you think 30 minutes was enough for them to consider all the different pieces of evidence?
no, that was too
No.
fast.
I mean,
Now,
well, listen, I will say this, when a
if they
jury
came
goes back,
in, but
they
if they
must have all
came in
agreed.
with video evidence of the shooting and much more physical evidence, I could see 30 minutes.
I'll say this, it was quicker than I would have expected. I thought that
Yeah.
day when the verdict came in, it would have been later on in the evening. Within
Mhm.
30 minutes after sitting them back that's pretty unprecedented in a lot of murder cases that even we've watched together,
Yes.
where we're like, "What? An hour and 15
What?
minutes?" You know? So yes, they could have came to that conclusion. No, a jury is not obligated to sit and discuss every single piece of evidence. You are absolutely right,
They're not. You're right.
in that. But I think it's a little,
I thought it was
you
a
know?
bit fast, but I'm just a nobody. But before we
Right.
get back into it, I have to say I'm texting on the side because my niece just moved into her dorm today.
Aw.
And I'm talking about my nephew and his unknowledge of true crime. I just want to say I was not dissing you.
No.
Just because your dad is a cop in Texas, you should be a little bit more educated in the
Oh
legal
my.
system.
They're underhanded. It's
Just saying.
Well, in fairness, I'm gonna say this, in fairness, one, if that's not his profession, then he's just a
It's
civilian.
not his profession.
2, many
And this is
people
not in Texas.
well, also, many people are not educated in the legal justice system until they're in it.
You're just
Uh, I mean, that's just a fact. Like, you don't
you're
know
not.
what you don't know until you are in it, and then you
And that's a
actually
good
see it unfold, because a lot of people get their knowledge from TV and movies, which is
right.
nothing remotely close to how court actually works. So I do give people lots of credit there, that you can't always know what you don't know. Because I mean, I remember, having going in with like rose-colored glasses, and then you watch enough trials that you're like, oh, wait, this isn't actually how the system works. And whether you're a casual viewer or you end up, unfortunately, finding yourself in a legal case of any kind, it does not have to be a murder criminal case. It can be divorce, custody, housing,
Civil.
they're a civil, they're all a nightmare. And I think we're all led to believe that the system is perfect, right? But unfortunately and sadly, it is far from, which is why I
It's
believe
imperfect.
transparency is very important for us to
Right. But
come
it's
to our own
imperfect
decisions.
because humans are imperfect. And that's the thing I wish people would understand.
Right. But I do appreciate, when we all watch trials together, many of us have very differing opinions. For example, my opinion on Murdaugh is a very unpopular opinion, and that's okay. But, I did watch the trial and form my own opinion about that. And I think that that's what makes streaming trials publicly, the transparency is very, very important. Because I will say one of the first, not the first trials I watched many years ago, but on YouTube and being part of that world was the Wisconsin versus Kyle Rittenhouse trial. And I'm going to tell you right now, straight face, that if you read about that trial in the media and you did not watch it yourself, they told you the wrong story. That's a fact.
They
That is
did.
not up for debate. That is absolutely true. I watched every single day, every single minute. It was a fantastic trial to watch, to learn
But
about legal self-defense, textbook legal self-defense. But that's just why I'm a nerd and I like watching trials for funsies. So
and I agree with Buffy. Not basically a lawyer, but I think people like you who watches a lot of trials, I'm going to say, give an educated opinion to those of us that are not attorneys, not in the legal system. And I'm going to just say to my nephew, I love you, but your dad is in law enforcement. Law is not to protect criminals. The law is to make sure everyone is treated fairly.
the truth is that everybody is innocent until proven guilty, no matter how much
And that
you think that that person is guilty or not. I've watched trials where I know damn well, all right, that that person is probably who did it. But then I watch the state, the government, all right, come in with absolutely no case at all.
Right.
And I don't know about you, but I do not like the government having that kind of power. I want to
No.
uphold the government to the strictest and highest of
Right.
standards to dictate a civilian's life and innocent until proven guilty. And
Right.
that is a very American thing. I have many friends in
Mhm.
other countries that this is not how the criminal system works there.
It's not.
It's I understand. I've been very frustrated with cases in the past. For sure. I do get that frustration. But there are many people, innocent people, every day stuck in the system because it is imperfect.
Right.
There are many people
And
all over the place. There are zealous prosecutor's office. There are zealous police departments.
there
Corruption is
is.
rampant. It is, quite frankly, it's not up for debate. I'm not saying
No,
it's everywhere, but it is everywhere
no,
also at the same time.
but
Um,
I
but you should
I
always
mean,
hold the government first and foremost to the highest standard, always.
I'm like, it's personal, for me, but the system is imperfect, just like humans.
Mhm.
Okay. The system is there and we really hope it works. But guess what? Sometimes guilty people go free. And guess what,
That's true.
guys? Innocent people are found guilty. And it's because of the people testifying, the attorneys, and
And money.
everything we learn, and money by
Money's the
watching
biggest
trials.
factor. If you are a poor
Yeah,
person, period, in
you're
this
screwed.
country, you are screwed, whether
You're
you
screwed.
did it or not. That is without a doubt a fact.
Yeah.
And that
Because,
is not fair. That is not a fair system. When
yeah,
the government has all
it
the
is not.
money and can throw all of the money and resources to get whatever they want
Hmm.
to convict you of, that's a very real problem.
Yeah. And
So
Lob and I disagree on whether Murdaugh is guilty.
that is true. We
I
do.
think he is guilty. I don't think he had the balls to pull the trigger. I don't think he had the stamina to track down two people and kill them.
It's also not
As
the
a
state's
person
case,
who
though.
shoots gun, rides ATVs, I couldn't have done it. I don't even think maybe my brother could, who's in law enforcement. I do think he's guilty, set it up, knows who did it, was there,
Exactly.
association, all of that. But I don't think he did it. But he is still guilty as shit.
That's also not the state's case.
And it's not the state's case,
That is
but
true. Police corruption and malpractice happens everywhere, but not every cop or prosecutor is bad. That I
No, they're
absolutely, you're
not.
correct. I am not saying that. That's for sure. But
No, there's
unfortunately,
good cops. There's good prosecutors.
there's good, bad people
But
in
we
every
have to
profession.
remember,
But they hold a
in
lot of
this
power.
case, we know that the SLED detective lied to the grand jury. That to me is a bad cop. It does. All of the cops within SLED are bad, but SLED did some bad stuff.
You ain't never seen a rich person on death row for a reason. Anyway,
Is that because the
I don't
attorneys
think
tell
it did
them
either.
to plead out? I
No,
don't
because they
think he
work a
pulled the
deal with the
trigger.
state because they got money. That's
Plea
why.
deal.
I mean, it's about the
I mean,
only.
I don't think he pulled the trigger, but that's me. Oh, Buffy's
But that's
back.
not the
I don't
state's
think he pulled the
case.
trigger,
But that's not the
but I
state's
do think
case.
he's guilty.
So
I
therefore,
know.
your
It's
vote would
not
be
the
not
case's
guilty.
case.
So
The
that's just how
case,
that.
like we learned with speaking with Judge Blevins in the Casey Anthony case, you need to give multiple charges. Casey Anthony got off because the prosecutor was like, yes, we could get
Charged him
first
too
degree.
high.
That's all we're charging.
But not every state can you do that. You can't always do multiple
Buffy's
charges.
flipping her
So
hair. Buffy got some
she's like ready. She's like, girl,
come on, Buff.
this is wild.
I'm good.
Back on track. Back on track.
Focus.
That's true, Carmen. He is
Let's
a
get
piece
back
of
to it.
shit. I'll give you that.
He is a piece
We're
of
almost
shit.
done, guys.
And does he need to be in prison? Abso-fucking-lutely. He needs to be in prison.
Again, he's not
I
getting
agree.
out of prison
Buffy's
anytime soon.
hair needs its her own channel.
Agreed. What'd you do?
Oh,
Go curl it some more?
no, I didn't. It's flat.
But what I do
You've
find
been streaming
interesting
for almost
about
7 hours.
This whole discussion, why are we talking about the affordability of Charleston for a case? And you had an attorney for the defense on the witness stand.
Isn't weird. It's weird. Focus. The mods. Focus. That's for us. Please keep your comments to the case we are discussing on stream. Thank
Bells,
you.
did we
Thanks,
ask
mod.
you for your input?
Right, half-ass. That's right. Let's be honest. The parking is the most difficult part of a first-degree murder case. What are we going to do?
And
This
the
is
cost
a
of the
while.
hotel for witnesses.
If you have a problem with criminals getting away, then you can thank the government for that because that is their job. Your problem is not with defense attorneys. Your problem is with the state and the government and holding people accountable and having the appropriate evidence of it and plea deals. I mean, don't get me wrong. I have some opinions very similar. However, people getting away, that's the government. All right. That's
It's the
nobody
government.
else. Nobody else.
Agreed.
So there is that.
wow.
But anyway, let's go. We're almost done with this.
I love Poot. We're going into Poot with his hands up like this, and I kind of love
She's
it.
serious. He's about to get big hands going on. Big hands. Here you go.
So
I
that
like
makes
the
it
debate.
more
Doing that.
economical for us and allows us to have the money to hire a DNA laboratory in Texas. And we're going to have to hire other experts from outside the state. And we want to put our money into that, not
Where's the money coming from?
having to stay somewhere else or even paying for witnesses to have to come somewhere else. Now, our memo talks about, all kinds of things and the factors. But Your Honor, first of all, I would say to you, if he gets up here and argues we need to go back to Colleton County, then he is, and I don't know why he would do that. I have no idea why he wants to go back.
Oh, I don't think he said that.
Maybe it's his lucky courthouse.
What?
But it's not rational
his lucky courthouse.
compared to what his Sixth Amendment rights are.
I'm sorry. I don't think the
Okay.
state
To answer any
suggested that at
questions you have.
all.
Thank you.
Okay.
I don't think so
Here
either.
come in, Mr. Waters.
Your Honor, I want to start out by saying And the state was in a leadership position prior to the first trial in putting together logistics, doing things like asking for a gag order in order to try to do exactly what the state wants, and that is to put 12 in the box who honestly can be fair and impartial to both sides. That's been our entire goal the entire time. This is as I wrote in my motion, this is the world we live in, and the genie is out of the bottle. And I'm not going to sit here and not say that this case has been unique, almost nationwide in the amount of publicity that has been generated. And so that is going to be something that's going to be overcome. But the law is very clear that the remedy for that is, of course, an effective voir dire process. And we put together a good procedure last time. It was very efficient. It worked, even though the frenzy was out there then too. I want to be clear that I'm here to be reasonable because as I said before, I want to pick a jury that win, lose, or draw will stick, and that we have fair to both sides. And I believe that we can do that. But the issue, of course, is not pretrial publicity. Long gone are the days where people got their news from the evening paper or the morning paper.
Yeah.
And it is ubiquitous out there. So we're going to have to rely on our citizens and identify those citizens who can put whatever they may have heard aside and honor their oath to be fair and impartial. I also want to be reasonable here when I say that I'm happy to consider any other option, but I also am a steward of the taxpayer money. And the statute also requires the least logistical expense. I also, as I said before, we didn't let court break down for 6 weeks, and it was a logistical, huge effort that I give credit to a lot of these staff members back here and keeping one witness coming up after another to get this thing going. And so I'm thinking about those things, and I have been in court. I love Charleston. Charleston is one of my favorite places in the world. I have been to court down there many a time, and it is always a logistical difficulty. And to contend it's not the most expensive city in the state, I don't know what to say to that. So I have to at least not be, when the defense says Charleston or nothing, I have to at least say, Your Honor, there's problems with that. And we believe that there are other choices in the state that would be better, of which I am happy to talk about and consider those other choices. That's been the state's position. In the end, Your Honor, all I want is a fair jury to the state and to the defense, and have us be able to present our case to citizens who are going to abide by their oath and be fair and impartial to both sides. And that's the process that we're looking to have happen.
Okay, thank you. Anything else from the state?
Lainey didn't watch the first trial. Yes.
I mean, defense. I'm sorry.
He said happy, but not happy and
Thank
willing.
you. Are brilliant.
He has so much to say, but probably not. Well, that's the first
All right.
stick.
I understand.
Call him
It sounds
Poot.
to me like y'all are just agreeing to disagree. Y'all just want, each one of y'all want a different place to hold it. But let me tell you, I read your motions, and I took them seriously and went through and did some work on them. And I'm going to tell you, after reviewing the motion submitted by both sides, I even went back and looked at the transcript of the jury selection that was conducted back in January of 2023, and also the opinion from our Supreme Court. I'm going to order that venue be transferred to a county outside of the 14th Judicial Circuit, because I believe that the defendant cannot receive a fair and impartial trial
Agreed.
in Colleton County. I'm making this ruling in pursuant to the South Carolina Code 172180, and it's supported by case law. That would be State v. Law, where the circuit court retains the power to transfer venue outside of the circuit where a fair and impartial trial cannot be had. So I'm transferring it not only from Colleton County, but out of Colleton County completely. I find that the defendant has satisfied his burden under State v. Manning, where he's demonstrated actual juror prejudice. And unlike the ordinary pretrial publicity case, the evidence before this court is based on the actual results of the voir dire conducted in this case in the January 2023 trial. Fewer than 1 in 7 prospective jurors were qualified to serve, demonstrating an extraordinary degree of community exposure and prejudice. Second, under Reamer versus U.S., the interference with the jury process by an officer of this court is deemed presumptively prejudicial and cannot be measured by any voir dire. Ultimately, the decision to change venue lies within the sound discretion of the trial court, providing that a showing of actual juror prejudice is made. This ruling rests on 4 grounds. First, the exceptional rate of juror disqualification during the January 23 jury selection. Second, the community prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. You know, that can be cured.
I agree.
But with the 4 grounds that I've just stated, I am transferring it. Further, this ruling is supported by the court's recent order in Beach v. Parker that I just read yesterday that Judge Kelly, I was interested in his order. I did go read it. There, the court found that the moving party made an affirmative showing that a fair and impartial trial could not be had in Hampton County due to the extraordinary pretrial publicity and the surrounding litigation. The court concluded, other than publicity, the settlement of the wrongful death action, the criminal prosecution of Mr. Murdaugh, the defendant in this case, including his reversal by the clerk of court. The same publicity and public attention that justified transfer in Beach is present here and further supports this court's determination of a change of venue is necessary to protect the defendant's constitutional rights. Further, I'm going to find that under Section 172185 is not an adequate alternative. That procedure would require Colleton County to bear the substantial cost of transporting, housing, feeding, and securing an out-of-county jury throughout a multi-week trial. More importantly, it would not remedy the prejudice identified by this court or eliminate the concerns arising from retrying this case in the same community where the constitutional violation
Is Greenville or Columbia in the 14th
I
Circuit?
find that there's no lesser remedy that will adequately protect the defendant's constitutional right to a fair and impartial jury.
I don't think
The
Greenville
court
is.
rules venue is transferred outside of the 14th Circuit. I'm going to reserve my ruling to the specific county in which this matter will be transferred.
She cares about
You know,
parking
let
and
me tell
sandwiches,
y'all,
guys.
It takes a village to get this case transferred. For those of you who don't know, there's a lot of other things
true.
besides walking into a courthouse and sitting down and trying to try a case. You know, we have to consider security, transportation.
Parking and
Is
sandwiches.
the courthouse adequate?
And Llama and Buffy needing good
Is there
volume.
lighting? There's also docket considerations that have already been set for next year. There's a bunch of matters to consider.
Oh.
So what I'm going to do is I will think about it. I need to look at it. I will tell you, Mr. Waters, you are correct. Cost is a concern because Colleton County does bear the cost of the retrial in this case.
It does, but the state can give them
County
money.
is not a rich county.
Let's be for real.
It's a poor county.
Charge Becky.
So that will be at the foremost of my thoughts.
It's her book
when
money.
I transfer this
Her
case.
book money,
I
exactly.
was in hopes that the two of y'all could agree on a destination, but since that's not happening,
Really?
I will decide and I will let y'all know.
Okay.
I will issue an order. I will do a formal order on my transfer of venue and also will designate the county into
Thank
which
you,
we are
Ange.
going to try this case.
Oh, she's
Okay?
going to pick a place.
Any objections?
None from the state, Your Honor.
Perfect.
Thank you, Your Honor.
You're welcome. All right. Now, the last motion, Mr. McCullough, I know you've been sitting here since 10 o'clock.
He's been waiting patiently.
If you could come up and just for the record.
Well, why didn't this guy go
state
first? Who's
your
this guy?
position. I believe I've got.
Who's this man?
Mr. Waters, I believe I have your stance on this, but I'll get you to put it on the record and let me rule.
Some
please.
bright Oompa Loompa hair.
Go ahead.
I am sorry. That was rude.
He does look like an Oompa Loompa.
It's like Marvin Zindler hair.
Who is this guy? I don't know who this is.
She's going to tell us. I don't know
Is
either,
he?
but why didn't he go first?
Right? Oh, he's the egg lady lawyer, the juror's lawyer. Okay.
Oh, the egg.
All right.
Okay.
Why? Why is he here?
Oh, Lady Grace says he's a televangelist.
I don't think he really is, but he looks like one.
Okay, Buffy.
He does look
is
like
this
he
going to
could
be
asking for
spicy?
money.
Is this going to be
I don't-
spicy?
I don't know if I remember. It's
Okay.
been a couple. We've been streaming for like 7 hours. I
I'm
don't
like,
know if I
that
remember what
hair
happened before 1
It's
o'clock.
giving me vibes.
I mean, as soon as Barbara takes the stand, it's like a fever dream. I feel like I know I've
Yeah,
been
but that
drinking, but it
hair-
feels like a fever dream. It's
I
good
do
hair.
remember what
Taken
he's going to talk
seriously.
about. I don't know if it's going to be spicy, but it'll be interesting.
All right. All right. Angie says
Those
you'll hear
Marvin
why.
Zindler
Okay.
hair.
All right. I don't know why he's here, but okay.
Your Honor, the benches
Give
are
it to
hard
me.
and life is short, but I wouldn't have missed the Charleston travel log for anything.
I wish I would have. Go ahead.
Your Honor, I don't want to detail I'm here representing Myra Crosby, a former
Egg jury lady.
deposed jury in the criminal trial, which you're obviously familiar with. And given your nature of preparation, I know you've read my initial filings. If you have any qualms about how this matter comes before you, I will streamline that by simply saying that following the plea of Ms. Hill in December of 2025, during that proceeding, Solicitor Hubbard, who was placed in charge of the investigation for jury tampering, indicated the case was closed, no charges would be filed.
Okay.
From that point, shortly, several months after that, in March and then again in May, we filed freedom of information requests for the jury tampering investigations, which were closed and therefore no longer susceptible to any exception under the Freedom of Information Act. And we sent that to SLED, the Attorney General's office, and to Mr. Hubbard's office, Solicitor Hubbard's office.
Okay.
In response to that motion, I think it is correct, and I don't want to preempt, but Mr. Waters is here. General Counsel for SLED is here, and I spoke to Solicitor Hubbard outside to just confirm their positions are not in opposition to the remedial attention to the protective order, but they do say that they all three, as agencies, are constrained by protective order, which includes at least, if not is, the protective order of Justice Toll from January of 2024, issued preceding her new trial motion hearing. At that time, she issued a protective order, which I think the primary concern was to protect the identity of the jurors in the case that may have been to some extent interviewed in whatever jury tampering investigation led up to that point, January 24. And of course, that investigation continued after that hearing, after January 24. So we're simply asking, and there was no other way to get here, Your Honor. We originally filed a motion to intervene, to have a court review the protective order to determine that those issues were now moot. And at least the issues that Justice Toll addressed, or the reason, as I read her protective order, for constraining any release of investigative materials relative to jury tampering. Now, there's been a little confusion.
I'm confused.
The in-camera proceedings, I am not seeking the release of, because I have that, but I am constrained by the order of Judge Newman. I was allowed to have them, but I can't disseminate them. I'm good with that, and I don't think those aren't the issue today. So I wanted to eliminate that confusion. I'm here today simply asking, Your Honor, pursuant to the Freedom of Information, and you know, the purpose of the FOI is to simply make it possible for citizens and their representatives to learn and review the activities of their government. And secondarily,
is Egg Lady suing Becky?
Ms. Crosby asked me to pursue this because she wants to see the quality of the investigation. She wants to evaluate it. She believes the public should be able to evaluate it. She is hopeful that it will lead to additional information in support of her belief that she was targeted through an orchestrated effort to remove her from the jury. So
sounds like
for all those reasons, Your Honor, I believe that it's appropriate for me to be before you as the assigned judge for all things Murdaugh, and to ask you to review that protective order and any others that could be referenced that I'm not aware of. And to conclude,
You're not asking for any jurors' names or any
I'm
kind
not,
of
Your Honor,
identity.
but that's the worst secret on the planet. I think that
it's true.
Half of the jury
Is that a
jurors
wig?
went to New York and appeared on the Today Show.
I don't know. I think he really does have great hair.
No, he has just an amazing head of hair.
Sure does.
Like,
And he
that is
flaunts
great
it.
hair.
So this makes a lot more sense, because I was like, why are they bringing this in front of this judge? But that makes sense because she is now
Makes
the new
sense now.
presiding judge. She has to give authority, especially, listen, releasing anything that has anything to do with the jury is a very big deal. They do not like doing it. But it sounds, I don't think there's a lawsuit yet regarding egg juror at the Hill, but it kind of sounds like she might be trying to start a civil lawsuit, which is why she wants this information. But I don't know why she needs it in order to start one, but okay. This is very weird, but it's not very often you see these things anyway, so.
Understand all that,
But
but you understand
not
as a
opposed to the
court,
redactions.
you know, we protect our jurors. Now, whether they want to get out and go dance on ABC and tell them everybody who they are, that's
That's
fine.
right.
Your Honor,
But I'm not comfortable in unsealing any identifying factors for a juror or a juror's name.
not asking for that, Your Honor. And
Okay, just wanted to make sure.
I respect the position of the Attorney General's office, which actually filed the only responsive pleading. So I respect that. My only concern is simply this. When you begin redactions, I do not want to have to be back here or through the Freedom of Information and a lawsuit complaining about Epstein proportionate redaction.
Oh.
Protecting
Okay.
the identity
Epstein.
is one thing, but I don't want to get
Epstein.
pages and pages of blacked out, redacted.
I understand.
So that's our position.
Okay, Mr. Waters?
Thank you, Your Honor. First of all, as we detail in our response, there were multiple protective orders during the course of this. And
Right.
Of course, the first thing we have to talk about is what you just recognized, is that the court promised those jurors over and over again, both Judge Newman and Justice Toll, we're not going to release your identity. And we deal with this all the time. Just because I might be subject to state grand jury secrecy doesn't mean somebody who's subpoenaed can't go run their mouth about it. And I still can't run my mouth about it, right? Except as necessary in court. So, And so the other thing is that we also wanted to protect, of course, ongoing investigations, which have resolved at this point. And so that's why we have filed a motion.
You did, Sam.
However, our motion to unseal also includes the sealed portion of the initial inquiry that got that juror kicked off the jury. Okay. And that's important that that come out. In fact, I find it interesting how Mr. McCullough says he wants the public to judge what happened, but he doesn't want them to see what was the basis for the exclusion in the first place. And so there is, that needs to be unsealed at this point now. There's no reason to do that. Of course, redacting identities. And that, of course, is the only limitation that we have, is that those juror identities be redacted. The main difficulty in that is there are some MOIs. Those are easily redacted, and other personal identifying information that are normally redacted to protect people's privacy. The MOIs are going to be easy to do that, memorandums of interview, but they are summary documents only. And there are, of course, body cams of interviews and that sort of thing. And so that's going to be a little bit more difficult. It's going to take some time to do, but subject only to that, to honor the court and frankly the state's promise that we won't be the ones to release your identities. We believe that not only should the sealed inquiry at trial be released, but also within the appropriate bounds of FOIA and subject to redaction, the investigative file as well.
So there's like, yeah, that's fine. We just have to redact some stuff.
With regard to the in-camera proceedings, we're not asking for that to be unsealed.
Yeah, you said you had it.
Fascinating that the Attorney General's office is. I don't know how you're going to redact the identity of the person that everybody in the universe knows was the object of the in-camera proceedings and the only person who was removed from the jury. But I certainly will respect your ruling.
I mean, you just said her name.
Someone else decided to run their mouth and go to the media, then that's on them and ain't on us. I will also point out, Your Honor, that Mr. McCullough on June 24th,
that's with all court.
June of 2024 requested unsealing of the in-camera proceedings, and then filed on September 4th, 2024, a petition to intervene with the Supreme Court to seek it unsealed. So on multiple occasions, he has requested to have it unsealed. So,
and I achieved my goal, which was to have access.
Look, I like for everybody to know everything. So
Me too, girl.
This is the deal. We're going to unseal it.
Let's unseal it, girl.
We're going to protect the jurors' names. I want that redacted. I want any identifying
okay. Are you frozen, Terry?
Information concerning a juror redacted.
She is.
Is she frozen?
Unseal the rest of it.
Thank you. That's exactly what the state wants. Thank you, Judge.
Thank you. All right. Now, with all that done, let's talk about when we shall meet again.
Okay.
Already?
Let me pull up my calendar.
Yes.
Oh, wait, I already
I'm
added
telling
this.
you, I'm keeping us on schedule. We're going to get this
I lost
done.
Terry.
My 2 dates for my next hearing. And let me just tell the lawyers this. I did have a motion to exclude evidence.
Does that mean we can FOIA everything?
The state's motion to admit
South Carolina.
Evidence of motive, and that's going to involve the
Terry, we have stuff for you to do.
I think a
Add it to the
ruling at
list.
this time would be way too premature. I want to be closer to trial. That will I probably will not even consider those motions until the beginning of next year when we start doing.
Those are going to be some
pre-trials.
long hearings, y'all.
However, Mr. Harpoon,
Multiple
in your
days.
motion to dismiss, I was told I would be getting a supporting memorandum, which I do not have. I pushed that out because the state hasn't been able to respond to it because they haven't been afforded the opportunity. They don't have it.
Oh.
I will push that out to the next pretrial hearing. I do not want the DNA, Mr. Griffin, to wait that long because I'm thinking either November the 13th or November the 20th. That would be here in Lexington, again at 10 o'clock. That way I can address any other matters that might come up. Any of those, do those dates work for y'all? I know it's close to Thanksgiving, but I was
All the days work
trying
for
to
me,
get
Your
it in,
Honor.
so
Thank
I
you.
won't bother you over Christmas because I'm gonna start bothering y'all again in January.
The 13th would be far preferable to us because, so I'd have all my staff available and everything for that.
Okay.
That's a long
How about
time.
you, Mr. Harpoolian?
What was the first date, Your Honor?
The 13th, November.
3 months. Wow.
Okay, let me look. Wrong month.
Oh, girl, you're going to need more than one day.
That's a Friday.
Okay.
The 13th. Yep.
I don't know.
Friday.
Oh, gosh, is it really Friday? Well, I didn't mean to do that.
That's perfect, actually.
The way things gone, that's our lucky day. That'll be fine.
Okay. Oh, that's
Okay.
too funny. I'm sorry. I did not realize that was Friday the 13th,
Okay.
but I'm not superstitious. I hope you're not. All right, November the 13th, 10 a.m. is going to be our next pretrial. We will take up your motion to dismiss. Please have your memorandum filed timely. Let me say timely, because I was working the weekend. I get 18 motions at 5:15 on the 7th. That was fine. Then I've
Welcome
been
back, Terry.
getting motions all week long. And that's fine too. I understand y'all are busy and you have stuff to do, and but please try to be timely. So I'm going to tell you before you say that, Mr. Harpoolian.
Okay.
Let me see. Deadline, the Friday before, 11/7. It's gonna end on a 7. All motions that you would like for me to hear that day, please have them filed.
One day is not enough,
Your
girl.
Honor, may I make an inquiry?
You may.
The problem this week for, I think, us and the Attorney General is we filed a bunch of stuff, motions last Friday.
And we got
And
responses.
we had to do responses. So if perhaps you would
Set it up?
maybe move back a week
Sure.
for the motions and then give us a week to respond. And then if you want to file some sort of reply, do it at your own risk.
All right, how about October the 30th?
Halloween.
Which is a Friday.
She really wants to stay on
It's the
theme.
day before
Yeah,
Halloween.
Halloween and Friday the 13th at this point.
Well, why not?
Why not?
Just to have your motions in, then y'all can respond the following week. And I'm putting my deadline for the 7th.
Okay.
Yes, response deadline will be the 7th.
So 30th, 1st.
File your motions,
30th.
response by the 7th. So I'll have time. I mean, believe it or not, y'all, I really do sit down and read every motion that y'all file.
I do believe that she does.
Shorten them a little bit.
Always. The shorter, the better. But I do. read
Shorter the
all of
better.
them.
I think
Hey,
the
girl.
6th is actually Friday.
That no
It's
woman has ever
11/6.
said.
11/6.
Ah! Dick joke, not dick poo
All
either.
right. Anything else from the state?
Not this time, Your Honor.
Anything else from the defense?
No, Your Honor.
All right, Mr. Griffin, you're gonna let me know. Now, let me ask y'all about this. When he does let me know about the DNA, because I want to be on this. It's gonna be long before November.
She wants to
Is
be
it possible for us to have a quick hearing so we can decide what to do with the DNA?
Sure.
Yes, Your Honor.
Yeah,
Absolutely.
right.
Again, once we get that, I'm happy. to
It's
work
hard
with
for
them.
me to set a date until I hear from Mr. Griffin, but maybe we could set a date, and once he calls me, and I'll email y'all a few dates, and maybe we can have a quick hearing one Friday afternoon or something.
Quick hearing.
Your
Ah,
Honor,
stop.
we need to
I have so many
transfer
comments
the
going through my
material
head.
from Sled Lab to Othram. That's chain of custody, we're out of it, but nothing can happen until that transfer takes place.
Well, and I'm gonna talk with him about that, but thought that he represented to the court that they were gonna agree and not challenge chain and accreditation issues and that sort of thing.
We're not.
And then secondly, we'll work on that.
Are y'all gonna try, and let me, it's turnaround's fair play, are you gonna challenge any chain of custody on him?
Not if we agree to the procedure and my scientists are okay with it. and there would be unless, shenanigans happen.
Shenanigans. It's a
I
second.
did say shenanigans.
Mentions of shenanigans.
But I would also add that, just to be clear, it's still the same deal that I offered, that they're gonna process in quant and then stop, and then we'll find
Stop.
out.
That's exactly right. You understand that, Mr. Griffin?
Absolutely, and we're coming back to the court.
I'm gonna put it all in one place.
Okay.
Let you process it, then you're gonna contact the court. You're stopping. You're not doing any test
Correct.
until we know. And we're gonna have a hearing on it, a quick hearing. It won't take long. You can tell us, is there gonna
So
be
you
enough
think.
reserve for the state?
Ma'am.
Correct. I just want to be clear, we're talking about the unprocessed material.
Unprocessed and the leftover is going.
Oh.
It's going, but can we go ahead and test the leftover?
We're okay with that, Your Honor. They can run the leftovers. It's unprocessed.
Then why do we talk about it for 40 minutes?
Who's on first? Who's on first?
I'll talk to the
Pete?
lab, I'll talk to Dr.
Right?
Middleman.
Is it?
So I'll find out, but, we want to get this thing
Do we
going.
have-
Okay, well, I'm just telling you.
Didn't we
before
do like
you
an
do
hour
any test
conversation about this?
whatsoever, we're gonna have a hearing.
Okay, we won't do any tests.
Oh, we're gonna
Just
apply.
go ahead, get it quantitative.
And I guess one last thing I would ask is that by doing this procedure, they're waiving any claim under the Preservation of Evidence Act, at least as to these items.
Well, I mean, we have to, because if it's destroyed during it, I don't find that to be a willful. I read the Preservation Act, and I
Been
don't
over
think us doing this is in anything intentionally on either side to destroy any evidence, which
Sherry said that 3
you know,
hours
you're
ago.
obligated to uphold. I don't see that. So the court doesn't find that to be a problem. I mean, if it gets destroyed, y'all understand it's destroyed. Okay. All right. Thank y'all.
Thank you.
Thank
Your Honor.
you.
Court's adjourned.
Thank you, Your Honor.
Girl. If she thinks that one day is going to be good enough for a hearing 3 months from now with these guys, you are crazy, ma'am. Doesn't matter how good you are at wrangling cats.
I can't wait to see how many motions are filed between now and then.
So many.
I know. I'm
So
like,
many. Oh,
what the hell?
it's exhausting. Exhausting, but
So
magnificent.
are we just talking about the leftovers? I'm
The
Are we talking about all
leftovers
of
or the
it?
unprocessed? I like the
Or just the
organic
leftovers?
kind, or what are we doing? Oh my God, what a fucking shit show. What was the
Let me just
after
say-
recess?
She must eat leftovers a lot.
But it's about the leftovers. I hope there's so many memes. I'm gonna make one tonight for us to send around. What about the leftovers? Because yikes, wow. That was quite a hearing. It was close to actually it was longer than that. I'm sorry. It was a 4 hour and 37-minute long hearing. Though the first hour was literally nothing at all. Because
And
they
we only did
said
7
court was going to start at
hours.
9, and it didn't start till 10. Courthouse said 9. I know I had it on the schedule right. Trying to gaslight us. Yeah, and so a 3.5 hour turned into 7 hours for us, which tracks.
It's all Buffy's fault.
I mean, it's all Creighton and Poot's fault. My God, those guys just. I love to see it though. I'm not complaining. Would absolutely love to sit here for 7 hours a day talking about these two because they do not disappoint.
Next time,
Oh.
y'all go it alone.
No way. Next time we're
Buffy.
gonna watch in real time. I got news for you.
No, next time we got to do real time.
All right. Oh man. Well,
I
think
tried.
you did try, and I was like, well, I don't know. No, I thought that was a very interesting hearing overall, especially for those that like did not watch the first trial. You kind of got to see each of the lawyers have their moment, or to see them at work, including Barbara, which I thought is I think that's very interesting always to see. They are they're like, I feel like the defense in the state are like a married odd couple, if you will. Like they love each other and they can't survive without one another, but they bicker like a married couple. They do all the time. You'll see it. Today was a very good preview of what you can expect for a 6-week trial with these lawyers. So if you were entertained, they are certainly going to be very entertaining during trial when they are quote unquote on.
Oh, Buffy's taking off her earrings.
Oh, she about to fight somebody. She's ready. She's like, let me do my
They're
Buffy
like,
ruling
damn,
now.
girl, what are you doing?
So I'm about to get naked. No, I'm just kidding.
I will say that I thought a lot of the judges' rulings were very fair to both sides.
I agree.
And I really do appreciate that a lot, because sometimes you don't see that. But you could tell she had already made up her mind, but she was willing to hear both sides, which could have changed her opinion. And there was one in particular where they took a break, not the recess break, a different time, that I think she might have been like, I need you to go back and like reword this a little bit.
Right. She needed to reconfirm her decision because they gave good arguments.
Yeah.
I agree.
So, I mean, oh my gosh, there were so many motions they went over. She is agreeing to change the venue where she's going to decide. Since they didn't want to be all decisive, and no offense to your honor, but this is like planning a trip with your significant other, right?
Okay.
They do none of the planning. And then you're like, all right, well, fine. I guess fuck it. I'm just going to plan the whole fucking thing then. I asked you to do
But
one
why
thing.
didn't she just say, pick up the phone and call each other like we did back in the old days?
I think she should just put a big map up of South Carolina and throw a dart.
Might as well. Might as well. But no, her ruling of moving it out of Colton County and the 14th district is a very good thing to do. And so I think that was the right call. I mean, Becky really changed a lot of stuff, period. And I think that moving it further is a good idea. What else did they rule on? I thought her DNA ruling was good as well. I feel like her rulings were really trying to compromise with both sides.
I agree.
So that is very, very nice. Because that is how compromises work, right? Both sides don't come out as full winners. That's the art of a good compromise. And I thought she did a very good job with that. Like I said, Judge Newman, the previous judge, I thought he was a great judge as well. And I think she is good for it too. But why she let Barbara on the stand and that whole whatever that was, I don't know why that was allowed to happen. I would have been like,
That
what?
was
No.
insane.
That's weird. Put your own lawyer under oath for Charleston and why it should be there is weird. But as we said before this hearing even started today, both sides very theatrical, very theatrical. And it really showed today. What were some of the morning rulings before the recess they took? Oh my God, there were so many. I don't recall. But either way, she has scheduled the next hearing to be Friday, November 13th. She is very much miscalculating who is before her, unless she plans on just ruling without hearing arguments, but that doesn't really seem her style. That is bet it's going to extend to the next week for sure. I wouldn't be surprised if we get an added on day.
That's the holiday season.
Exactly.
She's definitely going to do an add-on date for the DNA already, she said. I guarantee there'll probably be more than DNA brought up that day. Or they'll argue for a really long time about DNA. But there were 3 motions she said she wasn't ruling on
we still have 3.
Yeah. And the last hearing was 6 weeks ago. We're talking 3 months. The next one. And you saw the 2 sides going at it the entire day, which I understand people have their opinions about lawyers, but for both sides to just be on and with it and ready to argue and have fairly good arguments on each side for each case is very impressive. And it really does show the level that I feel, my own opinion, that both sides are with lawyering, because that takes a lot to be with it, to be ready to go, just like that. It takes a lot of skill. So most people don't know that if you've never watched a trial, but it's impressive when you see it. You remember Alex? Was that his name? No, Andy. His name was Andy.
Andy
From the Canaro trial. You remember that?
from the Canaro.
Mm-hmm. Mm-hmm.
I knew exactly who you were thinking
Yeah.
of.
Yeah. But anyway, don't say the P word, Angie.
Was great. No
You're
P
gonna
word.
get fired. No P word.
As to say, Andy's
Oh, she
fired.
hasn't
I
been
will start
fired
the
today.
paperwork this weekend. I will start the paperwork
For what?
for firing Angie.
Oh, I thought you were talking about the FOIA. I don't know why you were gone and whatever happened to your internet. We had
no,
something
my
about you writing
Mac
it down.
I am locked. I can't use mouse, finger touch. This is what I got. Everything is frozen besides this.
Oh no. Yikes.
It says we've been
yeah,
on
I
too
assigned
long
you
is
a
what I'm
job.
thinking.
I gave
Well-
Terry a job to submit a FOIA for everything in the Murdaugh trial since they're
That's
unsealing
right.
it.
Oh, I can do that.
The jury stuff. I don't know what it is specifically. You'll have to
I don't
go
know what's in
I
there.
know.
Now I'm just nosy since we had to have a big old
I
conversation.
can just do a bunch of general ones.
Yes, that's true.
Can we get the sidebars? I want the sidebars.
No, I think those are protected.
I feel like weren't the majority of the sidebars were done arguing, like they just took the jury out in Murdaugh, didn't they? I don't think they had very many
Oh, maybe they did.
bench sidebars. They like argued it in court a lot of the time.
That was so many years
don't
ago.
remember.
I
I
barely
know.
remember how
I'm
that
like,
went.
how do you remember that, Llama? That was like a lifetime ago.
I know. So many trials since then, for sure.
Well, I was in Disney World, like between like going on rides, trying to listen to Murdaugh testimony. Like
You would be at Disney
I was like,
World.
he's taking the stand. I'm trying to go ride dwarves.
Disney World is a great place to be, Llama.
I guess I would never go. It is not on my list of
Yeah,
places.
you're
to
right,
ever
Bella.
Go to. Good.
Belle, I'm not paying, or we are not paying thousands of dollars to get the sidebar convo.
I know.
Not
I
that
feel like a
important.
lot of them were sorted out right there in the courtroom. Many of them, more than normal,
If I'm going
which
to pay
I
for
enjoy.
sidebar, it's going to be Karen Reed.
Well, those already came
want
out.
to know what Hottie says.
Oh.
No, but new ones going forward.
Oh, like in the civil cases?
Yes.
I don't know. They haven't really done any yet, but that's a good
Yeah.
point there. I don't
Can't
know.
wait for the civil
And this
case.
judge could be different. She may make them do sidebars at the bench. I don't know if there's any rules about it specifically, but like I've seen both happen. I prefer when they just argue in front of everybody because I feel like it's a learning experience. And again, transparency. I'm a big fan
And
of
because we're
that.
nosy.
And because we're nosy. First and foremost, it's because we be nosy bitches. I want to know all of the things. And then when I don't know, I tell Terry to go find it for me.
Or
Terry, go
Angie.
file it.
Angie can find everything and anything.
That's right. That's why we're all besties. And besties with a bunch of nosy bitches. Well, friends, that's what we got for you tonight. It is way later than we intended to be. And we are probably way more buzzed than we intended to be.
I was going to say, Llama said 3 to 4 hours. I think we're looking at 7 hours.
Hey, building your stamina,
it's-
babe. How are you
the
going to survive?
timer says 7 hours, 16 minutes.
We are training for the Murdaugh trial, ma'am. Okay? This is your training, like a marathon, you're training. Because it's going to be this, like every day. And it with 3 additional. So,
We will
but
order
Monday,
vodka for everybody.
vodka for everybody.
Llama, Buffy, and myself.
Now, Monday, Terry and I will be back to talk more Murdaugh as we're going to be covering Murdaugh on Mondays here on the True Crime and Wine Time Show. What we're going to be covering, Don't know yet. I got to put that together this weekend. But we will be again talking more. Maybe we'll talk more about, oh God, I forgot they brought up the whole gun thing, the extra guns. We're going to look into that.
Guns.
Boy, she squirreled. I was like, oh,
She
guys, what did we
squirreled
forget?
real
Like,
quick.
real hard.
Well, part of my brain has been working on like, what did we watch earlier today? And then finally it like shoved it to the front of my brain and it was like guns. Remember that weird thing?
We're going to have
that
to
Jim
research
said?
Fitz News.
That's true. That's true. All right. Well, let's go ahead and wrap up. Who wants to say things before I sign us out for the sake of all of us? Before we keep
Buffy, what you
jabbering on.
got?
I never have anything to say.
Yeah.
We're gonna
She's like,
work
I'm
on
just,
that.
Yay!
I'm just here. Just here to
What?
herd
She,
and catch.
she's the pretty
Y'all been
of our bunch.
It's true.
She always looks beautiful on camera.
Always.
No,
I know.
I mean, she always looks good. I mean, guys, let's
Aw.
stay safe.
Keep going.
And let's just say,
No, I'm just
don't
Keep going. I'm
believe.
so humble. Keep going.
Just keep going. I'm gonna just say, don't believe everything you hear.
tell me more about me. No, just kidding.
You're fabulous. You're beautiful.
That's true. That's true.
Okay, Lainey's going to watch Jaws. Who else is watching Jaws tonight?
I'm not watching Jaws tonight. What am I watching tonight?
I'll watch the back of my eyelids.
I am watching House of Dragons, episode
Nice.
4.
We're gonna find somebody else's stream to crash for the rest of the night.
Probably. I'm
Okay,
like, Buffy, who want to go on
Llama's
next?
been
Let's go.
drinking. Do not let her join anyone else's stream. Okay?
That's what I always
That is your
do.
job. But that is her job. Buffy, don't let it out.
You're not my mom.
No, Buffy
I would
is.
never be able to stop her from doing anything.
That's true. That's true. All right, everyone. Thank you so much for being with us today. It was a lot of fun, very insightful. I'm so excited that we're going to be covering this retrial because the first one was really a learning experience. It's very interesting. All opinions are appreciated here, even if we disagree. As long as we can be respectful to one another, we'd love to hear opposing sides. Because that's how the jury decides things, right? 12 of your peers who they're going to sit there and have talks and arguments about as well. So do we. But anyway, I hope you all have an amazing weekend. I'm going to do my best. It sounds like I got a busy weekend.
You're going
And
to have a
we will be
busy
next time.
weekend.
I do. Yeah, I do. All right, friends. Until next time, go forth and be amazing. Okay? All right. Bye, guys.